Yes.
Number
17. Other side?
Other side is statement.
When it is called on, Mr. Shinada? No. Not in the absence. Oh, acha. We will inform the other side. 17th, not today. Not. You are the petitioner. We will not this week. Please inform the other side whenever possible. Yes, what else?
Blood, there is an application, my lord. I mentioned the day before yesterday. Urgency is this, blood. We were challenged in the writ petition determining the status, caste status.
Yes.
Now, during the pendence of the matter, they have passed orders, my lord.
Hand
And
over the slip? Yes. Please hand
let
over.
it be taken up on Friday, my lord,
Whenever the file
application day.
Yes.
Item number,
I'm late.
item number 76, my lord, that is, my lord, the admission in the medical. My lord,
What do you want? Tell me.
my lord, kindly, my lord, update,
I
my
passed
lord.
an order. No. You are not there.
Kindly see the, my lord, I have stated, my lord, the ground, my lord, why, my lord,
What was the order passed?
the order, my lord, goes down, my lord. My lord, the counseling is.
সোমবার দিয়ে দিত সুদীপ্ত এটা যেটা বলছেন উনি মানডে ইট উইল অ্যাপিয়ার অন মানডে আপগ্রেডেড ম্যাটার সোমবার আপগ্রেডেড থাকবে ইয়েস
Your Lordship, I am permitted to mention.
Monday is the regular mention day. Please come back on Monday. These matters can be
My lord, it's an upgradation.
Come on
Your
Monday.
Lordship. My lord,
Floated, my lord, I will not be able to participate as long as the petition is pending.
ও আচ্ছা আচ্ছা very good.
my lord, kindly.
কালকে তুমি মেনশনটা থাকবে নন প্রসিকিউশন ইয়েস
Lordship, may kindly grant me leave to mention the matter. Lordship, I'm just praying for a direction on WBSADCL to provide firm power connection to the petitioners.
you are
Lordship-
mentioning for inclusion or is it appearing in the list
It's
what
in the list, Your Lordship. It's appearing as 692 in the combined list. I'm praying for
write
an
on a slip
upgradation.
of paper give it to my learned officer and ইয়ে সুদীপ্ত এটা কালকে আপগ্রেডেড থাকবে ইয়েস
My lord,
you
it's for upgradation, Your Lordship. So tender,
what is the urgency
Your Lordship, a tender was filed for a go down to be taken, but then after inspection, without any reason, they have not
what
taken.
is the item number
Item in the monthly list, item number is, Your Lordship.
hand over কালকে আপগ্রেডেড থাকবে
My lord, may I mention?
Grateful, Your
My
Lordship.
lord, my client is in custody since 1 year, my lord. My lord, the trial has not.
item number
Yeah, item number, my lord, 272 of monthly list.
কাল আপগ্রেডে দিয়ে দিও এটা সুদীপ্ত
Grateful, my lord.
give a slip
Your Lordship, I had mentioned yesterday one unlisted matter. Your Lordship had directed to me to file the.
your file
Yes, Your Lordship.
hand
Your
over
Lordship-
এটা আপগ্রেডে দিয়ে দাও
Your
hand over a
Lordship
slip
kindly fixes a date because they are already coming to my house.
no it will appear under the upgraded heading I cannot do more than that
Lordship
sorry.
kindly fixes any
No,
date,
no,
any
no.
date within this week.
yes next you have
পূজা পারমিশন
আপনি দিয়ে দিচ্ছি।
what is this upgradation or
আপগ্রেডেশন
দিয়ে দাও এটা আপগ্রেডে দিয়ে দাও call that
ডিপি লর্ডশিপ
thank you
Appellate sir, getting this item number 1 for judgment. Kanchi,
I've given certain observations again. I did in the light of the above observations, WPA 20731 of 2023 is disposed of by directing Respondent 1 to ensure that the prayer of the present petitioners for premature release is considered afresh in the light of the above observations within November 30, 2023. Immediately thereafter, necessary consequential steps shall be taken by the respondent authorities pursuant thereto. Whatever may be the outcome, the same shall be intimated not only to the petitioners but to each of the convicts whose cases have been considered in the SSRB meeting within a week thereafter. Such procedure should be followed not as a one-time measure, but on each such occasion for all prisoners. No order is to cause urgent certificate. I have given certain modalities in the previous paragraphs. Please go through the order on the website.
Grateful, Your Lord.
Thank you. Yeah, upload করার জন্য পাঠিয়ে দিতে।
You mention item number 2, Joy Balaji.
What is the
But
correct?
our instance, my lord, this is that bank where we have paid up the full amount by consent. I've indicated in pencil a small word to be added, a small phrase with the consent of the other side. Otherwise, I can't avail of financial facility.
Very
So this can be by
I'll do that.
Very well.
Thank you. Learned Senior Counsel appearing for the petitioners points out that an inadvertent error crept into the order dated September 26, 2023, inasmuch as the declaration date of the declaration of the petitioners as willful defaulter was not mentioned. Full stop. Accordingly, in the 5th paragraph of the order dated September 26, 2023, comma, the expression within double inverted, the willful defaulter declaration of the petitioners shall be suffixed by the following expression, colon, within double inverted, dated October 26, 2015 is revoked. Double inverted close, full stop. Let this order be deemed to be a part of the order dated September 26, 2023.
Item number 3,
Yes.
At my instance.
Yes.
Lord, I am the respondent in the writ petition. Your lordship
Right.
was pleased to direct, my lord, on an application filed by my learned friend, my lord, to file, my lord, our opposition on 10th. But
Right.
I'll be, my lord, only praying for extension of 7 days to file my opposition, my lord.
You are enjoying an interim order.
No, my lord, I was praying for an interim order. That is my difficulty. I have to.
But
then
that is the
go-
That cannot
electricity
be done
matter,
on
my
that.
lord.
No, my lord, I am not saying anything. That difficulty is that I'm express. Only thing, my lord, I believe the matter was supposed to appear
On
on.
13th. on
Let
thir-
me try without affidavit, my lord, whether I can convince this court or not. Because in
But
the
he
main
tried to
writ peti-
convince your lordship
Right.
was pleased to direct, my lord, evidence, my lord, it
in the
was, my
main
lord,
writ petition, my lord, there is
late
already
payment
an
surcharge
affidavit.
matter.
My lord, there is already, my lord, I have
Yes,
to.
Mr. Mukherjee will take it beyond the trial. I'll give you till 16th.
16 Deepak Parve.
16th. Let it come up at least in the list before the vacation.
Yes, my lord, but can it be on 17th instead of 16th?
The matter,
Mr. Agarwal is, my lord, he is unwell. That's the difficulty.
then it has to go after the vacation. Mr. Chair.
He is,
You don't become
he's
unwell
not
after
coming to
hearing.
court.
My lord, I said, but that's why I requested, man. I'm not insisting on the affidavit. My lord, it is supposed to appear on 13th. If I can convince, I'll take 5 minutes. If I cannot, my lord,
The
kindly
13th,
act.
today we are on 11th.
Yes,
so
my lord, 13th, without affidavits. Man, I was only praying.
13th he cannot get do the affirm the affidavit in
No, it
opposition.
cannot be. My lord, I'm saying, my lord, may I try to convince it without the, I'll rely on the affidavit filed in the main writ petition.
That
That
stage
he
is
has
over.
already tried after
stage is
hearing
over.
your lordship was pleased to pass this order.
That stage is over.
That was the
on the-
delayed payment
on the
surcharge point.
Prayer of
I have
Learned
to
Senior
go on
Council,
paying.
on the prayer of Learned Senior Council appearing for the DVC, comma, the time for filing affidavit in opposition by the DVC is extended till October 16, 2023, full stop. Next para, the matter be listed on October 18, 2023 under the heading upgraded matters, full stop. Reply, if any, shall be filed on the next returnable date.
My lord, I'm
Lord.
grateful.
তুই ওটা করে দে তুই। I'm grateful.
I'm grateful.
item number 4,
4 and 5, section 4 and 5, my lord.
What is the correction? Yes, you mentioned for correction.
No, no, my lord, it has come in at the instance of the department, my lord. I understand, my lord, certain, in the contempt rule in the second line, the, my lord, the affidavit of verification thereof dated
So let me check.
August 17, 23, it should be 9th of
Hmm.
9th of June.
আচ্ছা, আচ্ছা।
Well, petition affirmed on 9th of June, my lord. 2023,
That has to be corrected then.
it has to be corrected.
But you have to
And-
put in extra the fresh talabanas and all.
My lord, in the mean, my lord, I'll led by Mr. Lugnath
You have
Chatterjee, my lord.
put in the requisites in the meantime, but there is a mistake in the rule.
Yes,
So that has to be
Appeal
corrected
state
and
check
you have to put in
in the
fresh
meantime.
requisites probably.
in the meantime.
But the requisites have to be,
Yes,
you have to take that responsibility.
Well,
But they'll have to take
Lordship.
that responsibility, my lord.
Lordship, probably this may be corrected and nothing else is required. Contempt proceeding is stayed by the division bench.
Acha. No, even then we have to do our
Correct,
duties.
correct. Because then Talabana need not to be submitted by them afresh.
Why do you
Since it
say
is-
that?
Lordship,
The rule was directed to be issued at the wrong, with the wrong date.
yes, Lordship. So now it will be corrected today. It will be corrected in
So
today.
you have already deposited your,
No, no, my lord, they'll have to deposit. টাকাটা
your contempt application. But the rule, why should they deposit?
No, no, I'm on the appeal, my lord.
No, no, appeal. You have already gotten an order of stay. Then I'll only make the correction.
That's what I was.
It is pointed out by an office report dated October 9, 2023, that in the rule issued
Any order?
on September 29, 2023, comma, the date of affidavit of verification was erroneously typed as August 17, 2023 instead of June 9, 2023, full stop. Let the rule stand corrected accordingly. Full stop. The expression double inverted August 17, 2023 in the second and third lines of the said rule be read as June 9, 2023.
My lord, in the appeal, just that, my lord, they'll have to deposit it within a fortnight. That was the requirement. My lord, so therefore, in
I'm
failure
not,
of.
this is only appearing for correction. Whenever is the returnable date, let it come up.
That's in the November, Lordship, sir.
Grateful.
Yes.
Yes, so in
By
any
then
case,
the appeal is probably, the appeal
no,
will
that
be heard.
covers the fortnight period.
Acha.
Yes, so,
Still he is hopeful that I will fail.
my lord, my lord, reputation seats, my lord, for this organization.
No, no, no.
Don't defame the organization.
Grateful, my lord.
Item number 6.
6, yes. What is the correction?
The alleged contemner numbers 1 and 3.
My lord, on the last,
What is the correction?
my lord, correction is this, that
Miss Das, please take the microphone.
my lord, correction is that on the first, in the first line, only the reverse. Learned counsel appearing for the alleged contemners, no, I am for the petitioner, my lord.
Oh, you handed over.
And only the first, second, third, and fourth, everywhere the petitioner will be alleged contemners and alleged contemners will be
It will be the reverse.
just a reverse, my lord. Only thing, my lord, I have a I seek a for indulgence of your lordship, my lord. Kindly keep it pending till holding of the, keep the contempt application pending till holding of the election, my lord.
Holding of
Election, in the election to be held on January 24.
I need not pass any further order.
No, my lord.
Content was
In
disposed
fact,
of.
you
Why
disposed
should I
of.
recall
Only
that?
thing, my lord, I am.
No, I cannot recall that order.
My
That
lord-
counsel for the petitioner
My lord-
points out that in the order dated October 6, 2023, comma, in place, the places where double inverted learned counsel appearing for the alleged contemners double inverted clause were mentioned, comma, should be read as learned counsel for the petitioners and vice versa. Full stop. Let such error be deemed to stand corrected accordingly by reading the counsel appearing for the alleged contemners as counsel for the petitioners and counsel for the petitioners as counsel for alleged contemners respectively. Full stop. Next para.
All in all paragraphs, petitioners will be contemners. My lord.
Right.
Grateful, my lord.
Next.
Item number 7.
7, my lord, I am for the petitioner.
Was it appearing for
Lordship
you
had
mentioned?
taken up this matter yesterday, and since there was no dispute as regards the claim, Lordship directed the state respondents to take instruction whether there is any dispute in the claim.
Oh, yes, Mrs.
Well,
Saunders, yes.
But I have taken instruction. The bills raised by them are inflated in nature, and a certain amount has been disbursed. 8
That-
lakh was the amount, and after deducting the GST, 7 lakhs odd has been disbursed to them. No due, as per the office plot, no due is there. My lord. My lord, may I suggest one thing, my lord? As far if your lordship so pleases, my lord, direct the authority to hold a hearing whether there is any dispute regarding the bill or not. But I have this, may I hand over the instruction to your lordship, my lord, that the
Mr. Maiti, should I dispose of the writ petition by directing them to give you a hearing to clarify the issues?
But I do not know what
Or
are the
I may
issues.
direct the affidavits to be filed in this also, but ultimately would that help? I mean,
That will prolong the process.
that will prolong the process because ultimately it could not
Let-
be able to decide that.
Let them at least give a hearing so that I
Give
can.
a copy of this to them.
I will.
During the course of the day, I'll direct the dispose of the writ petition. I'll
have
record
a
your
look at
stand in my order.
Page 2, my lord. Page 2, column number 11, my lord.
Act order করবো। A written instruction is handed over by learned counsel for the state, which indicates that, comma, as per the respondents, comma, the total payable amount to the petitioner was rupees 8, 31, 216, out of which, comma, after deduction of GST, comma, cess, ACSS, and income tax, comma, total rupees 7,97,967 was paid to the petitioner vide the office bank advice number 883 stroke capital G stroke capital E small n full stop dated December 28, 2022, comma, a copy of which is also enclosed with the written instruction. Full stop, next para. However, comma, learned counsel for the respondent submits that if the petitioner is not satisfied with such instructions, comma, the respondents are willing to give a further hearing to the petitioner for the purpose of ascertaining whether there are any further dues by the respondents to the petitioner. Full stop, next para. In
Lordship,
view
if
of such,
If your lordship sees column 12, they say that no allotment has been made, therefore no payment released.
No, thereafter allotment is being made.
as soon as allotment was received, payment was made immediately. You have not read the entire thing.
Was
The
this
next
is-
para. In view of such fair submission, comma, since in any event it would be inappropriate for the writ court to assess evidence for the purpose of ascertaining the actual dues by the respondents to the petitioner, comma, WPA 2237 of 2023 is disposed of by directing the respondents to give a further notice of hearing to the petitioner within a week from date, comma, for the purpose of the petitioner ventilating his grievance, comma, if any, comma, regarding further dues by the respondents to the petitioner. Full stop. In the event the petitioner can substantiate such further claims by virtue of necessary documents and other materials, comma, the respondents shall take immediate steps to disburse the same. Full stop. It is expected that such exercise shall be concluded within 3 weeks from date. Full stop. It is further clarified that since no affidavits have been directed, comma, it is deemed that none of the allegations made by either of the parties against each other are admitted. Full stop. No rest to cause.
But instead of 7 days, can it be 10 or more?
Do it before the puja. If it is more, then you will be in difficulty. It will go into the puja, you won't be able to do it.
Well, extremely sorry. Yesterday I was not with the instructions. Instructions were not there.
Why should you be sorry for that?
No, no, it should have been.
The court is lucky that that you could get instructions within a day from the authorities. Yes, next one.
Item number 8.
Please
I
can-
do not know how it has come for release.
For release, yes.
Also, it's a little embarrassing situation.
No, no.
Not at all embarrassing. Yes, why should this is the police help matter? What is
Police
it?
help matter. That's why I have prayed for.
And
No,
Justice
but
Bharadwaj
even-
also.
Objection, no
Yes,
consent,
that
nothing.
is the embarrassing part. Malchi, what has happened?
No, why embarrassing? Yes.
No, Malchi, the thing is that my client has actually.
Please
sought-
use the microphone. Your
My-
client?
My client has sought for a no objection from a learned senior. Now, now my lordship.
Because it has come up before this court.
No, 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 no. It is
Thank God. Yes.
so my lordship now he's here.
Then they would have informed me that.
No, this is regarding this. I mean,
So vegetable heart was running here. Earlier, your lordship was fixed with the matter for hearing. Your lordship was not there. I tried before Justice Bharadwaj. He said that it will be before your lordship.
yes, it is not a police help matter.
Malchi, what has what
License is there, my lord.
Yes, what do you say?
actually what is happening is basically
No,
that
I'll say I have jurisdiction because of the relief sort.
yes, if Malchi wants
And
to,
let it direct.
Yes,
Yes.
Malchi, we have a very simple and straightforward prayer. My client has licenses to run a heart. In spite of that,
At this stage, my lord, very embarrassing for me. My lord, they have taken, they are appearing.
You are appearing for whom?
the petition,
Oh,
Without any consent, without any change, nothing.
Malchi, what has
no, it has been taken from Mr. Mustafa and given to you.
Yes.
No objection.
yes,
Not taking.
they,
Nothing.
Anyway,
My-
Your
the matter was apparently mentioned under the impression that this court does not have determination.
Yes,
Full
Manoj.
stop. However, comma, it transpires from the relief sought. Why do you say there is no determination?
Malchi, because I have problems, Malchi, against the police authorities. What the respondent police authorities
Your
are
reliefs
doing,
do not say so.
Malchi, may I point out, Malchi?
Then, my lord, I am really, I am leaving, my lord.
আচ্ছা ঠিক আছে তাহলে you solve it between yourselves
Yes, my lordship, then
at
kindly.
the এইসব কেটে দাও যেটা বললাম at the juncture when the matter is called on for hearing comma
Client কে বলছি,
it transpires that there is an embarrassment on the part of the bar comma since the petitioner has engaged new counsel apparently without taking no objection certificate from the erstwhile counsel full stop. In order to enable learned counsel to resolve the issue between themselves, comma, the matter is adjourned till Monday. That is October 16, 2023.
Well, I tried their allegation.
When it will be listed under the same heading.
Not his fault. The client said that you were not doing nothing. It was appearing in the upgraded top, number 1. Unnecessarily blamed, you are doing nothing.
I'm not accepting.
Yes, yes, your lord.
Item number 9. Will I appeal for the question?
Yes. Great. Yes. Mr. Bhattacharya, you are free now. So you can conclude your hearing today.
I have done
I continue this till the puja vacation, then
I
release
have
them.
done an extensive research, though I'm not very satisfied with the research I have done, but I think I'll be able to, my lord,
Excellent.
advance my submissions.
Great. But your research should be in a nutshell. I mean,
Yes,
should be
I am a
presented
huge-
before the court in a nutshell.
I am a huge fan of my lord's wit and humor. So it will be restricted in a nutshell, my lord. Not a very hard nut, my lord. It
So
will be a-
I'm very elated upon hearing that, but your chances decrease
I-
after this in the matter.
my lord, my chances of, my lord, advancing my submissions.
No, winning.
Oh, I am the union, my lord. I'll just point out.
You
my
are the
lord,
union.
Yes, the provision of law.
Well,
That's it.
yes, Mr. Datta, finish your
My
argument.
lord, Mr. Dotto was attempting, my lord, just, my lord, before entering the courtroom, he asked his junior to hand up some list containing, my lord, some judgments which they will be relying upon. So I said that I have not been served. I'll take it in front of when the matter is called on.
Whatever. Yes.
But yesterday, my lord, I had placed
Mr. Datta, I'll take a very short written notes, your notes from you. I mean, a typed copy of that.
but it's not in my lord conquest paper.
No, 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 just
Yeah, okay.
Mr. Bhattacharya, you can also put it, I mean, not necessary. I can just take notes also. Yes, Mr. Datta, please.
Well, dear lordship, can you have a look to my lord the note that I
Yes, yes.
handed
Better,
up?
better.
Please take my lord the second page first.
Yes.
At the bottom, my lord, K. With this, I have already placed yesterday. K is placed.
Right, right, right. Sahara and all, yes.
Now, my lord, page number 1. Point A, my lord, I have placed the judgment yesterday.
Right.
The what is media trial?
Yes.
Yes. But I'll start from B today.
Thank you. Yes.
My lord, media trial, my lord, has been held to be antithesis to the rule of law and it leads to miscarriage of justice. My lord, this is reported in 1997 8 Supreme Court cases, page 386.
এই সুদীপ্ত বলছি শেষ হয়ে গেলে এটা না এই জাজমেন্ট গুলো একটু আলাদা করে এটা হয়তো আজকে একটা ফোল্ডার করে দিলে খুব ভালো। থ্যাংক ইউ। ইয়েস মিস্টার প্লিজ কন্টিনিউ।
My lord, this was a case, my lord, where a case of rape of a, my lord, 8-year-old minor girl. Now,
Yes.
initially, my lord, the accused were convicted and then my lord, the convictions were set aside by the higher court. Now, my lord, being aggrieved by, my lord, the setting aside of the conviction, my lord, various Nagorik forum and all that, my lord, they took out all sorts of, my lord, procession, and which was, my lord, finally, my lord, telecast, my lord, in the newspaper and the media. Now, but in this background, my lord, the Supreme Court was considering this. Please take only one paragraph, that is paragraph 37.
37, yes.
We agree with the High Court that a great harm has been caused to the girl by unnecessary publicity and taking out morsha by the public. Even the case had to be transferred to Kolhapur, from Kolhapur to Satara under orders of this court. There is a procedure established by law governing the conduct of trial of a person accused of an offense. A trial by press, electronic media, or public agitation is the very antithesis to of the rule of law. It can well lead to miscarriage of justice. A judge has to guard himself against any such pressure, and he is to be guided strictly by the rules of law. If he finds the person guilty of an offense, he is then to address himself to the question of sentence to be awarded to him in accordance with the provisions of law. While imposing the sentence of fine and directing payment of whole or certain portion of it to the person aggrieved, the court has also to go into the question of damage caused to the victim and even to her family. As a matter of fact, crime is not only against the victim, it is against the whole society as well. Since late, there has been spurt in crimes relating to sexual offenses. Therefore, my lord, the Supreme Court over here, my lord, in that context, that where mochas and all that are taken out, my lord, says that it leads to miscarriage of justice and it does more harm than good. Now, the next one is the media trial does more harm than good, is serial number C of my note,
Yes.
2006, SCC Online Kerala, page 666.
Yes.
But this again, my lord, was a case of death sentence, which, my lord, finally was reversed, and my lord, normally, my lord, there were agitations. Now, please take note only one paragraph, that is paragraph 40. It appears that, notwithstanding the fact that the full bench of the court more than 4 decades ago had deprecated reprehensible tendency of police officials going to the press, with details of cases, we unfortunately find that the tendency continues with increased vigor. Millard, pausing here for a moment, Millard, the newspaper cuttings and all that I have placed,
Yes.
in various places, your lordship would find that something had percolated through the media, through the investigating officers. Because we do not find any counter reporting in any of the newspaper by the investigating agency that we have not percolated this information, therefore don't go by these informations. We unfortunately find that a tendency continues with increased vigor. Officers of higher echelons of police force appearing in the print and electronic media, giving interviews and narrating stories unraveled through investigation are not infrequent signs these days. When superior police officers indulge in freely passing on such information to the public, they not only breach the conduct rules, but also put unnecessary pressure on the subordinate officers. Indulge in freely passing on such information to the public, they do not only breach the conduct rules, but also put unnecessary pressure on the subordinate who are in the de facto investigation of the case. It is well known that many of the materials collected by the police during investigation are comprised of hearsay or inadmissible stuff, and at times extracted from the alleged accused persons themselves by employing third-degree methods. Such material will not stand the scrutiny of a court of justice. The Fourth Estate also does not seem to realize the irreparable damage inflicted on the victims of crimes and the alleged culprits and those close to them through the sensationalized journalist adventures. Truth is very often suppressed, exaggerated, or distorted to add flavor and spice to the stories. Trial by the media can do more harm than good to the society at large. Instances are not rare when test identification parades are reduced to mere farce due to the injudicious publicity given to the alleged assailants by publishing their photographs. Every such act of adventurism exerts unnecessary pressure on the courts, which are to eventually try the alleged offenders. Where the next sentence is very important. The fickle-minded public, which has been conditioned to believe a particular version through a calculated process of media indoctrination, will be loath to accept a different conclusion.
It's a very well written judgment, actually.
Yes. But this happened last week.
Yes.
Hence, if the court which finally tries the alleged culprit were to ultimately record an order of acquittal for want of legal evidence before it, it may not be out of place for the public at large to conclude that the verdict of the court is wrong. They may even attribute motives in the presiding judge. No disciplined society which believes in the rule of law can afford such state of affairs to come to stay. We wish to express our strong displeasure at the increasing trend of investigation lapses and trial by media in respect of matters which are sub judice. After the case under investigation is in the season of the court, it is not open to the investigating agency or any other busybodies to give their own version about a crime and influence the mind of the public without realizing the worth or otherwise of what has been collected during the investigation and placed before the court concerned. Lapses in this regard will be viewed very seriously, and the erring police officials and the media persons will be proceeded against appropriately. Now, this part, the last sentence of para 40, may be one of the parameters which can be applied by the court in this case. Because I had told the court yesterday that I'll, in my very humble way, try to assist the court in framing, at least framing a sort of a guideline for future adherence by both the police as, the investigating agency as well as the media. Now, the next is as back of 1961, volume 3, Supreme Court reports 460.
Yes.
Para 14.
Yes.
But instead of reading it in its entirety, but there's a sentence in the middle of the paragraph starting with, no doubt it would be mischievous. We are the second last line of printed page 8.
Oh, yes.
No doubt it would be mischievous for a newspaper to systematically conduct an independent investigation into a crime for which a man has been arrested and to publish the results of that investigation. This is because trial by newspapers, when a trial by one of the regular tribunals of the country is going on, must be prevented. This is another parameter. The basis of this view is that such action on the part of newspaper tends to interfere with the course of justice, whether investigation tends to prejudice the accused or the prosecution. There is no rest, I don't want to trouble your lordship. Therefore, the Supreme Court, as far back as on 1961, felt the need that there has to be some restraint put, otherwise it leads to miscarriage of justice. We need to differentiate between a gag order and these kinds of orders which tries to put in place the position of the victim, accused, witness, justice delivery system and the investigation, or what are the norms or what are the safeguards which are also to be maintained during the investigation stage. Now, this takes care of D. Now, E is several judgments which say that the investigating agency should not percolate information regarding ongoing investigation. But the first one is of 2010, volume 1, Supreme Court cases, page 457.
Yes.
But this was a case where Milord, an air passenger, Milord, was caught with cash. Now, this information
Yes.
was Milord percolated by the IT officers to the public. Like the first Milord item of news, Milord, which I have placed before your lordship yesterday regarding Milord gold. Milord, please have a look at para 21. Or if I may first place Milord para 7. But the para 7 is not in my note. Please have a look at para 7.
Yes. 7.
The appellant lists the following 4 acts on the part of the income tax officials as objectionable and violation of his fundamental right. Please take Milord Roman 4.
Yes.
Prematurely and maliciously disclosing to the media a complete false picture of the incident. The said acts, according to him, tarnished his reputation amongst his friends, etc. Then, Milord, please come to Milord para 21. But the appellant's grievance in regard to media being informed about the incident even before the completion of investigation is justified. There is a growing tendency among investigating officers, either police or other departments, to inform the media even before completion of investigation that they have caught a criminal or an offender. Such crude attempts to claim credit for imaginary investigational breakthroughs should be curbed. Even where a suspect surrenders or a person required for questioning voluntarily appears, it is not uncommon for the investigating officer to represent to the media that the person was arrested with much effort after considerable investigation or a chase. Similarly, when someone voluntarily declares the money he is carrying, media is informed that that huge cash which was not declared was discovered by their vigilant investigations and thorough checking. Premature disclosures or leakage to the media in a pending investigation will not only jeopardize and impede further investigation, but many a time allow the real culprit to escape from law, be that as it may. But the next one is no guilt to be concluded by investigating officers. This is 2010 SCC Online Kerala 4750.
Thank you.
But this was a case of custodial death. Milord, the investigation was transferred to the CBI. Now, Milord, the CBI percolated information in regard to the pending investigation or the progress of the investigation before the media, which is Milord dealt with Milord in para 7. It is a passion for certain investigating officers to disseminate to the media piecemeal or full information regarding progress of investigation. All concerned should realize that once a case involving the commission of a cognizable offense has been registered and the FIR forwarded to the magistrate concerned, the matter is sub judice and no police officer has a right to leak out information regarding the outcome of the investigation until the final report is eventually filed before the court. Cases may attract either justifiable or uncalled for media publicity. There is a tendency among certain sections of the press to draw sustenance even from unconfirmed sources, including the police, in order to boost their garbled versions. When police officers freely indulge in passing on information to the media and to the public, they not only breach the conduct rules but also put unnecessary pressure on the courts, which are eventually try the cases. It is very well known that many of the materials collected by the police during
Probably a reproduction of the previous
one,
the same judge also.
Yes, and fickle-minded public, etc. Milord, it's the same reproduction. But I don't read further, Milord. Milord, to the same is Milord 2020 SCC Online Kerala 3213. With a lengthy judgment, my lord, please take my paragraph 264. No. I think I've
Probably wrong paragraph.
noted a wrong paragraph.
Right. There are 269. That is one of the
269 হবে না?
269 is at
No.
least refers to this.
No, 269 ও না। 269 ও না। না, এটা পাতার নাম্বার ইয়েটা মিলছে না।
Begins with, we have serious reservations about police officers conducting press meetings.
Yes. My lord has found that.
Page 269, yes.
Just give me a moment.
I was just skipping over the evidence portions actually.
কি নাম রে মামলাটা?
এটা একটু you can take my copy, Mr. Dotto, and just
No.
locating your paragraph number.
No, I
You have a Manopatra copy?
Yeah, নাম মামলাটা কল।
Before that, all the evidences are being discussed. Whenever you finish the evidences, you will find this paragraph. This is the
Yes.
first paragraph after that. That's how I find it.
Oh. 264 ই তো লেখা আছে আমার কাছে। 269 how does it start? We have serious reservations. Yes, well, it should be 274. I'm sorry, my lord. Not 264, 274.
Right.
Oh.
269 in my copy
Oh.
actually.
Acha,
270 is
So,
Kerala Police Act.
my lord, I have got the my lord SAC version, therefore 269 in my lord's
Yes.
copy. We have we have serious reservations about police officers conducting press meetings in respect of criminal investigation, which they and media consider to be sensational. In our view, on many occasions, holding press meetings would spoil the quality of evidence collected during the investigation. This is another ingredient which says that spoils the quality of evidence. In our considered opinion, no police officers conducting investigation into a crime shall be authorized to divulge the facts ascertained during investigation through media. They should remember that a criminal case has to be finally decided in a court of law. Police officers would refrain from airing their personal views in respect of a case under investigation. They are not expected to reveal before media the facts ascertained in course of investigation by questioning material witnesses or confession made by the accused. It is a common knowledge that recently the practice of police officers rushing to media with speculative information about ongoing investigation is on the increase.
Mr. Dotto, one differentiating factor in your case is here the media is reporting that they have learned from the police.
Yes.
There no press conference has been held as such. It cannot be. I mean, should not be also. Nothing of that sort.
Yes.
The police may come and deny that they may say that we have not disclosed.
Yes. But number one is, we have not found any denial.
That is there. That is there. No public statement.
Number two is, there are instances where, nowadays ED, they release press statements, but in the form of circulation, to the press. But
Yes, but nothing of that sort has been annexed here.
well,
probably.
yeah,
It has been. Please give me the page number also,
Yes.
because
that
that is more appropriate for these judgments.
Yes.
Otherwise, the press saying that I have learned from the police may not be correct. I mean.
If the matter is not finished today, but I can, give at least one press release to the court tomorrow.
No, don't add anything to the report. Yeah.
No, to only demonstrate that, kindly take it as my submission.
I can put in general findings. Yes.
But
All these are general findings, in fact.
Mr. Bhattacharya,
I'm only for the union, I'm not for the ED.
very well. I understand his constraints, Millard.
Yes.
But Millard, in matters where Millard we have challenged Millard the investigation or the ECIR, there Millard we have placed before the court that the progress of investigation is being circulated by ED by way of press releases.
Mr. Chatterjee, you were wanting to say something.
I wanted to say something, Lord, I got this today and it's a
big list, Lordship.
Give it back. You are not entitled to that. That's not a written notes of arguments. Give it back. Here, what he's saying, he's citing the judgments. Take note and argue. You are not entitled to anything of that sort. It's not a written note. It's only a compilation of the judgments he's citing. If you are aggrieved with that, return it.
I'm not aggrieved. I've taken the note of this.
This should not have been given to you at all. I mean, they are gracious enough to give it to
They've
you.
given us.
You are saying you have got it only today. You could not have got it under law.
No,
This is not a written notes of argument. It's a compilation of the judgment.
Yes. But in fact, yesterday, I said,
These are well settled propositions.
yes, yes.
this looks like Lordship, PM Bokshi constitution. After that, the list of judgments. After the-
Before exam or after exam?
After-
PM Bokshi constitution before your exams.
ও জানেন ওর বইটা তো বেঞ্চিতে রেখে নিয়ে নিয়েছিল।
Yes.
The next judgment is 2020 SCC online SC
Yes.
765.
কোথায় নাম লেখা?
এই আমি এসছি
কোথায় এসছে?
এর রোমান 4 এই আমাকে একটা কপি দিতে এটা আমার প্লিজ this is মনুপত্র copy para 21. What has further aggravated the situation is the fact that the statement on DVD recorded by the investigating agency were played and published in a program named Putta Mutta by Udaya TV, allowing the said DVD to go into the hands of a private TV channel so that it could be played and published in a program is nothing but dereliction of duty and direct interference with the administration of justice. All matters relating to the crime and whether a particular thing happens to be a conclusive piece of evidence must be dealt with by a court of law and not through a TV channel. If at all there was a voluntary statement, the matter would be dealt with by the court of law. The public platform is not a place for such debate or proof of what otherwise is in the exclusive domain and function of the court of law. Any such debate or discussion touching upon the matters which are in the domain of courts would amount to direct interference with the administration of criminal justice. But in fact, there are a line of decisions which say that case diary itself is a secret document at the stage of investigation. Why, my lord? The reason being that it is only for the perusal of the court for limited purposes. Say somebody applies for bail and anticipatory bail. Number one.
Right.
Number two, the records of the case diary is only available to the accused after the charge sheet is filed. And now, my lord, of course, very recently, my lord, the law has been expanded by saying that while giving the documents to the accused, the investigating agency should not only give the documents relied upon, but should also give the documents not relied upon but collected in course of investigation.
I didn't know that.
Yes, this is my lord, a very late, my lord, expansion of law. Otherwise, what happens is, previously, my lord, there is a 1987 Calcutta High Court judgment. Of course, we are not relating to criminal matters. It was in case of a disciplinary proceeding where, my lord, I'm sorry, in an excise matter, where, my lord, our High Court held that you cannot say that I have not relied upon this document, therefore I can't give it to you. I will only give it to you, give only those documents which I have relied. That is the authority. There, my lord, our High Court, my lord, to my research, for the first time held that non-relied documents should also be given because that may come in aid of the person against whom the charges or allegations are made.
Yes.
My lord, the next one is latest trend in holding press conferences. Where this is 2004 SCC Online Delhi, page 65. Sure.
Yes.
But I'll place a few paragraphs of this from 7 to 13.
Right.
This case is a nefarious example which manifestly demonstrates how the trial and justice by media can cause irreparable, irreversible, and incalculable harm to the reputation of a person and shunning of his family, relatives, and friends by the society. He is ostracized, humiliated, and convicted without trial. All this puts at grave risk due administration of justice. It is common knowledge that such trial and investigative journalism and publicity of premature, half-baked, or even presumptive facets of investigation, either by media itself or at the instance of investigating agency, has almost become a daily occurrence, whether by electronic media, radio, or press. They chase some wrongdoer, publish material about him, little realizing the peril. It may cause, realizing the peril it may cause, as it involves substantial risk to the fairness of the trial. Unfortunately, we are getting used to it. Latest trend of police or CBI or investigating agency encouraging publicity by holding press conference and accompanying journalists and television crew during investigation of a crime needs to be stopped, as it creates risk of prejudice to the accused. After hogging publicity and holding the person guilty in the eyes of public, police and CBI go into soporific, I don't know the meaning.
Soporific.
Slumber.
Sleepy, inducing sleep.
I
I
see.
learned somewhere.
Slumber and take years in filing the charge sheet, and thereafter several years are taken in the trial.
But soporific slumber is wrong.
I see.
If it's slumber, it's slumber.
Yes.
Either it's soporific or it's slumber. Both mean the same thing.
Or maybe a
Soporific is
a drowsy part of
drowsy is soporific.
Yes.
Then slumber is always soporific.
Yes.
So it
Yes.
cannot be both together. Anyway,
Anyway,
so we cannot discourage these things. We are only on media trial.
yes. Now that skipping over 10, please have a look to 11.
Yes.
There is nothing more incumbent upon the courts of justice than to preserve their proceedings from being misrepresented, than to prejudice the mind of the public against persons concerned before the cause is finally heard. The streams of justice have to be kept clear and pure. The parties have to proceed with safety, both to themselves and their character. Miller, again, skipping over 12, please. 12 is about fair trial. Please take 13. It is one of such cases where public servants who are no more, have met. I see this was made against my public servant side.
Yes.
Somewhat similar fate, being victim of trial by media. They have already been condemned and convicted in the eye of public. Recent instance of such a trial is of Daler Mehendi, whose discharge is being sought few days after his humiliation and pseudo trial through media, as they have not been able to find evidence sufficient even for filing the charge sheet. Does such trial amount to public service is a question to be introspected by the media itself. But in fact, Millard, digressing for a moment,
Yes.
in respect of all these scams, which are, Millard, said to be monstrous, humongous, but finally, Millard, the charge sheets which have so far been filed,
So many of the cases.
is, Millard, what should I say, abysmally low. I mean, the amount which could be attached to the persons concerned is abysmally low to what Millard was represented before the public so long. So, but so therefore, Millard, this trend of decisions, your Lordship will find, Millard, have three basic aspects. First aspect is, Millard, the prejudice to the witness, accused, etc., Millard, those who are connected with the crime. The second aspect is administration of justice, where it is recognized that it ultimately, Millard, affects administration of justice. And Millard, the third is, Millard, which is again connected with the administration of justice, is a right of fair trial. Now, this right of fair trial, Millard, it starts from, Millard, investigation itself. But it's not that the trial, pure and simple, is the trial.
I mean, apparently, Mr. Dotto, right to information, and this is the antithesis of right to information.
Right.
This may be misinformation also
Yes.
in certain cases.
Yes.
So, which is an
Yeah,
antithesis
I'm
to that
grateful,
right of
Millard,
the
for this observation. I did not think it in that fashion.
because it to the public also something is going which is not authentic as
Right.
of that date. Maybe misinformation is the
Right.
antithesis of right to
Right,
information.
Right to be informed will not include a right to be misinformed.
Rather, it includes the right not to be misinformed.
Not to be influenced. Yes.
Anyway, so
Yes. Now, my lord,
question is
this,
how far we can go,
yes,
how far the courts can go.
yes,
We are not the press council.
yes. But the press council,
That is what is to be considered. Definitely, we can go up to a certain extent. Definitely, and it has been gone by so many courts.
but to my knowledge, my lord, this registration of press and that
Their
pre-independent law, yes,
role is very
yes.
limited.
They have, my lord, very little
right.
role to play, my lord, on the contents.
Right. Like the censor board. Actually, we hype the censor board.
Yes.
Censor board does not have so many powers.
Yes.
Anyway, I mean,
Hmm.
they cannot curtail information.
Yes. But the next issue is, through these uncalled for or untimely media reports, my lord, the presumption of innocence, my lord, which is ingrained, my lord, in the criminal justice system, my lord, this get, my lord, affected. Well, this is my next point. F. First is, my lord, First is, my lord, 2010-6 SCC, page 1. But this is again, my lord, acquittal, acquittal reversed, and where the matter ultimately goes to the Supreme Court dismisses the appeal. Therefore, my lord, reversal of acquittal is, my lord, upheld by the Supreme Court. My lord, please take my paragraphs 301 and 302. Printed page 111.
Yes, got it.
Presumption of innocence of an accused is a legal presumption and not to be destroyed at the very threshold through the process of media trial, and that too when the investigation is pending. In that event, it will be opposed to the very basic rule of law and would impinge upon the protection granted to an accused under Article 21 of the Constitution. It is essential for the maintenance of dignity of the courts and is one of the cardinal principles of the rule of law in a free democratic country that the criticism or even the reporting particularly in sub judice matters must be subjected to the checks and balances so as not to interfere with the administration of justice. In the present case, various articles in the print media had appeared even during the pendency of the matter before the High Court, which again gave rise to unnecessary controversies and apparently had an effect of interfering with the administration of criminal justice. We would certainly caution all modes of media to extend their cooperation to ensure fair investigation, trial, defense of the accused, and non-interference with the administration of justice in matters sub judice. But the rest, my lord, I don't please.
And 303 clause 11 is also
Yes,
there.
yes, yes.
Same thing.
Yes.
Yes.
But the next one is the Onukul Pradhan, my lord, which has been referred in the paragraph that I placed. 966354. Para 7, my lord. This is a Hawala transaction case. This has been quoted. Kindly note down this paragraph.
Right.
Then, my lord, is K. Chandrasekhar, where, my lord, the Supreme Court has said that guilt cannot be determined at the stage of investigation. (98.5) Supreme Court cases, page 223. But this was a case, my lord, primarily, my lord, the Supreme Court was considering as to what is investigation, reinvestigation, further investigation, where Justice Manoj Mukherjee was pleased to lay down, my lord, the difference. Now, please take note paragraph 25. Incidentally, my lord, these observations have been made.
Yes.
It's a lengthy paragraph. কোথা থেকে শুরু? Yes, it starts from printed page 15, but I'll not trouble your lordship with in its entirety. But please take, my lord, printed page 19 or 241. 5 lines above para 26.
Yes.
If before taking a further investigation, an opinion has already been formed regarding the guilt of the accused, and that too at a stage when the commission of the offense itself is yet to be proved, it is obvious that the investigation cannot and will not be fair, and its outcome appears to be a foregone conclusion. Now, this principle, in my very respectful submission, would also apply over here because this is a case of further investigation. But still, Miller, the Supreme Court says that the investigation is on. So therefore, kindly do not come to any conclusion about the guilt of a person. Well, we are at a much earlier stage. Then, Miller, Shoival Kumar Gupta.
Shoival Gupta was cited by you
Yes,
in a different context. There are certain repetitions, maybe on different points.
Millard, please score out Millard Shoival Gupta from this.
Yes.
Then whose duty to prove guilt? It is the prosecution's duty. This is where 1957 SCR 657.
This is against the court's observations even.
Court's observation.
Yes. And these principles should be applicable to courts also.
Yes. But if it is considered to be a Article 21 right, then Millard, it has to be applied at all stages by all forum.
Yes.
Millard, in my note, it is only para 8. Please have a look to para 7 also.
Yes.
There is a passage in the judgment of the High Court which appears to us to be disconsolate and indicative of a wrong approach in deciding the guilt of an accused person. Although the learned judges recognize the principle that the onus was on the accused, yet one of the observations is such that it comes perilously near to putting the burden on the accused if it does not actually do so. The High Court has said the respondent himself did not have the courage to say that he did not find them at the spot. If he were innocent, he must have come out of his house immediately on hearing the noise and must have known who was present there and who was not. That is why, Millard, your lordship's prima facie observations, Millard, for grant of bail also, Millard, your lordships make it clear that this would not be relied or ultimately affect the trial.
Absolutely.
Para 8, this passage is so destructive of the cardinal principle of criminal jurisprudence as to the presumed innocence of an accused person till otherwise proved that it has become necessary to reiterate the rule stated by eminent authorities that it is the duty of the prosecution to prove the prisoner's guilt, subject to statutory exceptions. And Millard, the last one is Millard, presumption continues throughout the trial. এটা পড়লাম হচ্ছে এখন পড়বো হচ্ছে 1958 SCR 1226.
প্যারা 7 যেটা পড়লেন ওটা হচ্ছে নিসার আলী সাথে।
নিসার আলী। Only one sentence from para 6. Rather, two sentences. Now it is obvious that the primary object of criminal procedure is to ensure a fair trial of the accused. Even criminal trial begins with the presumption of innocence in favor of the accused, and the provisions of the code are so framed that a criminal trial should begin with and be throughout governed by this essential presumption. But a fair trial has naturally two objects in view. It must be fair to the accused as must also be fair to the prosecution. the test of fairness, etc. The rest, I don't. Then, serial number G.
R.K. Anand was cited by you.
Yes, but on a different context, but here, we are
Right.
on para 291.
Very well.
I have cited 293 on what is media trial.
Yes.
Yesterday, I had cited.
Yes, right. Just find it.
May I hand up another copy?
No, no, no. That-
The thick one.
Yes, got it. One of the thick ones. 291 this time.
291. But printed page 92.
Yes, got it.
It R.K. Anand. It was 2009 SCC 106. This is, however, not to say that the media, in the context of Article 19(1), this discussion. This is, however, not to say that the media is free to publish any kind of report concerning a sub judice matter, or to do a sting on some matter concerning a pending trial in any manner they please. The legal parameter within which a report or comment on a sub judice matter can be made is well defined, and any action in breach of the legal bounds would invite consequences. Compared to normal reporting, a sting operation is, I'm not on sting operation. But another judgment on this is, same point is 2005 to SCC 686. This was a article which came called "Doomed by Dowry." In that, in respect of that publication, para 10.
Yes.
Having gone through the records, we find one disturbing factor which we feel is necessary to comment upon in the interest of justice. The death of so-and-so took on so-and-so, and the complaint in this regard was registered and investigation was in progress. The application for grant of anticipatory bail was disposed by the High Court of Calcutta on 13/2/2004, and special petition pending before this court. Even then, an article has appeared in a magazine called Saga titled "Doomed by Dowry," written by one Kakoli Poddar based on her interview of the family of the deceased, giving version of the tragedy and extensively quoting the father of the deceased as to his version of the case. The facts narrated therein are all materials that may be used in the forthcoming trial in this case, and we have no hesitation that these types of articles appearing in the media would certainly interfere with the administration of justice. We deprecate this practice and caution the publisher, editor, and journalist who were responsible for the said article against indulging in such trial by media when the matter is sub judice, however, so and so. Then we had one judgment on that journalists, they don't have any extra privilege. This is a very old judgment, 1914, AIR 1914 Privy Council 116. But here, an article was published in a Rangoon newspaper, mockery of British justice. Obviously, the Britishers were quite annoyed. But please take para 34 টা এখানে কত আছে?
You have to give the page numbers.
At the top of the page, my lord will find the page numbers, page number 19.
19.
19.
Yes.
Their lordships regret to find that there appeared on the one side of this case the time-worn fallacy that some kind of privilege attaches to the profession of the press as distinguished from the members of the public. The freedom of the journalist is an ordinary part of the freedom of the subject, and to whatever length the subject in general may go, so also may the journalist, but apart from statute law, his privilege is in no other and no higher. The responsibilities which attach to his power in the dissemination of printed matter may, and in the case of conscientious journalism, do make him more careful, but the range of his assertions, his criticisms, or his comments is as wide as and no wider than that of any other subject. No privilege attaches to his position.
Please read out the next sentence.
Upon the other side, it would appear from certain observations of the learned judge that this false and dangerous doctrine may have been hinted at that some privilege or protection attaches to the public acts of the judge, which exempts him in regard to these from free and adverse comment. He is not above criticism.
The public acts of a judge, they have to be very careful. Should
Yes.
be.
Yes.
All of us.
Now, but this is at an era where, my lord, we did not have, my lord, our fundamental rights.
Constitution was not there.
Not there. 1935 Government of India Act also, my lord, does not
It was
contain
also
chapter.
not there. Right.
The previous one was, I think, 1917. 19. That also did not have.
Even Lordship Mohandas Karamchand Gandhi did not arrive in India.
Pardon?
In 1914, Gandhiji did not come to India.
Yes.
So before we learned everything about our rights.
After Gandhiji came to India, the rights were curtailed, or
And
why is it so special?
I-
Why Gandhiji? Why in this context? Media trial.
Press, freedom of press.
Press, freedom of press. Was it curtailed or opened up?
Expand-
Let your turn come, Mr. Chatterjee. No, this is not a threat. Yes. Yes, Mr.
But the next one is, my lord, 2022 SCC Online Kerala, 621,
Yes.
para 37. We have printed page 15.
Yes.
These words intend to convey the message that even the highest court in the country has no claim that it is infallible. This case has generated a lot of media attention. Mainstream television media and social media have commented upon the way this court went upon its business in handling this case. Observations made in court during the course of hearing have been dissected and made subject matter of intense discussion. Well, this should stop, my lord. Any observation of the court, my lord, hitting the headlines the next day, which has got no relevance, my lord.
The system in play. There's a difference between the
Observations.
comments made in his
Yes.
and the ones which we put in our judgments.
Yes.
And there's always an interaction between the bar and the bench. I mean,
Has to be.
we are part of each other. I mean, there's always an interaction. That everything cannot go in seriously. It's not a solemn affirmation of a what?
Yes. Right. He's one of the victims.
He's one of the culprits and one of the victims.
I am not a culprit. I consciously.
Mostly he's the culprit. Sometimes he's the victim also.
No,
Naturally,
I
balance of
consciously, I'm very camera shy, so I consciously.
very camera shy.
Yes, yes, very camera shy. I consciously avoid the media.
Avoid.
যদি ধরে গেলে আমি কি করলাম?
So deliberately he does. Probably he's right. As much as he can.
কি করব? আপনি আমাকে নয় গুলিয়ে ফেলছেন বোধহয়।
হ্যাঁ?
কাকে দেখলেন
To
গুলিয়ে
practice standing on a chair in your home.
But if it is credit worthy, my lord, I can take this credit.
Which one?
Then not to, my lord, go before the
You'd
press.
never. Not now, previously also,
I have
when there
never-
was much more scope.
Yes, yes. Well, at the younger days, my lord, where
I never saw you.
no, I've never got. I've never got.
Tell this to Mr. Basu also, Mr. Kollal was.
Yes, I'll tell him, but I wanted to inculcate this to Jayanto Narayan Chatterjee. I failed.
Jayantaran Chatterjee has become incorrigible now. Even he himself cannot avoid.
can definitely try out the other charity. Sabyasachi charity.
Mr. Chatterjee has practiced standing on the chair. I feel for the chair though. Yes, Mr.
Yes.
Dutta, yes.
My lord,
So court has criticized the press discussing the
yes.
whatever is going on in court and
Yes.
all.
But the last 4 lines, my lord, of the first paragraph,
Yes, yes.
subparagraph, the constitutional courts in this country have been zealous to protect the freedom of speech and expression, but this cannot be a license for the persons armed with half-baked facts, with little or no knowledge of how the judiciary functions and little or no knowledge of the fundamental legal principle that govern it, abuse the justice delivery system. Lord so-and-so said such.
I wonder what happened if any of these matters came up in contempt. And how would it be enforced? That is what is I'm thinking about all the
Yes.
time.
But
Behind
we-
the back of my mind, whenever I pass an injunction order or any order, Mr. Dutta, whether we can enforce that. We'll have to think about that.
Yes, but
Definitely we
to-
can.
to
There are
the
certain
extent,
modalities.
my lord, is provided under the contempt of court section.
Yes, yes, definitely.
I don't think
And
we.
215 is always there and
Yes.
anyway, yes. But we have to be very cautious. We cannot gag the press. I mean,
No. But that's why, my lord, at the outset, my lord, I said, my lord, my endeavor is not to gag, to guide.
no, definitely, yes. There has to be a balance in between.
Yes.
Because if the constitutional courts start choking the voices of the press and curtail freedom of speech, then
Yes.
I mean, what remains?
Yes, yes.
So we have to strike a balance between the two.
Right. So, but this is made on the
Yes.
rights of the journalist.
Hmm.
Then, my lord, the most important right is right to privacy, so far as I am concerned.
Thank you.
কোনটা দিলি? এটা হয়ে গেছে তো? হ্যাঁ, হয়ে গেছে, হয়ে গেছে। রাজাগোপাল দিয়েছিস?
Rajagopal, para 26. Yes.
Para 26. 94(6). But this is only these 3 judgments that I will not lay much emphasis on what is right to privacy, etc. But this is only to, my lord, indicate these next 3 judgment is my right to privacy includes protecting my family also.
Oh, that, yes. That is important because I am against you on that
Yes, yes.
for the time being. Yes.
Please take note paragraph 26.
Yes.
Rather, I should have started from 75. Anyway, my lord, I'll come back to 75.
75.
No, 75, the next judgment.
Yes, we can take that. I mean, if
Acha,
you
তাহলে
want.
তো 75
If
টা
it's
দিন।
a logical,
Yes, yes. Development of law, my lord.
right.
Hmm.
This is Krishna.
Hmm.
Yes.
Any right to privacy must encompass and protect the personal intimacies of the home, the family. No, para 24, I'm sorry, ma'am.
Yeah, 24. Yes.
Any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, motherhood, procreation, and child rearing. This catalog approach to the question is obviously not as instructive as it does not give analytical picture of the distinctive characteristics of the right of privacy. Perhaps the only suggestion that can be offered as unifying principle underlying the concept has been the assertion that a claimed right must be a fundamental right implicit in the concept of the ordered liberty. Then Millard, paragraph 29. The European Convention on Human Rights, which came into force on 3rd September 1953, represents a valiant attempt to tackle the new problem. Article 8 of the convention is worth citing. Everyone has a right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority with the exercise of this right, except such as is in accordance with law and is necessary in a democratic society in the interest of national security, public safety, or economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of rights and freedoms of others. So, but it is not only confined to my personal or exercise of my personal right of privacy. It can expand to family and others. But the next one, Millard, in the sequel is the one, Millard, I've handed up here, 94 6 SCC. 632. Please check note para 26.
Yes.
We may now summarize the broad principles flowing from the above discussion. 1, the right to privacy is implicit in the right to life and liberty guaranteed to the citizens of this country by Article 21. It is a right to be let alone. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical. If he does so, he would be violating the right to privacy of the person concerned and would be liable in an action for damages. Position may, however, be different if the person voluntarily trusts himself into controversy and voluntarily invites or raises a controversy. The rule aforesaid is subject to the exception that any publication concerning the aforesaid aspects becomes unobjectionable if such publication is based upon public records, including court records. These are the exceptions. This is for the reason that once a matter becomes a matter of public record, the right to privacy no longer subsists and it becomes a legitimate subject for comment by press and media, among others. We are, however, of the opinion that in the interest of decency, Article 19(2), an exception must be carved out to this rule, that is, a female who is the victim of a sexual assault, kidnap, abduction, or a like offense should not further be subjected to the indignity of her name and incident of being published in press media. This is an exception to the exception. There is yet another exception to the rule 1 above. Indeed, this is not an exception but an independent rule. In the case of public officials, it is obvious that right to privacy, or for that matter, the remedy of action for damages, is simply not available with respect to their acts and conduct relevant to the discharge of their official duty. This is even where the
Not necessary.
not necessary. The third exception is not necessary.
Yes.
Right? এটা তো বলে দিবেন, পড়ে দিচ্ছি। এটার মধ্যে দুটো এক্সেপশন, প্রথম এক্সেপশন আর পাবলিক রেকর্ডস এর একটা এক্সেপশন আছে। Then Millard 97(1) SCC.
Yes.
Now Millard, we have now come across the concept of Millard right to be let alone. Para 16. Now, the previous judgment is referred to in R. Rajagopal so and so, speaking for the court, observed that in the recent times, right to privacy has acquired a constitutional status. The learned judge referred to Kharak Singh's case, Govind's case, and considered large number of American and English cases, and finally came to the conclusion that the right to privacy is implicit in the right of life and liberty guaranteed to the citizens of this country by Article 21. This is a right to be let alone. A citizen has a right to safeguard the privacy of his own family, etc. But the last two judgments are, my lord, in answer to what Mr. Bhattacharya said yesterday, that I do not belong to, I mean, or other words, I'm not a citizen of this country as yet. Therefore, my lord, to what extent, my lord, I can enforce my right?
1421 not.
Yes.
Yes, anyway, you cited.
Yes, because these judgments, my lord, they recognize that this right to privacy, my lord, is a part of Article 21.
Yes, yes.
And, my lord, these two judgments only kindly have a look. My lord. The first one was Chandrima Das's case, my lord, that unfortunate rape that had happened, my lord, in Howrah station premises. 2000, Volume 2, Supreme Court cases, 465. Oh, sorry. Where paragraphs 28, 30, and 32. The fundamental rights are available to all the citizens of the country, but a few of them are also available to persons. While Article 14, which guarantees equality before law or equal protection of law within the territory of India, is applicable to person, which would also include the citizen of the country and non-citizens both. Article 15 speaks only of citizen, and it is specifically provided therein that there shall be no discrimination against citizen on grounds of so and so, so and so, so and so. Then where Article 16 is also considered.
19 is an exception. 19
Right.
citizens has been specifically used. So,
yes.
so that will be for Google and YouTube to argue
Yes.
that they have that right.
Then we have 30 and 32 minutes.
So we'll resume after 10 minutes.
Yes.
Mr.
Yes.
Yes, sir.
My lord, Chandrima Das's case, my lord, I was placing my lord, para 28, my lord, I placed.
Yes.
30 and 32, my lord, it says the same thing, my lord.
Yes.
30 also distinguishes.
Different articles. Life is explained what is
Yes.
universal
And
declaration.
32, my lord, life is explained my lord, under
Yes.
the
Yes.
Universal Declaration of Human
Human
Rights. And my lord, the last judgment, my lord, is 1991, volume 3, Supreme Court cases, 554.
Right.
Para 13. J8II.
Watch it. We did it.
Yes.
The next point taken on behalf of the petitioners that foreigners also enjoy some fundamental right under the Constitution of India is also of not much help to him. The fundamental right, fundamental right of the foreigner is confined to Article 21 for life and liberty and does not include the right to reside and settle so and so. That was a different point. Therefore, these are, my lord, my very respectful submission, my lord, in respect of, my lord, the matter, my lord, which has come before this court, my lord. My lord, would your lordship, my lord, permit me to make a sort of a chart of what I have placed, not the judgments, of the offending articles.
Yes, you can do that. The pages. You refer
Yes.
to certain pages.
Pages and paragraphs.
You can do that, but give copies to them in
Yes,
advance. Then.
Yes. And my lord, yesterday
you mentioned certain pages.
Yes, those only, my lord, to collate them and
Need
my
not,
lord,
need not,
Very.
need not.
Very.
Don't add anything, add to the papers. You have sufficiently indicated the pages. I have taken note of all the pages.
only one or two items, my lord, is also there, my lord, in the supplementary affidavit. We have served the other side. Isn't it?
This is regarding what? Some other articles?
Some other articles.
I'll not permit you at this stage, Mr.
Very well.
So that will open up a plethora of, Pandora's
yes.
box in fact.
Very well.
Right.
These are my submissions.
Thank you. You want to submit before the union? Union comes first. Responder number 1, that's right. State.
Aligarh police station is the
No, union, because theirs is the shortest probably. You don't have anything to say. What do you say?
No, but essentially, had Mr. Ganguly been here, my lord, he would have.
Mr. Ganguly for the state.
No, for the respondent number 10, 11, and 12. He'll be there in 5 minutes.
No, because the minute under section 23, my lord, he has a right of pre-audience, my lord, since of the Advocates Act, my lord, since he's a
So, Mr. Ganguly means Mr.
Shondipal Ganguly.
He has a pre-audience why?
My lord, under section 23 of the Advocates Act, my lord. No,
If he is present, Mr.
If he is
Bhattacharya.
present, yes.
He is not present, so start.
Very well.
Let us conclude the matter.
But in so far as my lord, grant of interim reliefs, I understand. that.
You are for the union only.
Yes, yes.
Right.
But the first point, my lord, that I will be taking is, my lord, a lot has been said.
Mr. Bhattacharya, you want to use an affidavit. Otherwise, I am hearing the main writ petition.
But I would like,
Including the maintainability point.
yes, I would like to come up with an affidavit, including the maintainability point. Mine will be, in fact, my lord, essentially on the point of
Maintainability point is open. Please argue on that also.
Mine will be essentially on the
Yes,
point
yes,
of
absolutely,
maintainability, my lord.
absolutely. What is that? That does not require an affidavit from you.
But
I'll ask the others also. If affidavits are not required, either I can hear it for interim orders. Let us be sure on that. I mean, are we hearing this for interim orders? Do you want to add papers by you of opposition? Otherwise, opposition is not necessary for legal arguments.
Opposition.
I can permit you to file very short written notes of arguments, but opposition is not necessary for law.
So far, the public documents are there.
Yes.
These are all available. As Mr.
Those have been annexed by him.
And there are sources upon which we have made some of the sources.
You want to disclose those?
If required, Lordship, I will.
No. Either you, if you wish to use an opposition, I'll keep it open. I'm hearing this for interim orders then.
Lordship, for the purpose of interim order, Lordship, kindly considered for the purpose of interim order, but Lordship.
Very well. Then I'm hearing for the purpose of interim order. Not, if you want, I can direct affidavits after that. This is not the final disposal of the writ petition. Let us be clear on that first. Very good.
My lord, I open my case, my lord, by
Yes.
saying.
Right.
My lord, I'll repeat it, my lord, even for the sake of prolixity, my lord, that I am representing, my lord, only the respondent number 1 and 2, my lord, being, my lord, the Union of India, Ministry of Information and Broadcasting, and, my lord, the Union of India, Ministry of Electronics and Information Technology. So, my lord, may kindly record that, my lord, that I commence, my lord, on behalf of only these two respondents
Right,
and none
right,
else.
right.
My lord, but I'll deal, my lord, with the, my lord, the merits also, my lord, first, my lord, and then I'll come to, my lord, yesterday.
Whatever we do, let us try to limit it to the nutshell.
No, my lord,
You deal with everything,
the
whatever you
point
want.
that I had taken yesterday, my lord, at the
Yes.
commencement, I'll take that last, my lord.
Whatever, yes.
My lord, first is, my lord, the question is, admittedly, my lord, action under defamation, my lord, is a right in personam, my lord. It's not a right in rem. So whether the cause of another person also be advanced in an application under Article 226 of the Constitution of India, which is otherwise not permissible, my lord, under defamation proceedings, my lord, be it civil or criminal, my lord, by way of, my lord, short-circuiting the process and approaching and knocking the doors of justice under Article 226 of the Constitution of India. My lord, why I say so? I had taken a point yesterday that whether a fundamental right which is available exclusively to the citizens of India, which has been exclusively and consciously preserved by the framers of the Constitution for the citizens of India, whether, my lord, that can be, my lord, whether there can be imposition of a ban or a temporary ban, my lord, by a foreigner. The petitioner, admittedly, my lord, is a foreigner, my lord. Now, the petitioner has described herself to be a Thai national. She is, I understand, presumably having a Thai passport also. And along with that, she is an OCI card holder. OCI means Overseas Citizen of India. Now, my lord, I will be relying upon my lord, the Gazette notification. No, no. সেলাই করাটা কোথায় গেল? এই সম্পূর্ণ নিয়ে নিয়েছে। Yes. And I'll be relying upon the Gazette notification. Please. দিলে নে ভাই, টেনে নিচ্ছিস কেন?
হ্যাঁ, এটা পিটিশনার এগুলো আলাদা একটা ইয়েতে কোড দিয়ে দাও এখন। হ্যাঁ, হ্যাঁ, হ্যাঁ। Yes.
But this is the Gazette publication, my lord, by the Ministry of Home Affairs. This is the latest one pertaining to, my lord, the OCI.
Give a copy to them.
I have already.
Yes.
I have already, my lord.
Right.
But while I was busy, my lord, guarding the copy, my lord, which was being attempted to be snatched away by, my lord's namesake.
Yes. Please, the first page.
Yes, my lord, this is, my lord, the notification in exercise of powers conferred by subsection 1 of section 7B of the Citizenship Act and in supersession of the
Please, the first page, Mr. Bhattacharya.
first page. It's in Devanagari, my lord. So, my lord, I'll
read it out.
my lord, and
one of the official languages of our country.
Yes, it is one of the official language, my lord, but I take a lot of time, my lord, reading it. So by then, my lord, I'm sure
Let us try.
The vacations will commence, my lord, if I start reading it now.
Yes. What do you want to rely on?
Yes. My lord, this notification categorically specifies that the OCI, my lord, kindly takes the explanation at the last page.
Yes.
For the purposes of this notification, the OCI card holder, including a person of Indian origin card holder, is a foreign national holding a passport of a foreign country and is not a citizen of India. So, my lord, admittedly, my lord, she is a foreigner, my lord. Now, a foreigner is before your lordship pleading that her rights under Article 21 and 14 are being infringed, and on the basis thereof, a curtailment of right to freedom of press and private individuals, my lord, who I understand are citizens of India, are sought to be, my lord, curtailed, my lord. The freedoms, my lord, as guaranteed under Article 19. Now, lord, if we visualize, my lord, the situation, I'm asking this question to myself, my lord. But if this is allowed, my lord, if a foreigner is permitted, my lord, to come and file a writ application and scuttle the, my lord, voice of the citizens of India, my lord, under Article 19, without going into the veracity of whatever has been there, my lord. I was going through, my lord, the reports, media reports, whatever has been annexed, my lord. These, my lord, these, most of them, my lord, these seem to be, my lord, questions. It has been hard. Is it true? These are the nature of, my lord. Sorry. These are the nature of, my lord, the headlines, my lord. I was going through a few, my lord. I can place, my lord, a few of the headlines, my lord. First is, my lord, the first annexure.
Mr. Bhattacharya, give me the page numbers instead of
78. Yes. No, my lord, I'll just run through the headlines, my lord.
Do that. Give me the page numbers also.
78, annexure P1.
Yes.
Such and such's wife caught with 2 kg gold. Then there is a question mark. Then there is a question mark. Then there are certain, my lord, tweets, my lord, which has been also appended, my lord, to this article. Page 80 explained why CBI is investigating the petitioner, wife of such and such, in illegal coal mining scam. Other parts are illegible, my lord. Thereafter, my lord, coal scam.
Questions are not statements, you were saying.
Yes, page 84. These, they will be in a better position to apprise, my lord. I was just going through the petition. I was doing my research. This struck me, my lord.
I'll take down your point. Yes.
Page 84. Bengal syndicate tapes. Coal scam accused Anup Maji's aide exposes syndicate in TMC rule. So I do not find, my lord, any mention of the petitioner herein, my lord. So, my lord, why this apprehension? It has been stated that the CBI, page 87, that the CBI has questioned the MP, MP's wife, the petitioner, and his sister-in-law, such and such, in connection with the case. So, I understand it is not Mr. Dotto's case, my lord, that they were not questioned, or unnecessarily it is a false statement. Thereafter, page 88. Abhishek Banerjee got 900 crore from coal cow smuggling, alleges BJP, releases proof. So this is absolutely political. These are between two political parties, which, my lord, this particular, whatever this media is, at a media, HT, Hindustan Times. So they do not say that, no, we are saying that Abhishek Banerjee has taken 900 crore. They are saying that BJP has alleged that Abhishek Banerjee got 900 crore from coal smuggling, cow smuggling, etc. It is alleges. So, my lord, these are only, my lord, CBI ED page 93. CBI ED probes into Bengal scams. Is judgment day fast approaching for the Trinamool? My lord, the petitioner, my lord, being a foreigner, one of the preconditions of holding, my lord, an OCI card is that she is not supposed to meddle into, my lord, the political affairs of India. That entails, my lord, cancellation, my lord. So does she say, my lord, that she is representing this particular political party? She cannot be, I understand, my lord. As I said, my lord, it's a right in personam, my lord. So, my lord, if we go on reading, my lord, these are, my lord, basically, these are the nature of, my lord, post, my lord.
What are the point, Mr. Bhattacharya?
Yes.
Yes. So 3 points I've gathered. One is defamation, right in personam. That cannot be, I mean, in the garb of a 226, that cannot be ventilated. Article 19 cannot be overridden. Citizens' rights cannot be overridden by a foreign national in the garb of Article 21 and 14. And the third is, these are questions and suggestions and allegations, sort
what
of.
appeared to me, my lord.
Very well, yes.
I consider, myself to have not much prudence, my lord, but with such lesser degree of prudence also, my lord, this is what appeared, my lord. This is what transpired, my lord. My lord, a person, my lord, who is a foreigner is definitely, my lord, permitted to file writ petitions, my lord. But my lord, a person who is not a citizen would not be entitled to enforce rights which are preserved exclusively for a citizen of India. My lord, this, my lord, was first held by our court only, my
No, no,
lord.
this is Article 21. She is enforcing
Oh.
2114.
She is,
But she's trying to curtail
she
your
is
allegation
seeking,
is
my lord,
Cartel
she
19.
is seeking negative enforcement of Article 19, my lord. She is seeking negative enforcement.
Why do you say that? Seeking negative enforcement is different from curtailing somebody's right.
19 be suspended as against, my lord, the private respondents herein. That is the case, my lord. Again,
Very well, very well.
again, my lord, coming to, my lord, this YouTube, etc., my lord, these are platforms, I understand. YouTube, I understand, will be in a better position to explain that. These are more like platforms where people who are performing on these videos, my lord, they upload it. And I understand they have their own privacy policy. And there are options, my lord, even in Facebook. I am a Facebook user. I am not much of a YouTube user. But there are community standards and privacy policies, my lord, where there are options, my lord, to notify it or to report it. And if it matches along with the community standards of those platforms, then they take appropriate action.
Right.
In Facebook, I personally find, my lord, whenever some music that I love, I upload a photo of mine or a photo of a landscape with that music, I immediately find that there has been, it is a copyrighted soundtrack. So immediately that is muted. So these community standards are there. Now, my lord, constitutional tort, what they are essentially claiming, my lord. But constitutional tort, my lord, even if we go by the views of Justice Nagaratna, my lord, in the recently delivered judgment, my lord, Kaushal Kishore's judgment, my lord, that was the dissenting view of Justice Nagaratna. But, my lord, it was her ladyship's view that it is best left to the parliament to introduce laws regulating the conduct of citizens, my lord, insofar as freedom of speech, etc., are concerned. And hate speech and connected, my lord, subject matters, my lord, they were, my lord, left to, my lord, the common law courts, my lord, being, my lord, the civil and criminal proceedings. That judgment is, my lord, reported in 2023, 4 Supreme Court cases, page 1. The concluding portions, my lord, boita আছে তোর কাছে? আছে? কৌশল কিশোর, হ্যাঁ। আছে, তুই দেখাবি কি ওটা? Oh, Mr. Chatterjee will be relying on that exclusively, my lord. So I will not take much of the precious, valuable judicial time, my lord. The question is, my lord, as I'll now come back to the moot question, my lord. Can Article 14 and 21 be invoked by a foreigner to assert that no, the freedom of press, my lord, has to be curtailed? But the Honorable Supreme Court says none of the articles in Part 3 of the Constitution of India, none of the fundamental rights outweigh each other. It is not the case that 19 will outweigh 21 or 21 will vice versa, my lord. A balance has to be struck. But again, having said that, the Supreme Court says that someone, in order to curtail the freedom of speech as guaranteed under Article 19, that someone has to resort to 19(2) of the Constitution of India. I cannot say that I am resorting to Article 14 or Article 21 to curtail someone's rights as guaranteed, the freedom of rights as conferred under Article 19. Article 19(1), freedom of speech, the fundamental freedoms, my lord, that is on a higher pedestal than the other freedoms guaranteed under Article 19.
Right to life. More
Then
than
that is what the, no.
Article 21 is.
No, I said, my lord, Article 19(1), my lord, freedom of.
91 overrides is on a higher pedestal than right to life also.
But I am on Article 19. I am talking
You are
about.
submitting that Article 19
No,
is on
I-
a higher pedestal than the
I
other
said
fundamental
Article
rights.
19(1), freedom of speech
Hmm.
is on a higher pedestal
Then
than, my lord, the other freedoms. That is Article 19(1)(a) is on a higher pedestal than the freedoms as contained in 19(1)(b) to
other
G.
freedoms, definitely.
So, my lord, in this connection, my lord, the first judgment, my lord, that I will be relying upon is reported in 1994, supplementary 1 Supreme Court cases, page 615. Second copy, sir. Second copy, sir. But here what happened, a foreigner, he filed a writ petition invoking Article 21 and Article 14, saying that I have a right to asylum or a right to residence, which is guaranteed. So he claimed, my lord, protection under 19(1)(e). Now, para 75.
Why is this relevant? I mean, we are not on 19(1) freedom of speech versus 19(1) others.
No, I
We are
am
not
on, my
claiming on freedom of other freedoms
No, no.
as opposed to freedom of speech.
But kindly, my lord, I'll just place the relevant paragraph.
Tell me, why is this relevant?
Well, this is relevant because my lord, in order to bolster my contention, that other articles cannot come into play to enforce Article 19. Article 19 is self-content.
The judgment you are citing, Mr. Bhattacharya, if I understood you correctly,
Yes.
that is 19(1) freedom of speech versus 19(1) other freedoms. So
But
that has no relevance
I'll
here.
just,
You are saying the other articles will not be borrowed to curtail 19(1)
yes,
freedom of speech.
yes.
So
As such,
my specific question to you is then, if you say that, then do you say that Article 19(1) freedom of speech itself, which is on a higher pedestal vis-a-vis other freedoms, is it on a higher pedestal than the right to life also?
freedom of speech, as the Honorable Supreme Court has said, my lord,
yes,
can be only curtailed by, my lord, the reasonable restriction, my lord, under
that is in the
92.
context of the other freedoms.
Under 19(2).
Yes, 19(2) is
19(2).
one of the fetters.
No,
but
because 19(2) has to be read in light of procedure established by law,
yes,
as contained in 21.
right.
So 21 is the procedure established in law.
No, Mr. Bhattacharya, we are on a higher footing here.
Yes.
It's other articles versus Article 19. Your judgment is on Article 19 vis-a-vis, I mean, inter se. Freedom of
But
speech.
I'll just read out, my lord, the relevant portion. It's just 3 lines, my lord.
Give me the paragraphs.
Yes, paragraph 75. It states, my lord, that it is true that fundamental right is available to a foreigner as held in Louis D. Red versus the Union of India, which was relied upon by Mr. Dotto. Then para 13 has been quoted. The next point taken on behalf of the petitioners, that the foreigners also enjoy some fundamental rights under the constitution of this country, is also of not much help to them. The fundamental right of the foreigner is confined to Article 21 for life and liberty and does not include the right to reside and settle in this country as mentioned in Article 19(1)(e), which is applicable only to the citizens of this country. As such, Articles 19(1)(d) and (e) are unavailable to foreigners because those rights are conferred only on citizens. Certainly, the machinery of Article 14 cannot be invoked to obtain that fundamental right. Rights under Articles 19(1)(g), D and E are expressly withheld to foreigners. So, my lord, I am on this, my lord, borrowing this analogy and saying, my lord, that if she has to plead for curtailment of freedom of speech, she has to avail the reasonable restriction as has been contemplated under 19(2) of the Constitution of India, my lord. And my lord, what the other judgment, my lord, that I'll be relying upon is, my lord, it's reported in AIR 1962 Supreme Court, page 603. I'm sorry, page 305. The relevant paragraphs will be, my lord, para 35, 36, and 37. This will be of some essence, my lord. Please. Yes, sir. But I'll just read the paragraphs. These are not very lengthy paragraphs, my lord.
Yes, yes.
But the para 635 starts at page 313.
Yes.
Since the very object of the impugned law is to affect the circulation of certain newspapers which are said to be practicing unfair competition, it is difficult to appreciate how it could be sustained. The right to freedom of speech and expression is an individual right guaranteed to every citizen by Article 19(1)(a) of this Constitution. There is nothing in Clause 2 of Article 19 which permits the state to abridge this right on the ground of conferring benefits upon the public in general or upon a section of the public. It is not open to the state to curtail or infringe the freedom of speech of one for promoting the general welfare of a section or a group of people unless its action could be justified under law competent under Clause 2 of Article 19. It is admitted that the impugned provisions cannot be justified on the grounds referred to in the aforesaid clause. It was, however, contended, the next paragraph, on behalf of the state, that there are two aspects of the activities of newspapers: the dissemination of news and views of commercial aspect. These two aspects, it is said, are different from one another, and under Clause 6 of Article 19, restrictions can be placed on the latter right in the interest of the general public. So far as it is relevant for the purpose of the argument, Clause 6 reads thus: nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the rights conferred by the said subclause. Then para 37, it may be well within the power of the state to place in the interest of the general public restrictions upon the right of a citizen to carry on business, but it is not open to the state to achieve this object by directly or immediately curtailing any other freedom of that citizen guaranteed by the Constitution, and which is not susceptible of abridgment on the same grounds as are set out in Clause 19 of Clause 6 of Article 19. Therefore, the right of freedom of speech cannot be taken away with the object of placing restrictions on the business activities of a citizen. Freedom of speech can be restricted only in the interests of, well, mark it kindly, the security of the state,
Did I mark it?
friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. It cannot be like the freedom to carry on business be curtailed in the interest of general public. If so, this will be, my lord, relevant, my lord. So, my lord, what I was humbly trying to contend, my lord, and demonstrate before your lordship, if my lord kindly takes Article 19, sub-article 2. So 19.2 deals with, my lord, the reason, 19.1a. It states that nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. So, my lord, here, my lord, we are, my lord, before the Honorable Court, my lord, exercising, my lord, powers under Article 226 of the Constitution of India. Now, powers under Article 226 of the Constitution of India, my lord, are to be exercised, my lord. How? It has been laid down, my lord, in Article 225 of the Constitution of India. Now, 225 opens with the word that subject to the provisions of the Constitution. So, my lord, the law has to be made subject to the provisions of the Constitution. And, my lord, under 19.2, or the procedure established by law, my lord, the reasonable restriction is, my lord, the laws pertaining to defamation. Insofar as, my lord, these allegations, my lord, if taken, my lord, on their face value, at the most, my lord, they can lead to, my lord, actions under the laws pertaining to, my lord, civil and criminal defamation. So, my lord, the question is whether when there is a procedure established by law, but the legislatures, my lord, at the time of enacting the laws, my lord, were very conscious. Even the procedural law, my lord knows far better than me, my lord, so far as, my lord, the civil procedure code is concerned, my lord. The procedure has been laid down also, my lord, about how a suit has to be filed by a foreigner, my lord. So every safeguard, every procedure is contained therein, my lord. So, my lord, in that premise, my lord, the question remains whether this writ petition at all will be maintainable, where admittedly on the face of it, my lord, It cannot be adjudicated also, my lord, without going into, my lord, the evidence, my lord. This requires taking of evidence, my lord, examination, cross-examination, essentially a trial. So this is one point, my lord. The other point, my lord, that I will be arguing, my lord, or I will be indicating rather. Mr. Dotto has argued, undoubtedly we are a court of record. The Honorable High Court is a court of record. Powers are available under Article 215. Now, my lord, powers under 215, whether that can be enforced by way of, my lord, filing a writ petition, where admittedly, my lord, no trial has commenced. First. Second is, my lord, there are allegations leading to multifarious issues, my lord. It's a clear case of misjoinder of causes of action, my lord. This scam, that scam, this and that, someone visiting overseas. So, my lord, going by Article 225 of the Constitution of India, my lord, the rules pertaining to, my lord, applications under Article 226, my lord, has also been framed by our High Court. Now, my lord, if we take, my lord, the determination, my lord, we will find that, my lord, it is, my lord, the division bench, my lord, of the Honorable the Chief Justice, my lord, which is having, my lord, the determination to hear out, my lord, criminal contempt matters, appeals under Section 19(1)(a) of the Contempt of Courts Act, matters relating to contempt of subordinate court, even if, my lord, trial has commenced, my lord, then, my lord, the subordinate court's contempt, my lord, any other matter irrespective of classification as directed by the Honorable the Chief Justice. So, well, this is, my lord, the procedure.
Mr. Bhattacharya, apart from criminal contempt determination being with the chief, the other component of your argument is also there that because central agencies are there, I'll also have to
Yes,
deal
I said, my lord, I'll take that point last because I felt, my lord,
even
after
then,
doing a
even then
thorough,
it's a valid point.
after doing a thorough research, my lord, I thought that I should indicate, my lord, these points, my lord.
Very well.
And, my lord, misjoined as I was indicating, now the Supreme Court, my lord, in 2012, volume 10, Supreme Court cases, page 603, which was the first case relied upon by Mr. Dotto, my lord, the Sahara India's case versus SEBI. So, para 52, my lord, will find you. Acting as Oh.
No, you can read out from there because he has cited all.
My lord, the
Para 52.
yes, para 52, my lord will find yeah. Kindly bear with me for a moment. Yes. Yes. Take a I'm sorry, my lord. Para 53, my lord. The last, my lord, from after Placitum F. We do not wish to enumerate categories of publication amounting to contempt, as courts has to examine the content and the context on case-to-case basis, my lord. This is what, my lord, the Honorable Supreme Court has also said, my lord. After, my lord, observing elaborately, my lord, this was the final conclusion of the Honorable Supreme Court, my lord, even in Sahara's case, my lord. My lord, had the ED been here or had I been for the ED is not represented, my lord. My lord, much was argued on this on the point, my lord, that the police cannot do this, the police cannot do that during investigation. My lord, the ED, I understand, my lord, under within the contours of Section 50, they conduct an inquiry, my lord, not investigation. So, my lord, I understand, my lord, inquiry and investigation, my lord, are classes apart because upon completion of the inquiry, the prosecution has to be filed, but I cannot, my lord, submit on that aspect, my lord, because I am not authorized in this case, my lord, to.
Should I record this submission or
No,
not?
my lord, I am just, my lord, we are discussing the law, my lord. I found this matter to
Let
be
us
a
not discuss the law. You make your arguments and I'll hear
very
that.
well, my lord. The last point is, my lord.
Discuss law in some other place.
No, here, my lord, Mr. Dotto has elaborately discussed law. It was.
No, he has argued. He has made specific argument.
He has argued, and in fact, my lord.
If you have to argue that, I'll take it as a
No,
point.
in fact, my lord, I will be, my lord, rather be thankful to Mr. Dotto for being enlightened, my lord. It was a discourse on constitution, my lord. I felt like since yesterday, I have always considered him to be one of the authorities, my lord, insofar as this field is concerned. It was more like going back to college, my lord.
The limelight is shifting from the court, Mr. Bhattacharya. In the morning you started with me. Now you're ending with Mr. Datta. That may be crucial. fatal to you.
I always have the highest regard, as I said, my
Yes,
lord.
Mr. Bhattacharya, anything else? Yes.
The
let us
last
finish the
point
matter.
is, my lord, but this stems out of, my lord, there are two aspects, my lord, insofar as the petitioner's case is concerned.
Yes.
One is my husband has filed some FIR before the Kalighat police station.
So your parent argument remains that the family cannot be brought in by
No, family cannot
because
be,
these
but
are
no.
separate cause of action.
Yes, first of all, that is there. But what is her basis to knock the doors of justice under Article 226? She says that my husband has filed some FIR relating to some sting operation. Therefore, the Kalighat police station.
That is stated in the writ petition.
Yes, yes, that is one of the prayers also.
Very good. Yes.
So, my lord will find, my lord kindly takes prayer.
I'll take it on your statement, Mr. Bhattacharya. Let us proceed on that.
Yes.
What is your argument on that?
No, a writ of or in the nature of mandamus directing the respondent number 5, that is the Kalighat police station, to keep strict vigil over the false, fake, motivated news being broadcast and or published by various media houses, channels, individuals, and take necessary steps in order to avoid any adverse law and order situation that may be caused due to such wrongful reporting in the state of West Bengal. So this is, my lord, the writ petition emanates out of, my lord, the FIR which was lodged.
The presumption is Kalighat police station has jurisdiction over the entire West Bengal.
Seems so, my lord.
As per this prayer.
Seems so, my lord.
Mr. Datta will be able to better explain that.
Oh, but it's 0.5 is the state. No, the pleading is Kalighat police station.
Better.
And, my lord, that apart, my lord, the other fact is, my lord, their cause of action, my lord, is from, my lord, the inquiry being conducted by the Enforcement Directorate, the press statements which they heavily relied upon, and the investigation. So this basically stems out of, my lord, the investigation conducted by the central agency. And but central agency will come within the definition of police in terms of, my lord,
That's certainly.
yes. I have the monthly list with me, my lord.
Yes. Can you just furnish a photocopy of that page? Just for the records.
Yes, I will do that, my lord. I will do that. By lunch break, my lord, I'll furnish.
Yes, yes, absolutely.
I'll furnish it. So, my lord, these are, my lord, my limited argument. Nolakha's matter, which was relied upon heavily by Mr. Datta yesterday, I had indicated the Bombay High Court judgment, my lord. That was, my lord, after exchange of affidavits. That was the final, that was the judgment, my lord. That I had indicated, my lord. So my lord, I'll correct my submission, my lord. The surveillance and supervision by the state is based on the FIR lodged by the petitioner's husband in Kalighat police station. That averment is there, my lord. I'll just averment to para 49. I'm grateful to my
the petitioner's husband lodged an FIR. I mean, lodged a complaint.
lodged
That
an
is the
FIR.
genesis of this. They are alleging.
Yes, I'll just read it out for your lordship. my lord.
Yes.
It is submitted that the respondent
This
number
is para 59.
49, my lord.
49 only.
49, page 50.
Right.
It is submitted that the respondent number 5 is responsible to maintain law and order situation in the state of West Bengal. The respondent number 5 is presently investigating Kalighat PS case number such and such under section such and such of the Indian Penal Code, wherein the petitioner's husband has complained that the respondent number 4 is leaking confidential and sensitive information regarding pending investigation to the media houses. It is thus important that the respondent number 5 should keep vigil over the different media houses, channels, individuals who have the habit of publishing, broadcasting fake and bogus news, as the same may lead to adverse law and order situation. These are I say, my lord, that the writ petition ought not to be entertained, my lord. First of all, my lord, it has to be dismissed in limine, because there is, my lord, the procedure established by law available under Article 19, sub-article 2, my lord, which is an action under defamation at the most, my lord. This is one. Second is, my lord, I have already indicated, my lord, I will not, my lord, repeat and, my lord, take more of your lordship's, my lord, precious time, my lord. I'm grateful to your lordship.
Mr. Ganguly, you are for the? Who is that? ইউনিয়ন অফ ইন্ডিয়া না, এটা রেকর্ডে থাকবে। আচ্ছা আচ্ছা, হ্যাঁ হ্যাঁ, এটা ইউনিয়ন অফ ইন্ডিয়া আলাদা ফোল্ডার করে ফেলে রেখে ফোল্ডার শেষ হয়ে যাবে তো, মামলা শেষ হয়ে যাবে, অনেকগুলো ফোল্ডার খবরটা আলাদা। ইয়েস মিস্টার গং।
Finding myself arguing against Mr. Datta is one of the hardest tasks for me, considering my level of understanding of this branch of the law. But still, my lord, your lordship will kindly consider the purport of the judgment which was relied upon by my learned senior friend, the Sahara. My lord, what did the Honorable Supreme Court was whether the reportage made by the different media houses was affecting the administration of the course of justice. Well, it did not, the Honorable Supreme Court did not limit itself to the violation of only the fundamental rights or the legal rights of a person. It looked into the entire question as to whether the confidence of the people in the administration of justice was being affected by the reports and the publications which were being made. Now, in this case, kindly considers, so far as my client is concerned, the petitioner has alleged about 2 publications. None of them relate to any reporting with regard to any proceeding which is going on before any court of law.
Mr. Ganguly, can you please give me the page numbers of your reportings? Just give the page numbers.
Yes, Malad, they are
During the course of your, you may continue. You may just give me the page.
84 to 86, 87.
Yes.
And then 100 to 108.
Thank you.
I'll take your lordship through the same. Now, therefore, if your lordship has to pass an order, interim order, protecting the petitioners, well, your lordship has to be satisfied that these reportings affect the course of administration of justice. Well, while passing an interim order, my lord, these are issues which are more within your lordship's province and my learned friend's
No,
province.
there is no province for any.
My lord, urgency needs to be pleaded. That unless this happens, this will. My lord, in the entire petition, there with subject to correction, my lord, no urgency has been pleaded. My lord, kindly considers the 2 reports now. My lord, one starts at page 84. This is a report which was published on the 3rd of April 2021, about 3.5 years ago. Kindly sees whether it relates to the petitioner or her husband even. Well, it starts with Republic Bengal Syndicate tapes, coal scam accused Anup Maji's aide exposes syndicate in TMC rule. Republic TV on Saturday has accessed tapes of conversations between an unknown individual and this. It goes on. Then next page. In a massive development, Republic TV on Saturday has accessed tapes of alleged conversations between an unknown individual and coal scam accused Anup Maji's right-hand man Ganesh Bagaria, exposing the syndicate culture in Bengal government. While the tapes have not been verified, Bagaria is heard allegedly describing the syndicate which runs the coal smuggling business since 2012. Currently, Bengal polls are underway where an emerging BJP is trying to oust the 10-year Trinamool. It goes on, my lord. Kindly sees in none of those pages, except, my lord, at 87, your lordship will find the last sentence. CBI has already questioned Trinamool MP Abhishek Banerjee's wife this and his sister-in-law this in connection with the case. A reporting of a fact. That's all. My lord, the next one is at 105. 100, sorry. my lord, it relates to reporting regarding a Prabhavshali Neta or an influential.
There's a tag which names her husband.
It also includes TMC. It
TMC, she
also
cannot have any
includes ED. My lord, why these tags come? Because my lord, these tags are for the purposes of wider circulation.
Yes.
And when these tags are popular are trending in the Twitter, it is in those circumstances those tags are attached.
But Mr. Ganguly, the tag is attached by the author of the post.
Yes, yes.
In any social media. So this, if at all her husband can be dragged into this, I mean, she can canvass her husband's case, if at all. But her husband's name is tagged in that post. So if you put a question, I mean, Prabhavshali Neta you say, and then you in the tagline you put in somebody's name, then obviously you're indicating that person.
Well,
so whether we can go into that her husband's case, that is a different question altogether. But
well,
it's very specific.
The issue is,
yes,
I have that explanation. In fact, in relation to this tweet, a case has already been started by the husband of the petitioner. That is Kalighat Police Station, case number 111 of 2023. This is the copy of the first information report, which was filed by the husband of the petitioner. Kalighat PS case number 111 of 2023.
Yes, the exact same tweet.
Same tweet
Right.
is the subject matter of an investigation already, in which a reporter of Republic TV was summoned by the police under section 160 of this Code of Criminal Procedure and was examined by the police. And the last page of that has the summons under 160 and the compliance thereof. Now kindly considers.
Should I keep this on record?
Malat, please.
Right.
Now, these are the two reports which are there. The report per se also does not reflect the name of the husband of the petitioner. Now, in those circumstances, whether or there is a requirement of an interim order at this stage, your lordship will kindly consider, in view of the fact that stale causes of action have now been raised before your lordship in order to obtain an order. Milord, why I say the issue of misjoinder gains importance is that, Milord, multiple media houses, government agencies have all been brought together under the umbrella in order to get a blanket order. Now, if your lordship kindly sees the prayers which are being sought for. The ad interim order in respect of the media houses starts at page 73 of the application.
Yes.
Kindly sees K. Ad interim order directing the respondents number 6 to 21, these are the media houses, to not make any statement, publication, and/or circulation, genuine or otherwise, and/or voice any opinion, and/or make any representation concerning the petitioner and/or her husband in respect of matters which form the subject matter of pending inquiries, investigations, proceeding, or otherwise, in any manner whatsoever, save what appears from court records obtained access legally, or any other record of any investigating agency obtained access legally, or any. So even expression of any opinion by the media houses are being sought to be stopped. Now kindly sees L. Ad interim order directing respondent number 6 to 21 to not publish, broadcast, and release any news report, publication, and/or circulation concerning any ongoing investigation about the petitioner and oblique or husband, or from publishing anything in any manner that would render such investigation or trial as a trial by media. Now, that is the second part. But the first part is that kindly stops any circulation or publication concerning any ongoing investigation about the petitioner or her husband. Now, kindly considers the strict nature of the prayers that are being sought for. Milord, I need not even submit before your lordship with regard to the need for a free press in a democracy. Milord, the honorable courts have always also put certain restrictions in extreme situations where perhaps that the word has been used by the Honorable Supreme Court, Lakshman Rekha, that Lakshman Rekha has been crossed. Milord, in my humble submission, Milord, from the two reports, which is the subject matter of a cause of action against my client, Milord, your lordship perhaps would not find anything which has crossed that Lakshman Rekha.
Right.
Milord, in fact, prior to the lodging of the complaint with the Kalighat police station, which led to the initiation of this case, Milord, we had received a communication from the learned counsel representing the husband of the petitioner, to which we had duly replied by explaining the reason why such tag had been included in that tweet. And we had also informed that we have also deleted that tweet. Well, this is the first is the notice and the second is our response.
This tweet?
Yes.
That has been deleted?
Yes. Immediately. Copy this too? Hey, I reply copy to the Are Kishore da ke একটা করে নিচে দিচ্ছে বেশ Well, now also, sorry.
Right.
And kindly now considers the prayer O. Ad interim order directing the respondent number 5 to keep strict vigil over the false, fake, motivated news being broadcast and oblique or published by various media houses, channels, individuals, and take necessary steps in order to avoid any adverse law and order situation that may be caused due to such wrongful reporting in the state of West Bengal. Now, kindly considers it does not even relate, it does not restrict itself to the petitioner or even a husband. Now, kindly sees even at the interim stage, a prayer of such wide nature is being asked, where a parallel body to the usual regulatory bodies are being sought to be set up in order to keep vigil over the false, fake, and motivated news. And where investigations are already going on in respect of one of them.
Good.
In both. Now, kindly sees the array of the causes of action as has been set out in the application. Milord, kindly takes it up from page 13 of the application.
Yes.
Well, these are the details provided in respect of the different publications which has impelled them to approach this honorable court. Well, the first of which is being published in 2019. 18th of March 2019. And that is by a publication by the name of My Nation. Matlab, the second is of 2021 of Swarajya. Then ours is 3rd of April 2021. The fourth is also of 2021. And then the 5th, 6th, and 7th are of 2023, 7, 8. And none of them relate to my client. Malad, if my learned friend has a grievance, he cannot get a blanket order like this. He cannot seek a blanket order unless he makes out a case of such gravity which affects the administration of justice. Now, therefore, my humble submission is that, Malad, this is an issue. Malad, with regard to the maintainability, the Union of India has already submitted. I will not trouble your lordship on that. I was also to show that last portion of the Sahara judgment where the Honorable Supreme Court has said it has to be decided on a case-to-case basis. And that is what is my submission. It should be decided on the report-to-report basis. It cannot be considered in a conglomerate manner as is being sought by the petitioner. Now, therefore, my humble submission is that this requires substantial delving into the issues which have been raised by Mr. Datta. And for that, Malad, if your lordship permits us to use an affidavit, and since no urgency has been pleaded, extreme urgency has been pleaded by the petitioner to justify their prayer, Malad, in those circumstances, I was praying that their plea for an interim order may kindly be rejected. And there are other alternative forums, though.
Yes.
Malad, that is under the Cable Television Networks Regulation Act and the rules which provide for the reliefs that may be sought for in respect of any reporting which has been made contrary to the rules provided under there. Sections. এটার একটা কপি আছে? আরেকটা কপি লাগবে। আরেকটা কপি লাগবে। হ্যাঁ। এই না আরেকটা কপি আছে। Malad, in this respect, Malad, we have prepared for your lordship's consideration, Malad, a small notes which provides that there are remedies which are envisaged under the Cable Television Networks Regulation Act. Malad, we have set out the rules which are there under the rules created under this act.
Thank you very much for this. Yes.
So my humble submission is that without approaching those authorities, deliberately this has been done on stale causes of action or on cause of actions which do not reveal that urgent requirement for passing of an ad interim order. Well, these are.
Thank you.
Well, these are my humble.
Yes. এগুলো হচ্ছে R11. Yes, Mr. Chatterjee, you are for the, give me the respondent number.
17 and 18. I have instructions from both of them.
I apologize for this matter which my lord has already heard, that I just received instruction from the enforcement directorate to represent Millard. If anything is required from my side, Millard, but I don't know what the submissions were, Millard. I was totally oblivious, Millard. I apologize.
You take the help of your friends.
Millard, I shall. Well, I'm just recording that I'm also there in the matter. Millard. Just now I received the information.
No, that is very dangerous for you, Mr. Trivedi, because there are not allegations. In the nature of allegations that you are disseminating information to the media. You are one of the investigating agencies here. So you are disseminating this information to the media, which ought to be deprecated. I mean, this is the plinth of the arguments against
Well,
you.
then in that case, my lord, I require to be heard because
I think
this
so
is a
because
very
just
serious allegation being made in a very casual manner.
yes,
And my lord, in that
you
case,
don't have to be impromptu on that. You take your instruction and come back.
my lord, if my lord gives me a day's time, by tomorrow, my lord, just I will not waste more than my lord's 1 minute or 2
Mr.
minutes.
Doctor and Mr. Chatterjee and Mr. Trivedi and whoever is concerned, I mean, I won't continue after the recess with this because there are other
No,
urgent
my lord,
matters.
I'm not
I'll
wanting.
continue with the hearing of this. So, in any event, we'll come back tomorrow on
My lord,
this.
in that case, my lord, that would be a salvation. My lord, this is salvation because I was just informed over the.
Mr. Chatterjee, yes, you complete in 5 minutes. You have been waiting the longest, so you have to complete in 5 minutes. There is a sort of logic which is being employed nowadays. Yes, Mr. Chatterjee, what is your argument?
Lordship, I have
Give me your respondent number first.
17 and 18. Arambag TV and Lordship, Banglar Barta.
Arambag TV, you cannot chicken out at least.
No.
Yes. What is
Now-
your argument?
117 is Safikul Islam for Arambag TV and Shanmay Banerjee Banglar Barta. Now, Lordship, we are the digital platforms. We have the digital YouTube channels through which we have an editorial stand. We are critical about the government ruling dispensation of the state. And we decode the news, we analyze the news, we pass on some commentaries on the contemporary political activities. Both of them are facing numerous criminal charges for defamations, and even the cases under defamation has been started at the instance of the state. Both of them were arrested by the police, detained for sometimes repeated cases, and throughout the years these cases are registered against him. I'm not on that. But since prayer O was pointed out to your lordship that someone is seeking an order in order to protect the law and order situation of the state, who is not a citizen of India, admittedly.
Not law and order situation of this.
Because kindly see.
Law and order is your domain, your client's domain. You are fighting for that. You are fighting for a cause, must be.
Yes,
but they are not on law and order. They are on their privacy and their rights and all.
No, kindly come to
and the administration of justice.
Yes.
That is the language.
Ad interim order to directing respondent number 5 to give strict vigil over the false and fake motivated news being broadcast and published by various media houses, channels, individuals, and take necessary steps in order to avoid any adverse law and order situation in the state.
That's a side prayer.
It's a prayer.
Anyway,
no,
yes.
Lordship, in my humble submission, it amounts to interference with the internal political affairs of the country, possibly
By a foreign national.
by a foreign nationals, which is possibly not permitted. Now, Lordship, regarding the maintainability and the on merits of the petition, Lordship, it was relied by my learned senior friend, that Shahara India, and I want to read 2-3 paragraphs from that. And my paragraphs are, I will start from the 43. This is the conclusion. From the above propositions, the following principles emerge. In any democratic society, the open justice rule must always be norm and covertness the exception. The right to open justice flows from the right to fair trial. It also flows from right of the public to information under Article 19(1)(a). The media, apart from exercising its own right to freedom of expression under Article 19(1)(a), is serving a larger public purpose by facilitating the carriage of information otherwise not available or easily accessible to the public. Thus, by reporting court proceedings, the media is enabling the fulfillment of public's right to information about the working of the courts under Article 19(1)(a). B. 43(2). It is significant to note, under the open justice rule, reporting must be contemporaneous, as recognized by the House of Lords in re
that reporting may take place at this stage is reflected in Section 4 of the Contempt of Court Act. Fair comment must be permitted even during the pendency of the cases. I will be placing on this. Lordship, kindly consider my comments. May I be permitted to read my comments which has been indicated, particularly comments by the first. I will be placing the comment by the respondent number 18. That is HON'BLE Banerjee is placed in 97. It was reported regarding Abhishek Banerjee that it is absurd and unbelievable for a person to go to America via Dubai for 24 days just to get general eye checkup. Raising this question, is it not permissible by a person analyzing the situation? 24 days someone is going to Dubai. Even someone makes this analogy that someone who is advocating for a cause, like your Lordship was pointed out yesterday, that's a sense of humor. Even the Shastro Shati card, if someone is advocating for the cause, it is expected that a political person will be advocating for that has been promoted by the government, which is run by his own party. In which
References to this petitioner, Mr. Chatterjee, are probably two. One is third paragraph. Please come to that last sentence.
Yes.
Later, when he himself participated in that proceeding, he silently sent wife to Dubai to avoid ED investigation. This is one aspersion against her. And the second is last penultimate paragraph. They were speculating that Abhishek Banerjee would make an attempt to travel abroad since he has been unsuccessful in sending Rujira away. So these are the two things.
Even Lordship, if someone, and that's why Lordship, I will be placing that word which has been relied in the first line, the first judgment decision citation given by my learned senior friend.
Yes.
That in that note, Lordship, the first judgment. The media trial creates perception of the guilt in the minds of the public regardless the verdict. The petitioner would not be able to lead the rest of her life without intense public scrutiny. I'm asking this question, that not only being a housewife, but not only being the wife of a politician or an important
person, doesn't want to be a media housewife,
but also the partner in the business. Can someone of a politician, obviously, can he or she be immune from that criticism or even making those questions publicly?
Partner in what business? Partner in what business?
Those materials has to be produced.
What business? Partner business has not been referred here.
Because since all investigations are being done regarding the activities of a particular company.
Yes.
Right. And the money trail, which has been allegedly reported in various medias. It says there were some links. There may be some links. If I make the criticism of those things, or if I raise a question regarding that, will it not be permissible? I will try to justify, Lordship. Kindly give me.
We'll continue tomorrow.
Lordship.
Great. Sector line corner, hard in part for further hearing tomorrow. What is this, Mr. Bhattacharya?
Ask me to give a copy of that police central agency.
No. Yes. Oh, thank you. It is phone number 188 Union of India. One. Thank you, sir.
Great.
I inform Mr. Trivedi as to what arguments were made against his client.
So now the advantage is
that we can
advantage is yesterday I continued with my research till quite late last night. Thereafter I switched on the television and I saw the portion which I could not hear of Mr. Datto's submission. That's a great advantage.
Because live streaming and on YouTube it's available.
YouTube is which I responded number with. Yes.
I'm great.
My is it's a tender matter. So the auction for the coal has commenced from the 9th of October.
Why didn't you mention in the morning?
My lord, because the timeline or the updated timeline, I received it post your lordship sat to this morning. So that's why the auction will started on the 9th and will finish on the 13th. It's regarding the same process that the unit has been debarred for over 5 years and they're not resuming.
Auction will start on the 9th of what?
9th of October, your lordship.
It
So
has
there
started.
are different collieries.
It has started then.
It started. So the timeline today, that was a tentative timeline.
Mention tomorrow morning. Mention tomorrow morning. It's in the list.
It's in the list today.
Give a notice to the other side. Mention tomorrow morning. We'll try to
Okay.
take it up.
And if your lordship could be pleased to take it up on Friday, because I'm being led by Mr. Ratnanko Banerjee in
Tomorrow
this
is Thursday. Come and mention tomorrow morning. I'll consider that. Yes.
matter. Very well, your
Please
lordship.
call
My
on.
lord, I am also mentioned the next morning also.
Grateful.
Yes.
If your lordship so decide.
Yes. Call on the list.
Lordship.
File to them. File to them. ভুল আছে? ওহো, তাহলে নট টু রেকর্ড রাখুন। অর্ডার রেকর্ড করতে হবে নট। এটা পুলিশ এক সেকেন্ড। এটা তাহলে ছেড়ে দিতে হবে তো ফাইলটা। এটা কি ভুল এসছে? ভুল রিকুইজিশন হয়েছে নাকি? হ্যাঁ? তা ঠিক করে রিকুইজিশন করতে হবে এটা তাহলে। হ্যাঁ? নট টু রেকর্ড।
আপনি টেনে?
Item number 11.
My lord, I'm
Yes.
led by Mr. Chatterjee. My
What
lord,
is the matter?
it's subject to lordship sanction. That is, my lord, prayer is very innocuous, my lord.
Yes.
RTI application has been made. Thereafter, appellate authority appeal has been preferred. And thereafter, before the CIC, my lord, in terms of my application, my lord, the deputy secretary, before the deputy secretary, one inter-department application was made. That
You are
is
appealing for the respondent.
that is at my lord,
Pardon?
Leg by Mr. HON'BLE Sen. He's coming.
Yes. Yes.
intra-departmental, my lord, query that is at page 24, my lord. Your lordship may kindly have a look, page 24.
Yes.
I have prayed only, my lord, recommendation of 6 pay commission record report, my lord. There is 3 parts, first, second, and third part. Only these 3 documents, my lord. Your lordship may
What happened before the first 2 forums?
Nothing, not replied. Only, my lord, after making the application, SPIO informed the deputy secretary. It has been said in terms of section 5.4 read with section 5.5 of the RTI, I am to forward here with a copy of the RTI application dated so and so in respect of Sri Devaprasad Haldar, which is closely related to the function of your group, with the request to provide the requisite accessible information as sought for within 5 days. That too has not been, my lord, complied with.
If the second appeal is pending, how can we interfere here?
My lord, that thereafter CIC application has been made to the CIC, Chief Information Commissioner.
So we can direct the second appeal to be heard out expeditiously at
My
least.
lord,
The petitioner sought an information, footstep, however, comma,
for a long period, my lord, they have all the remedies I have exhausted, my lord.
no, you have not, because second appeal is pending.
No,
What do you
second
say
appeal is
exhausted?
pending, my lord, time is over. And thereafter, your lordship kindly have a look after second appeal, my lord, page 26.
You
Chief
start
Information.
your arguments when I start passing my order. Boshu, please complete your arguments. Let me pass my order now.
My lord,
Yes,
that
what is your argument?
that is
Complete
at,
it.
my lord, page 26. That is the CIC, the commissioner.
I don't get it. Your second appeal is not pending now.
Second appeal is pending.
If second appeal is pending, ventilate your grievances there.
My lord, I have ventilated, time is over. And
What
there-
time for what is over? Under which provision?
My lord, that
Time is over means what do you mean by that?
second appeal, my lord, within 60 days, they will provide the,
That timeline is over.
yes.
I'll direct that to be done.
I'm grateful to your lordship.
Learned counsel for the petitioner submits that the petitioner has applied for information, full stop, being unable to elicit, elicit such information, comma, ultimately a second appeal had to be preferred by the petitioner, which is now pending, full stop. It is argued that the time for disposal of the said appeal, that is 60 days, is now over. However, comma, the appeal is still pending. Full stop, next para. Upon hearing learned counsel for the parties, comma, WPA 8595 of 2023 is accordingly disposed of by directing the, it is pending before the, which respondent?
Appellate Authority, Finance Audit Department, I am saying, my lord, that is before the Appellate Authority, Joint Secretary, respondent number 3.
Directing the respondent number 3 to dispose of the second appeal pending at the behest of the petitioner as expeditiously as possible, comma, positively within November 30, 2023. Full stop. Next para. No arrest to cause charging certificate.
My lord, one indulgence, that is respondent
Respondent
number 2 and 3, whoever may be the Appellate Authority, although I have
we cannot pass such vague orders. Yes. Thank you. Next.
No, I cannot say Appellate Authority.
Yeah, please, Your Lordship.
Yes.
Well, Mr. Shane is there in this, HON'BLE Shane is there for the state, my lord.
My lord, I am for the private respondent.
Private response.
In the
Have you
issue-
got the affidavit of service?
Yes, my lord, it has been filed on the earlier occasion. My
Right.
lord, what
Yes.
happened, my lord? Directions, the specific point is, my lord,
Yes.
the power of attorney, the revocation of the power of attorney has been denied by the registering authorities. There is no such power on the register.
You wanted to
Register
the
a
period of
revocation of
revocation.
power. Kindly come to, my lord.
Show me the refusal, please.
Yes, my lord. In action, my lord, because, my lord, I gave the, kindly come to page 64 once, my lord. This is the revocation of power. I presented before the draft was sent to the so-and-so
Right.
for preparation of the query, my lord. Now the query, without the query, my lord, then, my lord, finally come to page 68.
Yes.
I sent a representation to the Register of Assurance that it has been denied. Kindly take steps. My lord, kindly, this is the, everybody I have informed, everybody, my lord. My lord, kindly come to the page 69, my lord. Paragraph 5.
Yes.
In any event, in any way, my clients have the due right to revoke the said registered power of attorney. On presentation of the draft revocation document, your officer expressed inability to register the said revocation document. However, your officer failed to give any reasons. My lord, kindly come to the, my lord. They have communicated one thing, my lord, page 72.
72, right?
Yes. Kindly see, I had presented the document before the Register of Assurance.
Right.
They had sent my representation to the district register, not 24 Parganas. And that was also on 10th of March 2023. From then, my lord, nothing and no step has been taken. Then, well, I filed the writ petition. The point is, my lord, whether the registering authorities could refuse to register the document. I have a right to revoke the power of attorney. Whether that can be denied.
Yes, Mr. Shane, what do you say?
My lord, first of all, Lordship, my lord, so far I, my lord, recollect the instruction, my lord, that is correct almost, but I think that the, first of all, no formal representation, no formal presentation, I think, no formal presentation of the document has yet been made. Second thing, my lord, the, there is a, my lord, the departmental, my lord, the, though that order, my lord, they could not be able to produce before me, but said that so far section 202 is concerned.
Contract Act.
Contract Act.
Registrar can't look into that. Registrar can't look into that.
No, my lord,
entirely beyond the power of the
no, my lord, there are several judgments that in
202 there are several judgments.
to several, my lord knows that. From
No,
Supreme Court,
everybody
our
does.
court, yes. Now, my lord,
You can go into that question. It's a question of
that
your
if
authority.
there is any right so far the grantee of the power of attorney is concerned, it appears from the power of attorney. And if he-
Registering authority
if he
can
has
only
changed
register.
his, because it's a matter of the development agreement. Now the question is that, yes, that I leave it to your lordship. That
I'll direct only that.
that,
Only
that
that I'll keep it.
whether the register can take that point or not. My lord, but the question is that, my lord,
Yes.
whether then my lord kindly, yesterday also my lord passed an order
with regard to that, the authority of the registering
the
authority.
judgment was cited also, you know
And,
that.
and there was some judgment. And in that case, no, in that case, that was, my lord, the question limited to that a lessee, in respect of his rest of the period leasehold right, whether can be transferred or
Not only that, both Justices Bhattacharya held that
yes,
only Stamp Act compliance, Registration Act compliance, that can only be seen, nothing else.
yes. Now,
And that's true, I mean.
but at the same time, my lord, if it appears, I leave it to your lordship,
Even if
whether
it
there
appears
is,
to be an
there is
illegal
any,
document in law.
whether there is any scope to take any, well, not contrary, but any departure from the same. I leave it to your lordship because, my lord, it is very necessary. My lord, lordship, kindly consider one thing, that whether, my lord, suppose, my lord, in respect of any, my lord, suppose, my lord, any government property, government land or anything.
Even if the
of
High Court
which-
is sold, even if the High Court is sold, Mr. Sen,
then-
registering authority can only see whether the Stamp Act and the Registration Act have been complied. It's beyond the scope of the registering authority to say High Court cannot be sold.
When it appears on the face of it that he has no right title.
How can it appear on the face of it? How do you know the High Court has not been sold in the meantime?
No, so far the
How can the
bar-
registering authority know?
So far
Personal knowledge does not count.
Here apparently and on the face of it, not prima facie, apparently and on the face of it, it appears that
Yes.
section 202, my lord, it is hit by 202.
Why does it appear? Tell me.
Because, my lord, he said that the power of attorney, what I have already executed in favor of the
202
somebody.
is not an
this
ex
is-
officio bar. It's not an ex officio bar. 202, if somebody acts on that, partially it has to be acted upon. How can you decide that being the registering authority? 202 has several
202,
components.
yes, acted upon. To some
It's a
interest.
sort of, yes, sort of not exactly established, but somebody acted on that or
He has
invested
changed his
money.
position. He
Right,
has changed his position.
Right. He has invested or
He
done
has
something.
invested.
That has to be decided by a civil code, Mr. Sen.
If I allowed to intervene, my lord, the full bench decision is there, my lord. Even if the development power of attorney can be revoked, that may be a cause of action for developer to approach the civil court.
No, obviously it's within the domain of.
That is paragraph 64. Full bench.
So, my lord, there is no need to, my
You are
lord,
appealing
then,
in this matter.
my lord, there is no need to, my
You are
lord.
supporting his cause.
My lord, I have one thing to say. In this regard, this development power of attorney,
Yes.
they have approached the registrar for registering a deed of cancellation, but they have also approached the civil court in Alipur with a title suit praying for cancellation and revocation of the power of attorney. So they have already made such suit before the Alipur court. They are merely trying to get
To operate in separate spheres. I'll make that clear in my order.
My lord,
Registering authority can.
my lord, that's the thing that there's already an order of the Alipur court in this regard.
What order?
My lord, kindly see page 52 of the writ petition.
Yes.
This is entitled suit number 1934 of 2022.
Yes.
Kindly sees the third paragraph. Sorry, fourth. The plaintiffs, by filing this petition, that part, have prayed for restraining the defendant and his men and agents from making any construction over the suit property on strength of development agreement and development power of attorney. And kindly sees the ordering portion, at the next page, at the end of the next page. Ordered that the defendant and his men and agents are restrained from making any construction over the suit property on strength of development agreement and development power of attorney.
Yes.
So, my lord,
You are the defendant there.
I'm the defendant.
So you have been restrained by an order of injunction from acting on the strength of the development agreement. He is seeking a revocation of the development agreement.
And power of attorney. It
And
is
power of
also-
attorney.
No, I am seeking revocation of the power of
Power of
attorney.
attorney.
Only power of attorney.
My lord, in the suit, he has already sought this. prayer.
No.
Yes, my lord, he is not. He is
Release
not,
are different.
He has not annexed his claim for this reason to suppress this fact before this honorable.
He has sought for a cancellation of the development agreement.
And power of attorney.
And power of
revocation
attorney.
the Power of attorney.
Very well, I'll record that. Registering authority still does not have power. I'll
So, my
record
lord,
my email.
So, my lord, there is no need to cite any judgment on 202, I think.
No,
If-
absolutely.
If that is so, then
202, there are several arguments to be made by them by anybody concerned. I mean.
Yes.
Learned counsel for the petitioner contends that the petitioner presented a deed of revocation.
No, not yet, my lord. No formal presentation.
That is his contention, Mr. Sen. Presented a deed of revocation of a power of attorney entered into with the private respondent. First up, it is contended that the registering authority are refusing to register the same, raising questions as to the legality of such document. First up, next para. It is argued that the registering authority does not have the jurisdiction to do so and has to adhere to the provisions of the Indian Stamp Act and the Indian Registration Act for the purpose of ascertaining the yardsticks as stipulated therein. Full stop, next para. Learned counsel for the respondent authority submits that the petitioner has not yet presented the deed in question for registration. Full stop, secondly, it is argued that the deed itself is barred within the contemplation of section 202 of the Transfer of Property Act. Contract Act of the Contract Act. Full stop. Next para. Learned counsel appearing for the private respondent submits that the petitioner has instituted a suit on the self-same cause of action and has also sought for a cancellation, inter alia, of the very same power of attorney which is being sought to be revoked by the deed in question. Full stop, next para. By placing reliance on annexure P4 to the writ petition, it is submitted that in fact, the civil court is not only in seizin of the matter but has also passed an order of injunction restraining the defendant stroke present private respondent from making any construction over the suit property on the strength of the development agreement dated November 1, 2018 and development power of attorney dated November 1, 2018 till a particular date. Full stop, next para. It is argued that since the matter is already sub judice before the civil court, a similar relief could not be obtained by the petitioner before the registering authority or this court. Full stop, next para. The merits of the suit is not to be adjudicated under Article 226 of the Constitution of India, that too, within the limited scope of the present writ petition. Full stop. The question arising here is what is the extent of the powers of the registering authority? Full stop, next para.
Under section 35 of
It
the
is
Registration Act.
well settled that the registering authority, within the contemplation of the Registration Act, is duty bound to ascertain whether the tests stipulated in the said act and the Stamp Act have been duly complied with by a person presenting a deed for registration. Full stop. If such criteria are satisfied, the registering authority has no option but to register the document in question. Full stop. The issue as to whether a document is hit by section 202 of the Contract Act is for a competent civil court to decide. Full stop. It is beyond the domain of the registering authority even to enter into such civil dispute between the parties. Full stop, next para. Insofar as the arguments of the private respondent is concerned, the same are also not tenable in the eye of law. Full stop. It cannot be accepted that the premise of challenge before the civil court and the registering authority are the same. Full stop. Whereas the petitioner has approached the civil court for a regular cancellation decree with regard, inter alia, to the power of attorney in question, the cause of action of the present writ petition is refusal by the registering authority to register a revocation deed. Full stop. Although, incidentally, the effect of a revocation deed and a decree of cancellation of the power of attorney might operate in the same sphere, it does not mean that the registering authority has co-equal power with the civil court to decide similar issues. Full stop. In fact, comma, whatever might be the civil consequence of the deed which is sought to be registered, comma, will be decided by the competent civil court either in the pending suit or otherwise. Full stop. Next para. The registering authority, comma, however, comma, cannot look into the effect of the said deed or whether title passes or is curtailed by way of the said deed, but has only to see whether the stipulations in the Registration Act and the Stamp Act are satisfied. Full stop. In such view of the matter, comma, WPA 9013 of 2023 is disposed of by directing the respondent number 7 to
No,
not the respondent number 7.
no,
No,
my lord,
six,
directing, my lord,
six.
may I tell? Directing the appropriate registering authority,
Which is
because
the
my lord, he has choice, maybe before the additional district register ADSR or before the, my lord, the registering
I have
authority
given the
here.
representation to respondent number 6. 6 is the competent
By
authority.
directing the respondent number 6 to register the document being the revocation of power of attorney deed, comma, if duly presented by the petitioner before such authority, comma,
No, 6 is not the authority. Registered is not. The DDSR 1 or DDSR 2, register of assurance is at the top. He is not the, my lord,
And
the
there are 11 offices I can register the revocation
no,
document.
but not before.
where have you presented it?
He
Well, I have
cannot
presented,
move
kindly
before
see.
the High Court Chief Justice all the time.
Kindly come to page 68. I have given the notice to register of assurance.
Why did you
and-
present the deed for registration?
No. I said that it was presented before the register of assurances,
Never.
but they refused to accept it. Kindly see, page 69, paragraph 5.
If it
This is
is,
my
my lord,
specific-
may I tell, my lord, my instruction, if it is before the register of assurance here, that is, my lord, whole, my lord, the deed of
All
West-
documents
West
can be
Bengal
registered.
can be registered here.
That's it.
Deed of
All documents of
assurance.
in the
Then,
state
my
of
lord,
West Bengal can be
then, my
registered
lord,
before the
eighty-
register.
Extra fashion কি বললাম আমি?
Additional director registration 1.
6, that is the register of
ADR
assurances, comma, Kolkata, to duly register the document of the petitioner, comma, subject to the said document, comma, being the revocation deed in question, comma, being duly presented before such authority by the petitioner as expeditiously as possible, comma, positively within 4 working weeks from the presentation of the said document before the respondent number 6.
and subject to compliance of all formalities, including, my lord, the stamp duties and other
And
registration duties.
যা বললাম ওটাই continue and subject to compliance of all due formalities as contemplated in law.
Deeply.
No rest to cause.
Next. Deeply.
Document report. আপনি একটু মাইকটা নিয়ে ডাকুন বাবু, মাইকটা নিয়ে ডাকুন।
Item 13.
Thank you.
About the CSC.
Well, I am appearing on behalf of the petitioner.
I dictated for the private respondent.
This is the affidavit of service.
ঠিক আছে।
ছোট করে বলে দাও, ছোট্ট matter.
New connection.
Yes, my lord.
New
Why
connection,
refuse?
I have applied for the new connection, my lord, but the CSC authority does not install on the objection raised by the
Signing.
private respondent number 5.
Milord, we had been there for inspection and we have been physically registered, Milord, and we have also received the objections
Well,
from
I
the
am a-
landlord
Well, I am a lessee.
in writing,
Well, he is not a landlord. He is the father of the private.
claiming
respondent
himself
number
to be a
5.
landlord. Whatever.
That is the point.
Yes, what do you say?
Might not be that much of simple, man. This is the letter issued by their authority, the CSC, which shows regulation 14 of the 2000
Take the mic.
regulation 14 of the 2013 rules splitting of charges. It was denied at their instance on an earlier occasion. They suppressed that and subsequently filed this writ petition on.
You claim to be the landlords.
I claim to be I am the landlord. The respondent of 4 was the original landlord.
You are refusing that, say that itself shows that there cannot be a splitting of load.
That
My
is the
lord,
point.
If you did not oppose,
my lord,
there might have been
I am not
splitting.
opposing to their new connection. I'm just showing that they suppressed these earlier instances and
Unless we go for an inspection, Milord, these matters cannot be ascertained.
Well, I have applied.
they went for
Any
inspection.
eviction suit pending between you?
My lord,
My
There's
lord,
an
yes.
eviction, my lord, may I
My lord,
hand over?
after filing of the writ, they have filed one suit,
I don't know.
claiming that I am a trespasser after filing of this writ petition, my lord. And my lord,
Very well, very well. Very well. Learned counsel for the petitioner contends that the petitioner is a lessee, is a tenant in respect of the
Lessee, my lord.
lessee in respect of the premises in question. However, due to resistance of the private respondents, the new electricity connection sought by the petitioner could not be given by the CSC Limited.
No, inspection could not be done even.
Of course, let me pass my order.
Sorry.
Learned counsel for the CSC Limited submits that the CSC Limited could not hold an inspection due to resistance by the private respondents and as such, it could not be ascertained as to the feasibility of giving such connection. Next para, learned counsel for the private respondent submits that the petitioner has suppressed previous occasions when the petitioner's application for new electricity connection were refused by the CSC Limited on the ground of apprehended splitting of load as per regulation 14 of the 2013 regulations. Next para. The ground on which the private respondents seek to oppose the petitioner's application are not tenable. The very fact that the private respondents point out the petitioner's previous rejections shows that all might not be well between the petitioner and the private respondents who are tenants and landlords between each other. Next para. Since the CSC Limited could not hold an inspection till date, it would only be appropriate if the CSC holds an inspection and ascertains the feasibility. However, the said fact cannot deter the right of the petitioner to get an electricity connection at the premises, in view of the ground of splitting of load not being available to the CSC Limited, since the private respondents are patently not in favor of the petitioner getting the connection. Next para. Accordingly, WPA 15719 of 2023 is disposed of by directing the CSC Limited to hold an inspection within a week from date upon prior notice to the petitioner and the private respondents for the purpose of ascertaining the feasibility and the location for giving electricity connection to the petitioner. Thereafter, the CSC Limited shall raise and shall issue an offer letter to the petitioner indicating the proper estimates in that regard. It is made clear that the CSC Limited shall not refuse to give such connection on the ground of splitting of load in view of the above discussions. Next para. Upon the petitioner complying with formalities, the CSC Limited shall give such connection to the petitioner subject to the petitioner complying with all due formalities in law, preferably within 2 weeks from compliance of such formalities. Next para. On any of the occasions, either at the time of inspection or giving electricity connection to the petitioners, in the event the CSC Limited is obstructed by the private respondents and or their men and agents, it will be open to the CSC personnel to approach the local police station for adequate police assistance, which will be given by the officer in charge, stroke inspector in charge of the said police station at the cost of the petitioner in both instances, if necessary, removing any padlock or other hindrance in the process. No arrest to cause.
My lord, may I pray for two things, my lord. No equity, since a suit for eviction is well, let that be recorded.
It is made clear that nothing in this order or the electricity connection, as and when given, shall create any special right or equity in favor of the petitioner, which the petitioner does not otherwise have in law, and shall not prejudice the rights and contentions of the parties in the pending civil suit between them.
Grateful. I'm really grateful.
The new meter, let that be installed within their occupied portion.
That is not.
Other tenants as well, there are several tenants.
All of them will be taken from there.
I'm really grateful.
Thank you.
I'm grateful.
And I'm sorry for the interference.
No, sir.
Stand
No.
corrected.
My lord, I am for the petition in this matter, my lord.
Yes. What is the matter?
My lord, this is really unfortunate case, my lord, because the
petitioner is a small businessman. He number of tender work he has.
Just can you please take the microphone a bit closer to you? Yes. Small
Yes.
businessman, yes.
He has completed number of tender works under the Bidhannagar Municipal Corporation.
One second, yes.
Documents I handed over to show them, may I take those?
আগেরটা document ফেরত দিন। Yes.
I'm good.
Please continue with this. Yes. Small businessman start from there.
He completed all works and thereafter department has prepared the bill. My lord, here is the petitioner not prepared the bill. Department has prepared the bill, but for since long, no payment has been, some payment has been made. But thereafter I made a demand, but they did not pay. That's why I have come before your lordship. Your lordship directed on last order, by your lordship's order, that is 19 July 2023. Next page, plot.
You are appearing for the municipality, Mr.
Municipal Corporation.
Your lordship specifically.
Bidhannagar.
229.
Your lordship specifically directed the respondent number 7 and 8 should file a short report indicating the reasons for non-disbursal of the amount in favor of the petitioners.
Yes, Mr. Bandyopadhyay, what is
They have submitted a report, my lord,
My
after
lord, we have already submitted a report, my lord, it's in your lordship's records, my lord.
Right.
totally misleading report. There is no whisper at all of what is the reason.
I have not received any exception to this report as yet.
Why they have,
Paragraph 6 onwards will be the
they
relevant.
have not disclosed anything, why the money has not been disbursed, because your lordship.
Report when did you file?
19th July. 19th of September. my lord.
Out of time, lord. Your lordship specifically directed within certain time. He did not supply me thereafter.
19th of September, there is no order. I can't
My lord,
find it.
your lordship
I'll
was my lord, taking up the circuit bench. The matter was appearing before a
Justice Bharadwaj.
coordinate bench. Yes,
Hmm.
my lord. There, my lord, the
Justice Bharadwaj recorded on 13th of September.
Yes.
A direction was passed on such and such date. Let the report be filed within a week from date.
Yes.
we are filing
Thereafter,
in court. or
Not
department?
initially,
filed. No,
It has been filed within that week in the department, my lord. Since the matter was not being taken up, my lord. At a copy,
lord,
my lord, we
Never
have served
copy.
them also, my lord.
initially your lordship.
have you got an extra copy of that?
is
At a
marked
copy
it.
then also.
Copy to give them, sir.
What is your stand taken there in
Yes,
this?
my lord, my stand there is that, first of all, the details
Yes.
they have provided in the writ petition, that is actually at paragraph 21. And that is also a reproduction of the same chart in their demand justice also. My lord, those are not matching with the work orders which they have annexed. That is number one. Number two, my lord, in paragraph 7, we have taken the stance that one of the claims is of 2012. When this corporation was not born, it was this work was done under the Rajarhat Gopalpur municipality. Thereafter, my lord, two municipalities merged into this corporation. So that part, those parts are all time barred. That is the second part. Third is that the payments that they have received in the meantime, specifically that of 11th of November 22 and 2nd of February 23, that has been suppressed by the petitioner. And second. And the other, we have said that we are disputing because most of the claims are false and fabricated. My lord, your lordship will find that the reasons for non-disbursal we had to disclose, my lord. It is true that it is not individually, but my lord, individually also, my lord, we have worked it out.
Mr. Bandyopadhyay, she is arguing that you had raised the bill, your department had raised the bill. or something.
You already annexed.
My lord, will kindly see.
Kindly see page 57, my lord.
What about that?
That is,
Can you resign from that position?
we are certifying. That is,
Yes, you're executive engineer.
yes,
But
my lord.
this is not a raising of the
Tendered amount, thereafter, my lord, final bill amount, 8,69,000.
the
thereafter,
completion
bill-
certificate.
Here is a billing amount, they have stated, my lord. They have measurement.
But they
This
have
is a
also,
system.
you have also indicated the final bill amount there.
This
Yes,
is a system.
But my lord, there have been two payments made in November 2022 and December and January 2020, February 2023. My lord, your
Deducting
lordship,
those, Mr. Bandyopadhyay, you have to disburse the balance payment as per
my
the
lord, as far as
settlement.
my lord, page 57 is not a sole bill. Your
No, it's
lordship
not
will
a bill.
kindly take page 21.
Hmm.
What they have done, my lord, old, new, they have clubbed everything together and made a composite prayer in the writ petition. My lord, knowing fully well that 65,90,000, knowing fully well that this a money suit will be barred by limitation. So everything has been clubbed together, old, new, everything.
No, new, my lord. That
Mr.
is,
Bandyopadhyay, this regarding this 10,36,839 at page 57 final bill amount, you have admitted that in the completion certificate, but you have admitted that. How
Yes.
can you resign from that position?
Yes, well, I'm not resigning whether from the final bill amount. The question is whether this has been paid within that 65 or not.
That is my statement.
Acha, what is the amount you have indicated in your report? You have annexed the receipts or something like that.
Nothing.
No, my lord.
Nothing.
We have not. We have not.
Produce those documents.
Well, I have those documents.
Very well. I'll direct you to file a very short written affidavit in opposition annexing those payments.
Very well.
I'll indicate,
But
but yes.
in fact, my lord, I would have prayed for the opposition, my lord, because this paragraph 21 needs to be dealt with. Because this entire, my lord, this is, my lord, it is my submission, my lord, subject to, my lord, your lordship's consideration. They have clubbed everything only to avoid the point of limitation.
No, the time but things they cannot get.
But kindly take page 15, for example. Kindly take page 15, last entry. In just above para 22. So 2012.
No, the components which are time barred, you need not pay. I mean, you cannot, you ought not to pay. You are not bound to pay. But the other components, those remain.
Malad, this petition is.
But that goes beyond 10 lakh something.
Malad, this petition is Malad simpliciter money suit. Simpliciter money suit.
Regarding the admitted sum, Mr. Bandavata, I direct you to pay. And relegate her to a money suit for the rest.
Malad, let us come up with the opposition. Malad, kindly keeps my point open so that I can argue at the final stages. Since I am filing an opposition, Malad, kindly keeps my point open. Malad.
Very well.
Well, not a single bill, not I have already number of documents.
Please file another copy of the report also. I'll direct the department to tag also, but do you know the things, the way things go?
Well,
So please file.
I'm making prayer before also kindly look at the page 75 for a moment. Page
75?
Page 75, last annexure, madam.
No, but the
Because it is
claims
the-
do not tally. You have relied on this document completion certificate where they have indicated 10 lakh 36 and odd is due. But you are making a claim.
Number of documents I have annexed. Number
Similar documents?
Yes, they have certified. I am not at all disputing how they are claiming. I am demanding. I am not claiming. It is an admitted fact. It is admitted fact on the rules also. It is legitimate claim, Lord. I have worked. They prepared the bill. I made an payment. I made the prayer, and they will release my
Let them
bill.
file an opposition.
But in the meantime, my lord, kindly see that that's why I have tried to lodge your attention.
In the
That
meantime,
is
what?
the person concerned, that is, he has stated, my lord. Last paragraph, I am small contractor and work various small types of PWD, PSC.
I'll give
work
you
by
short
collective.
time, Mr.
Finance-
Bandavata. You will get up to 17th of November to file this. You will have to get up to 17th of November to file this opposition.
One thing,
Do that.
may I pray, my lord,
3 days after the reopen.
before puja, my lord, kindly direct them so that family can
Money,
survive.
money claim.
No, my lord, detail how the money.
Family
can
survived
sustain
to 2012 claims are also there. Family survived so long.
That is the separate.
No.
That is the security money.
Learned counsel for the petitioners has made out a prima facie
But my lord,
case
before
that
puja only.
in the completion certificates issued by the respondent authorities themselves, apparently several amounts of due to the petitioner were admitted to be final bills for the respective works done. Full stop, next para. However, learned counsel for the respondent authority, respondent numbers 2 to 11,
2 to 9.
2 to 9, sorry, 2 to 9 disputes the quanta of the said bills and submits that some of the amounts have already been paid. Full stop. That apart, it is argued that many of the claims made by the petitioner are also time barred. Full stop, next para. Since such arguable questions have been raised, the respondents shall file their affidavit in opposition within November 17, 2023. Reply, if any, shall be filed by November 24, 2023. And the matter shall be listed for hearing on November 28, 2023. Full stop. In the meantime, the department of this court shall tag the report filed by the respondent numbers 2 to 9 pursuant to the order of court with the main file.
And also, my lord, again, I am making appeal to your lordship so that the people can, so
Right.
that the person.
Money claim.
Well, report filed by respondent number 7 and 8. Report is by 7 and 8.
Lord, I am asking myself how it is.
Report যেটা বললাম না filed by respondent number 7 and 8 তাহলে করে দিন ওটা বাকিটা 2 and 2 2
Consider again, my lord.
Paid for.
Again, I am making
No,
appeal my prayer, my lord.
no.
He has not received any amount.
Yes,
Lord,
I
the
think
people.
No,
That is
no,
the
Mr.
necessity to die, my lord. That's why he made prayer before the lordship has.
Next.
Yeah. Again. Whether
দেখুন but
Number 15.
মাইকে রাখুন শোনা যাচ্ছে না।
Number 15.
15, I appear on behalf of the petitioner, my lord.
Your Lordship, before my learned friend begins, he has filed a supplementary affidavit. Your Lordship, we've been served with an incomplete supplementary affidavit.
My lord,
Your Lordship,
that
we
has been
have
taken out.
leadings are.
My lord, that has,
Yes, Your Lordship,
My lord, I have
we
made-
had known
What
nothing
is
about.
this?
My lord, I mentioned the matter. Thereafter, I put on notice. My lord, learned advocate on record has specifically mailed to each and every respondent. I have an affidavit of service to that effect, my lord.
Lordship, we
And
have
the
received-
supplementary affidavit is also enclosed in that particular.
They say incomplete copies.
Yes, your lordship, the pleadings have been served on us. The annexures are not there. Your lordship, he's annexed a lot of documents.
My lord, I've taken out the supplementary affidavit, my lord.
No, complete the service.
My lord, the service of the petition is concerned, my lord.
No, you have course have
My lord,
incomplete.
so far as the supplementary affidavit is concerned.
Supplement. You are not relying on that.
I won't rely on that, my lord.
Move the matter. Let me hear. Yes.
My lord, this matters pertains to two associations, my lord, rather not two association, a group of 125 people, my lord, Apartment Ownership Association Act. Now, what has happened? This is a property consisting of 125 villas.
125
villas.
Villas.
The property is in Rajarhat. The property was.
You are for the association.
Lordship, I appear on behalf of some of the villa owners.
I'm also. My lord, the association.
Yes.
Lordship, there are two maintainability points if my learned friend wants.
Well, so far as the.
Take the maintainability point first, then we'll argue on.
Lordship, firstly, this writ has become infructuous. This writ was challenging an election which has already been held on 10th of September, and my learned friend had tried his luck before another bench, before on 10th of September, on 6th of September, and the learned judge was of the view that there's no urgency, and therefore the matter was again returned. My lordship, secondly, so your lordship, today the election has happened, the office bearers have been appointed. My learned friend's writ has perhaps become infructuous. Second, your lordship, there is a separate forum provided under the West Bengal Apartment Ownership Act under section 16B, which provides for a competent authority where my learned friend can approach. So, lordship, alternative remedy is there is available to my learned friend, and that is my second point of maintainability.
I'm very grateful to my learned friend.
They've asked for a direction to that effect.
Lordship, for consideration of representation.
Under section 16B, my lord. That is my first prayer.
That I
A
cannot
and B at that.
Lordship, that I cannot oppose. If the wants this represent
A and B at that.
My lord,
in spite of Mr. Ghosh being there, A and B remain the same.
Let it be there. No.
I only joined one issue.
Oh, you're also Mr. Ghosh. I'm sorry. Yes. Yes, Mr. Chittapriya Ghosh. What is your?
What happened in this matter? There are two associations in a company in a particular lordship, the premise. Two
They have prayed for these matters to be considered by the competent authority.
I don't have any problem if it is sent to the competent authority for consideration. But the thing is that entire reputation is in between the private dispute.
And it
Those
was
two
a-
association.
My lord,
they are
since it is
fighting
my
to
petition, if
take
I'm
care of
allowed
the-
to kindly
of-
place my petition, my lord.
Election
forward.
has already been held.
Election is over, yes.
My lord, I'm not disputing that, my lord. My lord, not disputing. My lord, the only fact
is the provision of 16A. 16B, there is a provision.
16A is a penalty, provision for penal consequences, my lord. My lord, what has happened, my lord, there are not two associations, rather a company.
See, if I relegate it to the competent authority, I cannot enter it. Should not. Elections are already over, so you have got nothing to
My
say
lord,
about it.
present petitioners are the erstwhile president and the secretary of the association.
Right.
The association was formed in the year 2020.
You are no longer the president and secretary after the election.
My lord, for that purpose, so far as the election is concerned, my lord, kindly in that
challenge the election.
I have to challenge the election, my lord, because they are debarred from participating in the election. So far as the bylaws are concerned, my lord.
Where is your representation to the competent authority?
My lord, that is at page 183, my lord. That is the first representation. There are altogether 9 representations.
The last is at 324.
It starts from page 183, my lord.
Does 324, page 324 representation speak anything about the elections or going to be held or something?
After the declaration of
After the
election.
But before the election has been actually held. So I am saying possibly this has also lost its force. He has to apply afresh. So today,
let us see what is
yes,
the
let us kindly, my lord, peruse 324,
My lord,
you at the previous board.
I'm the previous board, my lord.
So 16B contemplates
My lord,
allegations regarding
that is the catch of the matter, my lord.
against the board, the manager of the board.
My lord, I am saying I approach the competent authority under section 16B, saying that I am not competent person, kindly appoint an administrator, because the other members of the villa members are not allowing to function, because there are two groups, my lord. Association under the 1972 Act.
You are the manager.
I am the president. The petition number 1 is the president as well as the manager of the association.
No, 16B does not contemplate anything of
My
that.
lord, may I place reliance on section?
Read out 16B. 16B 2 applies to your case. Yes, sir.
But if the association of apartment owners having right to be exercised by the manager of board of manager fails to perform its functions under the act, or the bylaws made thereunder, the competent authority may give it such direction as to the authority concerned fit. If the
They will remove you. You are asking for your own removal.
I am saying that I am not being allowed to run this show.
That is not here.
My lord, that has not
Competent
been.
authority cannot do anything about
My
that.
lord,
They can only
my
remove
lord,
you.
so far my
If you say remove me, they'll remove you.
My lord, let it
You
be.
have been removed. The
In
election has
that
been
event, my lord, in that
So your
event,
prayers have been answered.
my lord, in that event, an administrator has to be appointed, a valid election has to be held, my lord. My lord,
I'll
so far,
give anybody to challenge the elections
my lord,
in a
my lord,
properly
prior to that,
constituted challenge.
my lord, what I'm saying, my lord, there are 9 representations pending so far as 16B is concerned that have not been paid heed to. My lord, there are hearing which was initiated at the behest of the private respondents. They have challenged the formation, that the formation was based on some false certificate. There are court order also, to which effect the competent authority heard the matter, passed an order.
Manager or the board of managers cannot go to the competent authority, because the scope of the competent authority under 2 is to remove the board of managers if there is any incompetence on their part.
My lord,
if you say you are incompetent, why don't you leave your post?
My lord, even if I
Why
leave
did
my
you go
post,
before the
my lord, even if I leave my post today, what is happening? There is a parallel company under section 25, the companies that is existing. They are running the show from 2012. My lord, if your lordship be kind enough to, my lord,
Then you have to approach the civil court.
my lord, I have to approach the civil court. I'm not on that.
Approach the civil court.
My lord, there is no suit pending. My lord, whatever instructions I have taken, pleadings of that effect that the suit have been already entered infraction and the suit has been dismissed for default. Whatever instructions I have referred. My lord,
The suit has been dismissed for default. You don't have a cause of action here. Order 9 Rule 9
I'm only seeking a direction upon the competent authority to consider my section 16B, my lord. My lord, the voting which my lord, the election will kindly be for a minute, my lord. The election which has been held on September 10, 2023, the persons nominated therein are defaulters. They have not paid a single penny, and by virtue of the bylaws, they are not even allowed to participate in the election process. My lord, I cannot imagine of like they participating in the election and thereafter they are getting nominated. So far as the election is concerned, I have a right. I may exercise that before the civil court. But so far my application under section 16B are concerned, my lord, kindly the competent authority may
Let's come to one of your applications before under 16B. Let us come to the last.
Lord, that is at page 324, my lord. Lord, if I may allowed to place reminder number 9. This is further to the following trail mails of and our first application under section 16B of the 1972 Acts and reminders thereof. We the understand placed on record that our inactions on our applications dated 13/5/2021 resulted in an utter blatant and willful disobedience to an office order dated 18th of May 2023. My lord, this 18th of May, when the competent authority took a hearing, as said the association was formed in a correct manner, my lord. Issued in compliance to the Honorable High Court order dated 17th of April 2023 in connection with WPA such and such by some of the villa owners, namely such and such. These villa owners for their own gains did not hand over control of the common area and facility. My lord, how they grab the hold control of the common area and facility? They are the directors of the Section 8 company, which is operating since 2012. By virtue of an agreement executed on a piece of 10 rupees stamp paper, they have grabbed the common portion. My lord, that I also have relied on.
The allegations made here are not faults of the association.
My lord,
it's a fault of some of the owners as per your perception. Section 16B1 says if the association of apartment owners having right to be exercised by the manager or the board fails to perform its functions under this act, the competent authority may give to it such directions as that authority considers fit. And B says if the competent authority is of the opinion that function of the manager or board of manager is detrimental to the interest of the association of apartment, do you go and say, do you admit that yes, my action is detrimental to the interest of the association?
If I'm allowed to say this, my lord, I am having three.
You don't have any idea of section 16B. I'm sorry, I must say this.
My lord,
you don't have any inkling of idea about
lord,
what 16B is about.
My lord, I have 3 roles altogether. At the same point of time, I being a manager, I am also the villa owner.
I pass my order. This is a frivolous application. Learned counsel for the petitioner contends that as many as 9 representations were made by the petitioners to the competent authority under the West Bengal Apartment Ownership Act 1972. Full stop, however, although initially hearing was given by the competent authority, no steps have been taken thereunder. Full stop. The plinth of the arguments of the petitioner is apparently that due to the unlawful action of several of the villa owners, comma, the functioning of the association could not take place properly. Full stop. Next para, learned counsel appearing for the different sets of respondents argue that the matter has become infructuous, comma, not only because the election, comma, which was on the anvil at the relevant juncture has already been held, but also because a civil suit initiated by the petitioner has met with a dismissal for default. Full stop. Next para. It transpires from the nature of the allegations made in the representations made by the petitioner that those are beyond the purview of Section 16 capital B of the 1972 Act. Full stop. The meat of the allegations are against some of the villa owners, comma, which villas comprise of the housing complex in question. Full stop. Next para. Such unlawful acts, comma, if any, comma, are to be ventilated by the association itself, comma, if at all, comma, before a competent civil court and not before the competent authority. Full stop. Under Section 16 capital B within bracket 1 of the 1972 Act, comma, if the association itself has a right to be exercised by the manager or the board of managers and fails to perform its functions under the act or bylaws, comma, the competent authority may give to it such directions as the authority considers fit. Full stop. Under subsection 2 of the said section, comma, if the competent authority sub jagah CA capital is of the opinion that the functions of the manager or the board of managers is detrimental to the interest of the association of apartment owners or is against public interest, comma, the competent authority may give notice and remove the said board of managers or manager. Full stop. Next para. The present allegations sought to be leveled by the petitioners as the manager or board of managers cannot be against themselves or the association which was being run by them before the election. Full stop. If so, comma, the same would lead to an absurdity that the petitioners seek their own removal under Section 16 capital B of the Act. Full stop. Next para. However, comma, the allegations were against apartment owners, which has to be ventilated before the proper civil court. Full stop. In any event, comma, since the election has taken place, comma, the petitioners are no longer the manager or board of manager or portfolio holders of the association. Full stop. Thus, comma, if the petitioners seek to challenge the election or ventilate their grievances against particular villa owners, comma, the appropriate remedy before them is the civil court. Full stop. However, comma, it has to be taken note of that in the meantime, if any civil suit in that regard has been dismissed for default, comma, the petitioners would be required to take due course of law in accordance with Order 9 of the Code of Civil Procedure for getting the suit restored first before ventilating such grievances. Full stop. Next para. In any event, comma, in the light of the above observations, comma, it is for the petitioners to decide how they want to approach before the competent civil court. Full stop. However, comma, there is no scope of interference in the present writ petition as the allegations made do not fall within the contemplation of Section 16 capital B of the 1972 Act. Full stop. Accordingly, WPA 21590 of 2023 is disposed of with liberty to the petitioners to take appropriate recourse of law before the competent civil court.
My lord,
No rest.
my lord, in the initial portion of the order, your lordship was pleased to record that my application under Section 60B was considered, but had not been dealt with in a proper.
You said you were hard?
No, it was on a different footage altogether, on a different context altogether, not on that.
Not your application?
Not my application.
Whose application was
My lord, that has been taken out at their behest, saying that the formation of the association has not been
which
done.
was initially প্রথম প্যারাগ্রাফটা একটু পড়ো তো প্রথম প্যারাগ্রাফটা একদম প্রথম 72. Although initial hearing was taken, given comma পর্যন্ত কেটে দাও, although থেকে comma পর্যন্ত কেটে দাও. However, no steps have been taken. Deleted. Thank you.
Grateful.
Thank you. বইটা ফেরত হবে. বইটা ফেরত দিন.
Item number 16.
My lord, I appear for the petitioner.
Service?
Service, my lord, I have done, my lord, with regard to my lord upgradation, I have sent an email, but that has
You are for
not.
the contesting party?
I am for the state, lordship. State has nothing much to say here.
My lord,
Good service. You have checked up. Good service.
My lord.
Yes, what is the matter?
My lord, I have moved DRT with regard to my lord, DRT 2, my lord, with regard to my lord, my 13 position notice. Subsequently, thereafter, my lord, the DRT 2 is not sitting presently, my lord. And they have, my lord, started taking coercive measure by my lord, by passing an order, the CGM, to take physical possession of my property. I moved DRT in the year 2022. Paragraph 12, my lord, I have mentioned.
DRT Siliguri is the taking of these matters?
No, my lord. Presently, my lord, DRT 2, my lord, DRT Siliguri is not in charge, my lord.
Who is in charge?
My lord, no one is in charge, my lord. DRT 2 matters are, my lord, stagnant, my lord, before the DRT 2.
Are you sure Siliguri is not taking up?
My lord.
Can I record your submission on that?
My
That
lord,
is the only ground on which I'll grant you a limited order.
My lord, that is my submission, my lord.
You are
Your lordship can record. Your lordship can record my submission.
I'll grant a limited order.
Although there is a report, lordship, I'll file it.
What does it say?
It's
Section 14.
yes.
Learned counsel for the petitioner contends that despite availability of an alternative remedy by way of an application under Section 17 of the SABYASACHI Act, the concerned bench, that is the second bench of the Debts Recovery Tribunal, Kolkata, is not functioning for some time now. First stop, it is submitted by learned counsel for the petitioner, on query of court, that the Siliguri bench, which was previously in charge of bench number 2, is also not functioning and not taking up such matters at present. Full stop. Hence, the petitioners contend that there is no bench whatsoever at the present moment to take up the application of the petitioners under Section 17. Full stop. In view of such exigent circumstance, keeping in view the principle of ubi jus ibi remedium, the writ petition is entertained, subject to subsequent availability of the appropriate forum, full stop, in order to grant protection to the petitioner for a limited period, on an ad hoc basis, even without going into the prima facie strength of the petitioner's case, the respondents are restrained till November 30, 2023 or until further order, whichever is earlier, from taking any coercive steps against the petitioner under the SABYASACHI Act 2002. Full stop. Next para, the matters shall be listed under the heading upgraded matters on November 20, 2023. Full stop. The petitioner shall, in the meantime, communicate this order to the absentee respondents and all concerned, and such communication shall be acted upon without insisting upon prior production of a certified copy of this order.
Grateful.
Keep that on record.
Acha, the report filed by learned counsel for the state today be kept on record.
Great.
Item number 18.
18. 17 কি হলো?
Not this week, লেখা আছে।
30 কি আছে?
Not this week.
Not this week. Not this week was paid for by Mr. Satyajit Sinha. He was probably going to see a doctor.
Probably the matter has been upgraded on his request.
His request, and I said that he should have mentioned before. He was supposed to inform you.
We are not informed.
No, he said he was going to see a doctor. He was not feeling well. He came to court. Mr. Satyajit Sinha probably.
Anyway, my lord, I am for the respondent.
Not this week. It has been made not this. Please keep somebody on Monday. Or mention when Mr. Sinara is not there.
Of course,
Make it 50-50.
it is a matter of the tender, my lord. Bid has already been opened. So there is, so
Monday, if you have any difficulty, please just get it mentioned by.
I will see. Well, I'm for the company, my lord. I'm for the respondent number 1 union of India. That's it. Please speaking, I have. But
Anyway,
anyway,
thank
Item 18.
18 who is appearing.
My lord, 18, I am
Yes,
appearing in
Mr. Wal.
support of the writ petition. My lord, the grievance of the writ petitioner is
So,
against.
what about service?
My lord,
ready?
service, they appeared on Monday.
No,
Monday.
yes,
My lord, we are stuck.
Oh, you are.
My
Yes.
lord, the sole grievance is, my lord, the state electricity distribution company has entered into my land, erected electricity distribution system, installed a transformer. A writ petition was filed. Pending the writ petition, my lord, they have activated the system and now they are, my lord, using that way without any permission from me, my lord. They have done it, my lord. My lord, that's the only grievance.
Yes, Mr. Naik, what do you say?
My lord, this is 10 decimal panchayat land. No, we know everybody. One square plot, rectangular plot. Panchayat office is there. Public Engineering Health Department constructed, my lord, a small room for installation of a
The
pump.
land belongs to whom?
Panchayat. According to us, it is Panchayat. But he submitted later on one document without showing the, my lord, schedule of the property in which side he remains. Panchayat allowed us, Panchayat requested us to draw the to give connection to the, my lord, powerhouse so that everybody in the area to get connect to water, because that's a pumping water system is to be installed by the Public Health Engineering Department, and that has been done. Now, my lord, if it is found illegal, we have no objection, my lord, to get it shifted. But Panchayat has done it. It is the area of the Panchayat, 10 kata land. He claims he is the owner of 3.5 decimal, not kata, decimal, I'm sorry. My lord, his representation, it has page 29, lordship, for a moment, can you see? Here it says, my lord, this is to inform you that I, HON'BLE, son of such and such and such and such, district Hooghly, that I am the absolute owner in respect of a landed property lying and situated under moja number such and such, and measuring about 3.37 decimal out of total land 10 decimal. After purchasing the said plot of land, I converted the said land from Sali to Vastu. During few days, one PHE department, Public Health Engineering Department, lordship, installed one electric connection over they said landed property with the help of local panchayat authority without my consent. And several times I requested personally, and also written complaint filed against authority did not take any appropriate legal steps against the said PHE department for their illegal and unlawful work. I came to know from reliable sources that the PHE department applied for electric connection over the said landed property. I strongly objection.
Transformer is not mentioned here.
Not transformer.
My lord, at that point of time, my lord, the transfer was not installed. They were putting up the poles. Transformer was installed, my lord, later on, my lord, after the letter was addressed.
1st of October.
My lord, 1st of October only it was installed and thereafter commissioned, my lord.
What
My
do you
lord,
say
in
with
spite
the
of
Panchayat-
receiving this letter, my lord, they proceeded. My deed is at page 13 and my record of rights are also there, my lord.
What does the Panchayat say, Mr. Chatterjee?
Record of rights is at page 28.
You'll have to remove it then, Mr. Naik. He has annexed his record of right. He has annexed his
No,
deed.
we have said specifically, my lord, he could not place, my lord, his demarcated portion, 10 decimal land, where panchayat of this is my instruction, lordship.
Where did he get his land
Maybe-
demarcated? Where he got installed that in spite of this complaint?
I'm not
My lord,
giving
my
permission to
complaint was
anybody.
that,
My only
my lord, my
instruction I am
complaint was
placing-
there. He should have got it demarcated before erection. How could I demarcate for him?
We are saying
Someone I'll
specifically-
delegate it to the magistrate.
Panchayat has said,
Cannot
Lordship
as a-
will call for a report.
No, I'll direct the magistrate to appoint, take a report from the BLLRO if necessary upon.
The district magistrate.
District magistrate will decide this upon calling for a report from the BLLRO as regards the exact demarcation of your land.
Absolutely.
And that will be done. And I'll indicate something that if it has been installed on your land, their land, then Mr. Naik, you have to shift at your own.
we have no objection, but that at the instance of the panchayat. So panchayat will have to, my lord, bear all this because they made application. They will stand for this or let them file affidavit.
because financial expenditure involved. That cannot be again at our cost because
Panchayat is conspicuously silent beside you in the matter.
they will remain. Well, two branches of the
Clarified in the instruction. This is
because they are
appearing in
not
the-
denying. We have specifically said. He is also saying. Well, he is saying.
From the earlier two.
He,
Application I have
Well,
given.
counsel for the petitioner contends that the
it is
petitioner
admitted by them.
specifically objected to an electricity line being taken over the petitioner's land, comma, which was converted by the petitioner after acquiring the same from Sali to Bastu. Full stop. Next para. Subsequently, a transformer has been installed in the petitioner's property and the same has been activated despite pendency of the writ petition. Full stop. Next para. Learned counsel places reliance on the copies of the deed as well as the extracts of the records of rights annexed to the writ petition indicating the petitioner's ownership of the property. Full stop. Next para. Learned counsel for this WBSCDCL submits that the WBSCDCL does not have any objection to shift the property
kindly will not-
subject to the. You said that thrice, Mr. Mukherjee.
One thing I have said also. He failed.
Let me complete my sentence.
No,
After that,
that is, I have said also.
Learned
he
counsel
failed to
for the
demarcate.
WBSCDCL specifically submits that the WBSCDCL does not have any objection to shifting the transformer and the line subject to the petitioner ascertaining the exact demarcation of his portion of the property. Full stop. Next para. It is further argued by the WBSCDCL that the Panchayat concerned, comma, which is also a respondent here in comma, gave a go ahead to the WBSCDCL to have the electricity connection activated. Full stop. Next para. Learned counsel, heard learned counsel for the parties. Full stop. It transpires from the documents annexed to the writ petition that the petitioner had purchased a portion of the property in question, which is demarcated, comma, the boundaries being indicated in the deed itself. Full stop. The records of rights also indicate that the petitioner is in occupation of the same. Full stop. Next para. Hence, comma, the WBSCDCL acted dehoors the law in activating the electricity connection over the petitioner's property and installing a transformer without taking consent from the petitioner. Full stop. However, comma, since it is beyond the scope of the writ court to exactly demarcate the portion of the petitioner's property, comma, it would only be appropriate if final orders in that regard are passed by the district magistrate. Full stop. Accordingly, accordingly, WPA 23117 of 2023 is disposed of by directing the petitioner, by granting liberty to the petitioner to approach the concerned district magistrate having territorial jurisdiction in the area in question, comma, ventilating the grievances as raised in the present writ petition. Full stop. If such an approach is made, comma, the district magistrate shall give an appropriate hearing to all concerned, including the parties to the present writ petition, and call for a report from the BLLRO to demarcate the exact portion of the property owned by the petitioner. Full stop. Upon taking such report on record and giving an opportunity of hearing on the same to all the parties to the dispute, comma, the district magistrate shall decide the issue in accordance with law. Full stop. In the event it is found that the electricity connection and or the transformer have been installed stroke taken over the property of the petitioner, comma, the WBSCDCL shall be directed by the district magistrate to remove the same within a limited period at the cost of the WBSCDCL. Full stop. Next para. It is, comma, however, comma, made clear that this court has not entered into the merits of the subject matter of adjudication before the district magistrate as indicated above, and it will be open to the district magistrate to decide such issues upon calling for a report in the manner as indicated above. No address to cause charges.
Well, the exercise may be completed within such period, Lordship.
It is expected that the entire exercise shall be concluded within December 15, 2023. December 31, 2023.
Well, it's in the sense of Panchayat.
So what?
Well,
They'll approach the magistrate.
Well, since at the instance of Panchayat, we have done this. If it has to be shifted, so it's not.
Beyond our control, candidly submitting, these programs are concerned. A list for the take care.
Hey, ওনাকে রাখো।
3 times we have.
এটা ফেরত দিন।
But no information.
But can it, if you lordship be kind enough to observe one line, Lord, this will be liberty to consider the interest of the party, at whose instance you have done this. If we have of our own, we have done, we shall bear. Otherwise, Lord, obviously, the Pradhan will have
If
to.
interest is looked into, Mr. Naik, you will be in difficulty.
It's now a fight between the state government and the local government.
Yes, the local government.
No, we are not state government. Yeah, state electricity.
He is state government. Mr. Chatterjee is representing the state.
No, he is also under the ministry.
Get full.
We have all Pradhan.
Well, he is under the Ministry of Power. He can't say he's not a state government, Ministry of Power.
এখন তো ওডি হবে
Extremely grateful.
Thank you.
মানে 29 puja permission, tomorrow is the last date. মানে Mr.
Last date of what?
Submission of application.
Online.
29, I took up to which matter? আপনি একটা কাজ করবেন, তো 29টা না কালকে টপে দিয়ে দিতে বলবেন, টপে দিয়ে দেবেন একদম উপরে। টু বি মেনশনড এর পরেই থাকে। More at the top.
My lord,
Number 30 is also regarding the puja permission. Kindly
30?
item number 30, your lordship.
Same.
30, 29, 30. Any other puja matter? No.
my lord,
29?
my lord.
Puja?
No, not puja,
Please,
but
no.
Tender matter, my lord, it will go.
এই
57, upgradation.
29 না 30 দুটোই টপে দিয়ে দেবেন কালকে।
My lord, kindly allow my prayer 57, upgradation, upgradation, my lord.
Let me come back tomorrow. Tomorrow I'll consider.
From
No.
morning, Mr. Sabudi is insisting that it will be taken up today.
Only your application will be rejected. The others I'll consider.
Item number 21, 14 families with bated breath and with a prayer on their lips. Everything, your lordship.
Good English, but sorry. Next. What is it?
Original site matters, any mentioning?
Yes.
Listed matter item number 1. Anirban Roy Chaudhuri and others versus the state of West Bengal and others.
I appear for the state response.
Purvasha is still getting water, Mr. Bhattacharya, or all water has been taken by Purvanno?
Purbanno, in terms of your lordship's order, they are getting that 4 times. No, this is my affidavit of service.
All have been served?
Yes.
Yes. What is the matter?
Now, there is a development. There is a recent development, my lord, which we came to know after we moved your lordship on the 9th. Out of the the outer limit for number of board managers is 48.
This matter?
Yes, outer limit for the number of board managers is 48. We came to your lordship's court at a stage when there were 31 board managers and 17 were to be elected. Your lordship did not interfere with the election process and granted that CA to consider. That was in the month of June. Now, my lord, it appears that, my lord, a notice has been circulated by the president of Uni World City, this apartment owners, that, my lord, the president and, my lord, about 37 other board managers, they have demitted, they have put in their papers. They have resigned. So today,
you wanted that?
Well,
of course.
forced to resign. Forced to resign. There
Whatever
are videos. It's vandalism going on there. They were forced to resign.
They are doing.
But they have now.
They are doing
The flat owners. Certain group of
They
flat
means the flat owners, not Mr. Bhattacharya.
Including the petitioners. They are supporting.
Now,
Mr. Thakkar is also there in this matter.
Yes, my lord. I have been briefed this afternoon. my
You're for
lord.
the security guards.
No, my lord.
They have been beating up people mercilessly, Mr. Bhattacharya is saying.
Mr. Bhattacharya is saying that, my lord, those security guards, I understand, has been suspended. Those security guards have been suspended.
It
But
proves
what
my
we-
point.
But
that
what?
there was some event.
Yes. My lord, what Mr.
You are
Bhattacharya.
representing whom, Mr. Thakkar?
I represent respondent number 3, my lord. Brief study. I have just one volume of the.
You are the association.
My lord,
I am for the resigned board of managers and the president. 4 and 5.
So you are Mr. Thakkar proverbially hand in glove.
On the same board.
Glove
Same
in hand.
page.
Whichever, glove in hand. or
Same
hand-
page. my lord, same
My lord,
page.
your lordship, I saw that from the order of 9th that your lordship was pleased to fix this matter today.
Yes, yes.
My lord, if my learned, I can request my learned friend to wait for a day, and if your lordship's business permits to take up this matter tomorrow, then I can take complete instructions. My lord,
I suppose
what is the interim order if my
your
learned friend?
grievance is already
No,
mitigated.
the grievance.
The urgency does not ring.
No,
I'll take it
it's
up.
for his
They-
petition to say what is.
They have.
Somebody
Yes,
else's
Lord,
petition, the respondent says there's no urgency. It's strange.
So actually, he's being kind to the court. Yes, Mr. Bhattacharya, where is
The
the urgency?
Bhattacharya is more kind, my lord, I am sure.
And if he wants a day's accommodation, I do not say, but
No.
they refused service.
So where is
when
the
they-
urgency now? Because if
Milord,
they
the
have their
urgency
papers and
is, Milord, the entire housing complex, Milord, is in, Milord, complete doldrums. Because, Milord, there is apparently, Milord, in view of this resignation, forced, duress, whatever, they have resigned. So, the entire,
there
law-
is nobody
there is
to-
no board. There is no one to function. I was only suggesting this, Milord, your lordship, Milord, independent of anything, having regard to the, Milord, tenor of findings returned by the competent authority. Milord, I respectfully say, Milord, that may be decided, whatever. Milord, in the meantime, during the
competent authority has the power to appoint an administrator.
Milord, that is the competent authority's brief. I am not saying
No, for the
anything, but I am only suggesting your lordship may appoint any independent, Milord. I can even suggest, Milord,
Let that
an
be done by the competent authority.
ex-director general of police, Milord. I can, Milord, suggest his name.
I don't want to, Milord, the lordship will see to whom the resignation letter is addressed, please, once. Kindly see to whom the resignation
So he
letter
has
is
instructions,
addressed.
Milord, let me proceed.
Your lordship will see to whom the resignation letter is addressed, and that, my lord, answers everything. And now the suggestion which has come, my lord, ex-director general. My lord,
If you have put in your papers, Mr. Thakur, then
my lord, we were compelled to, and kindly see to
There's
whom it is addressed. Lordship-
yes, I
Yes,
appreciate
so that shows how we were compelled to put this in. That shows how we were compelled. I am
the-
just seeking a day's accommodation. I understand now, I was not there.
Milord, they were served on the 9th, they
Yes.
threw the papers.
No.
They just
No, no.
literally
No.
threw the
My lord,
papers.
so served on 9th by email.
Mr. Thakur, if you have put in your papers under whatever, under duress, under compulsion, under whatever situation. Now,
We are not inclined to resign.
you are not
Now,
inclined-
because it is now we are, 1 minute,
Milord,
1
the
minute.
law,
have already resigned, Mr.
No,
Thakur.
no, my lord, we have
I
not.
mean, what relief are you expecting? I mean, in this writ petition, what can be done by the court in your
Yes.
favor?
Now, my lord, I was compelled to give this resignation letter to a person who's not nowhere involved in this. If this was addressed to the competent authority, I would have understood. If it was addressed to the residents, I would have understood who have elected me. Kindly see the authority.
Say that this has no.
this circulated in their, Milord, in their official website.
Yes.
Very well, Mr.
Because those were the circumstances. Now,
Sir,
because the matter is because after this, and this is, my lord, before the letter is perhaps before the filing of this writ petition, a day or two prior, if I'm not mistaken. I don't know the filing date. What I have got is an unaffirmed copy. What I have is an unaffirmed copy.
Milord, kindly sees whatever I have handed over, I am giving it to Mr. Thakur. Perhaps he does not have this.
No, this
I'm
I do
sorry.
not have.
It was on the same day.
Yes.
Milord, it was on the 9th. It was
Both are
done.
on the 9th.
Now,
Writ petition affirmed
Milord,
9th.
on the October
Yes.
10th.
So now, my lord,
Milord,
before,
in
because
my
it is
case,
before a
Milord,
court of
there's
law,
some
my lord,
portal.
because it is before a court of
So, Mr. Thakur, as of today, you say that those are under compulsion.
Yes.
This is not a valid resignation.
This is
at
not
all.
a valid
So
resignation.
you're still there.
I am still there. My lord, whatever
The cause of action remains.
cause of action remains, kindly, my lord, only a day's accommodation, kindly take it up. A day's accommodation, my lord. 9th, they served by email. They served by email on
come back
9th. If
tomorrow.
I have refused, how do I have the papers?
What will happen by tomorrow?
Milord, the entire housing complex, no
fall down.
payment is being, Milord, they are not clearing garbage. They are not clearing anything, Milord. The dues are not being cleared. Bonus is not being paid before pujas, everything.
Tomorrow, my lord.
For a
One-
day's time, let him come back tomorrow. Let him come prepared.
Milord, in the meantime, Milord, I am expecting, Milord, at least this much. Milord, this limited, Milord, thing, Milord, the day-to-day activities which was being run by their internal house staff.
Day to day won't be fulfilled in the meantime.
Milord,
Because
yes, they are.
today is day and tomorrow is today.
Kindly visualize, kindly visualize. Milord, if there is no one to clear the garbage, Milord, from the stars, Milord, that has to be done. That has to be done.
Till tomorrow, tonight, just stay with the garbage, Mr. Bhattacharya.
No water stop.
One.
Garbage is being
No, my lord, whatever was being done, it's Mr. Bhattacharya can't have it both ways, that I have resigned, but I'll still do the work.
He says he has not resigned.
Correct. So
So
I
there
the
comes-
work will happen. It's
An
will happen.
adjournment at order an adjournment is sought by learned counsel having instruction to appear for the respondent number 3 association. Full stop. Accordingly, let the matter stand adjourned for the day and shall be listed tomorrow at the top of the list.
Milord, this portion of the order remains. In order to
Everything
hear the,
remains.
Milord,
Everything remains,
in the
only
event-
adjournment granted. Oh, adjournment granted for a day, Mr.
Very well.
What are you saying?
Only one thing. I don't know
Not the.
I'm not recording
the
anything
heated-
regarding this
The
resignation.
heat generated, my lord, shows, my lord, that the adjournment is also something which is, my lord, a pre-planned adjournment.
No,
My
it
lord,
shows that
pre-planned in the
even
sense,
an adjournment, innocuous adjournment is opposed to the hilt. That is what is shown.
my lord, because
At the instigation of learned
Because,
juniors.
my lord, who is seeking an adjournment before the court? My lord, persons who have been found to have, my lord, siphoned off public funds.
We'll decide that tomorrow.
But only one
Chalo.
thing, whether it should be in the original side or the appellate side.
Why do you say that?
First writ petition, the previous writ was in the appellate side.
The previous writ petition was in the appellate side. This is our competent authority's order. New secretariat building is his office.
You are challenging the competent authority order.
Yes. Yes, 7th September 22.
Respondents have to be there. You will be affected by the order. What has the competent authority done, by the way?
The competent authority, apropos your lordship's order, my lord, your lordship interdicted, directed.
Just tell me what was done.
My lord, the competent authority has come to categorical findings, which has been recorded.
What has been done? What is the order import?
The order impugned says that, my lord, 16B1 has to be, directions have to be given, and he has given directions instead of acting despite coming to find.
Number 1 take 16B2.
Basically,
Come back to work.
basically.
Come back.
He has appointed the president
Connected.
to do the job, but the president has resigned on 7th of October.
Who has
7th
appointed
October.
president?
We'll decide that.
Who has appointed?
কে কাকে appoint করলো?
Next matter.
বুঝতে পারছি।
Item number 2 for hearing, Madhumita Construction Private Limited and another versus Reserve Bank of India and others.
Yes.
একটা volume দিয়ে দিয়েছে, দুটো volume এর মাপ।
Yes, Mr. Pan.
I have got the petition in this matter. Quite of a direction last.
At last, yes.
No, my lord, this is again, my lord, kindly see the conduct.
What has
Your
been done?
lordship directed them to file their affidavit by 3rd. Day before yesterday, I was served with a notice, with this affidavit. Not only that, they never sought for any extension from your lordship. Moreover, with this letter, they have said that my counsel will not be there, so I will pray for adjournment.
That they can say.
No, my lord, kindly see. No, my lord, kindly see, my lord, your lordship's order.
When was it affirmed? Let me see that.
You know, they have 9th man. And I have served you next day, the very next day.
Affirmed 9, 6 days after.
9th. Yes,
6
9th.
days after.
Yes, because it was, I make it ready, but due to some reasons, it cannot be affirmed. And I have given him notice also.
Why is the State Bank of India? I mean, why is this the scenario? Because we have directed you so long back. After that, you failed on so many occasions.
Your
And now.
lordship's made it clear that
Third was the last date, Mr. Palchudri. Why should I accept this? You affirmed it on 9th, 6 days after a week after that. Why should I accept this?
I am seeking leave.
What is your case, Mr. Pan?
No,
Let
my
us
lord, lordship
decide the
can
matter.
see
Yes.
No, no, my-
NSP of, my lord, the fraud. State Bank of India initiated proceeding against me by way of filing a suit, followed by that fraud was reported to the RBI. Now RBI issued a caution notice without intimating me. Now, when I sought for the opening of an account in another bank, then I came to know about the existence of this caution notice. The moment I came to know, my lord, I approached this honorable court.
This is as per the fraud notification of the RBI.
Yes, there is a second time.
That circular regarding the
Yes,
fraud.
second time. My lord, in connection with the earlier one, suit is pending, criminal proceeding is pending. Now, in the second time, on the self-same issue, which is occurred in 1998.
No, Mr. Pan, these are two separate causes of action. I mean, cause of action may be the same, but these are two separate forums. Suit is on the fraud, maybe the amount.
Yes.
And this fraud circular is different. That is
that
to
is
notify
exactly.
to other people that you
Yes.
fall under the category
So
of fraud.
that for that caution notice is there. I approached before this honorable court. Caution notice says that not debarring me from either opening an account or carrying with the business. My lord, what I am on is this, my lord. Then I approached before this.
Let us see what you are challenging.
Yes. 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 Well, the CFR, the website that has been uploaded, but without giving an opportunity of hearing me, without represent myself.
Where is that?
Yes. My lordship, kindly turn to.
This is not willful defaulter circular.
No,
It is a fraud circular.
It was occurred in 1998. Now we have not reported, we have not done anything. It is Reserve Bank of India because he has given us against the.
No. I have my categorical case is.
Which page, Mr. Pan?
Yes. My categorical statement is this, my lord, at the instance of this. My lord, kindly see, my lord. Page 36.
What is the stage of the suit, Mr. Pan?
Suit, my lord,
The money suit, regular money
it's a
suit.
money suit.
What
It's
is
a
the
money
stage
suit.
of that?
My lord, the pending, my lord, examination is. Oh, the bank has not filed any affidavit of assets or the document. The discovery of document has not yet been completed.
Page 36 is the impugned thing.
Yes, no, my lord, this is the, my lord, kindly see. While assessing the, my lord, I sought for enhancement of my credit limit, loan limit. Now, my lord, in rejecting this, my lord, this was issued by the Punjab Bank. My lord, wherefrom I got that my name has been uploaded in the fraud registry. My lord, kindly see, my lord, while assessing the proposal and doing diligence, due diligence, it has been observed that fraud number such and such is showing in the central fraud registry portal against the Madhumita group reported by the State Bank of India.
You got a copy of the fraud circular?
No, my lord. My lord,
Yes,
That's
but
most
it's
relevant
annexed
here.
to- it's annexed to the-
my lord,
Annexed.
It's annexed, my lord, this.
কোথায়
That's
circular
page
কোথায়?
31.
No, that
Page?
is not the fraud circular.
That-
He is showing your lordship the caution notice.
No.
I don't have any access to the fraud circular.
That's on the website, Mr. Pan. In
Website.
every
That-
matter
that-
it's being cited.
that- my lord,
Ask your junior, he will get it for you.
my lord,
Fraud circular is
oh, my lord, that is, I have been instructed, my lord, that is only meant for the banks only. That is only meant for the banks.
every matter those are being cited by petitioners,
Oh, my
Mr.
lord.
Pan.
Okay, similar, I will
That's,
try my
that's
level.
on the RBI website. Why
Yes.
for the banks?
Now, only one thing
You
I
have a copy handy. That's the difficult.
my lord, only thing is this, my lord, I like to show your lordships one thing, whether this
Mr. Pan, please come prepared on the circular. RBI circular is the only thing to be looked into within the periphery of that, whether this can subsist. Because there are certain stipulations there, certain yardsticks.
that's that exactly. I want to like to show your lordships one clause of that circular. One clause of that circular, my lord. If your lordship kindly see, that has been quoted in the, my lord, in a judgment cited to your lordship, my lord. That
Yes, Mr. Dotto, you should be prepared with the circular every time, whatever matter you move. You have got so many orders or got adverse orders on the basis of this. You should carry the circular always. Fraud circular, willful defaulter circular. You must be having some. He actually has. I told you.
Because the next matter involves that. Lordship knows.
my lord,
This is the entire circular. Who gave this?
এই আমাকে একটা
এটা কে
কপি
দিল?
দে তো
এটা তুমি দিলে? My officer is giving this, Mr. Pan, and you are saying that this is not available. My officer handed this over to me.
Kindly have a look at them, my lord.
Now let's look into the which is the clause now.
Yes, yes. My lord, clause 8.9.6. Kindly have a look at the 8.9.6. What is the condition precedent?
তুমি তোমার এদিকে থাকা উচিত ছিল 8.9.6 yes.
That it may be noted that the overall time allowed for the entire exercise to be completed in 6 months from the date when the first member bank reported the account as RFA or fraud on the CRDC platform. Then lordship kindly turn to that paragraph 75. Paragraph 70 of the judgment that I have cited before. Paragraph
Give the
75.
citation for Mr. Palchudri.
Yes, my lord, that is, my lord, 2006, 2023, volume 6, SCC, page 1.
Para 70?
Para 75. Here, my lord, this has happened in the year 1998. Without giving me an opportunity of hearing us, without any notice to that, they reported to the RBI, and my lord, accordingly, a caution notice was issued. Now, this master circular has come in the 2016.
This is on a different footing.
No, my lord, it's the same footing. My lord, kindly
No,
appreciate.
8.9.6, it is said that within this time, adequate opportunity of hearing can be given to the borrower.
My lord,
Here, no opportunity was given to you.
Opportunity. No opportunity was
The
given to
RBI
me.
a party here.
Yes, my lord, I have served. That is my case. And when I challenged that caution notice, my lord, then this honorable court said No, that is not, that will not debar you. You can open, bank can allow you to open the accounts accordingly, accounts are opened in a different bank. Now on the my lord, they are doing this thing.
How do we know that it was not done within 6 months?
Because that circular came into 2016. And when I moved before this court, in 1998, in my lord,
1990, the circular was not there.
Yes, circular was not there. But I tell you, lordship, why?
After this circular came in force from July 1st, 2016.
Yes.
Amended subsequently. After
Subsequently.
2016, was there any report by you?
No, they are saying no. Just now they have said that.
Let them speak for themselves.
Yes.
Nothing, my lord. We have, it was done in the year.
Some other
1998.
bank might have done it.
Yes.
Let us
this
see
is-
that.
This is.
But kindly see, my lord, kindly see, my lord, kindly see the paragraph, page 36, one
That is
second.
Punjab National-
Yes,
that is
36.
Punjab National Bank.
The-
Not by, not.
Kindly page 63, my lord, once again, my lord, the 36, page 36. They have categorically said.
Reported by State Bank of
Yes. Reported by State Bank of India.
It was done in the year 1998, my lord. And that is also one of the challenge before the High Court, and that is also
what?
They challenge this circular with the High Court, my lord. And suit was pending in the suit. And also they filed it.
Who challenged the circular?
They, in the year 1990.
Master circular was challenged.
My lord, they challenge.
What circular was challenged?
The challenge that notification.
Huh?
That's that caution notice. Caution notice.
Caution notice. We have
Kindly see the caution notice page 29.
My lord, page 32, kindly come. Page 32.
Page 29, my lord.
Page 32, kindly have a look at the page 32. Your lordship has categorically put me on the first day question that whether that has been quashed.
And that is
I
all.
said, "Well, that was not required. That's
This
why
is your caution notice.
Yes,
Caution
not
advice.
my caution notice. It is Reserve Bank caution notice.
Page 29 is not your caution advice.
Yes, it was based on our reporting, not
That
it is
is
done by
on the
Reserve Bank.
advice of the State Bank of India.
And they challenged it in the page 32. That order is there, my lord. And that order was confirmed. Page 33.
So they are otherwise admitting the State Bank of India has never further reported to the RBI.
That aspect is closed in the year 1999, 98.
So
Where is the final order on that?
Yes.
Yes.
Where is the final order on that?
That is
Final order,
page 32, my lord.
Page, my lord,
Page 33, my lord.
33.
Page 33.
Page 33, confirming the interim order. That is in connection with the.
I know. Not thereafter, we have not reported anything.
So
Whatever Reserve Bank of India asks us something with the report, we have submitted that report. No further caution, no further advice, my lord. And this is
At order record code.
16.
The compass of the present challenge is short. Full stop, next para. The respondent stroke State Bank of India gave an adverse report against the petitioner, which led to a caution advice bearing caution advice number 339 dated December 8, 1998 being issued with regard to the petitioner. Full stop. The petitioner, apprehending prejudice, preferred a challenge by way of preferred a challenge before this court, giving rise to a particular writ petition. Full stop. However, the said writ petition was ultimately disposed of on August 18, 2005 by a coordinate bench, observing that by the impugned notification, the learned single judge did not find that the petitioner had got any basis for apprehension, and it would be open to the petitioner to carry on business in usual course in accordance with law, if so advised. Full stop, next para. Subsequently, when the petitioner sought to enter into a transaction with the
Punjab National Bank.
Punjab National Bank, which is not a party herein, it came to the notice of the petitioner comma, as communicated by the said bank, comma, that while assessing the petitioner's proposal, comma, it was found that fraud number SBI 9804-0001 is showing in the Central Fraud Registry, CFR capital, within bracket CFR, bracket closed, portal against the petitioner number 1, comma, reported by the State Bank of India. Full stop. The type of fraud shown is fake LCs. Full stop. Next para. It was further intimated that the fraud is open as on the date as per the CFR report. Full stop. Next para. Being aggrieved by the said declaration of the petitioner's account as fraud by the State Bank of India as recorded in the CFR portal, comma, the present writ petition has been preferred. Full stop. Next para. Learned counsel for the petitioner places reliance on the relevant provisions of the master directions on frauds hyphen classification and reporting by commercial banks and selected FI small s dated July 1, 2016, comma, updated as on July 3, 2017. Full stop. In clause 8.9.6 thereof, comma, it is stipulated that the overall time allowed for the entire exercise contemplated therein is to be completed in 6 months from the date when the first member bank reported the account as RFA or fraud on the CRILC platform. Full stop. Next para. The trigger for the classification of the petitioner's account as fraud in the present case is evidently the intimation by the State Bank of India in 1998. Full stop. Next para. The respondent stroke State Bank of India files its affidavit in opposition. Full stop. Learned counsel for the State Bank submits that the bank is no longer connected in any manner with the said classification. Full stop. Next para. It transpires upon hearing parties that the bank itself had initiated a civil suit for recovery of the sum pertaining to which the caution advice was issued. Full stop. Next para. Since the matter is sub judice before a civil court and the caution advice was given as far back as in the year 1998, comma, coupled with the fact that a coordinate bench of this court had categorically held that the same did not have the effect of preventing any banking transaction or other transaction of the petitioner, comma, the said caution advice could not be a trigger for the petitioner's account to be classified as a fraud account under the master directions of the RBI dated July 1, 2016, within bracket, updated on July 3, 2017, bracket closed, full stop. As such, comma, the said classification cannot stand the scrutiny of law, full stop. Hence, WPO 1436 of 2023 is allowed, comma, thereby setting aside the classification of the petitioner as petitioner's account as a fraud account under the master direction of 2016 within bracket updated on 2017 bracket closed, full stop. Hence, comma, the fraud number SBI 9804-0001 as shown in the Central Fraud Registry portal against the petitioner number 1 stands set aside and quashed. Full stop. The respondent authorities shall take appropriate consequential steps to give effect to the said order as indicated above. No orders to cause urgent certificate. Thank you. Mr. Pan, have you filed your reply? No.
No. I have no. And moreover, my lord, paragraph 3 has not been.
No, they are actually not taking a stand against you in that sense. Next.
Item number 3, Bishambar Saran versus Punjab National Bank and another.
Yes.
My lord, I appear for the respondent bank. My lord, Mr. Sen is not here today. My lord, he has not come to court because of his personal difficulty. My lord, tomorrow and the after tomorrow, he will not be here in Kolkata, my lord. If any day, my lord, next week.
He had not completed his arguments.
No, my lord. He's here to conclude.
Yes.
My lord, she says personal difficulty, he has not come. I really cannot object.
Hmm.
My only prayer is, my lord, because my lord, there was some urgency. We were
Obviously, yes.
my lord, next week, my lord, if Tuesday lordship keeps it at the top, my lord.
Very good. An adjournment is sought on the ground of learned senior counsel for the respondent bank.
Respondent
bank. Full stop. Next para. Accordingly, let the matter stand over till October 17, 2023, when it will be listed at when it will be placed at the top of the list.
I'm grateful, my lord.
I'm grateful to your lord.
Item number 4, Sri Sushil Kumar Bansali versus Reserve Bank.
Yes, Mr. Dutt.
For the petitioner, my lord,
Yes.
my lord, affidavit of service is actually not complete, but my learned friend is appearing. This is my application for extension of interim order. I'm appearing for the RBI.
What about the other respondents? Mr. Dutt.
Well, they have not appeared
Axis
in the
Bank.
beginning. My lord, if your lordship say, I can wait for further day. This is just extension of interim order, not, and they have complied that order also.
When did it expire?
Well, it's expiring on 19th of October.
It will expire on 19th.
19th October.
Let us come back on 16th, Monday.
Yes, well, I have not mentioned it. It my listed
What?
automatically.
Why Since the affidavit of service, no, since the service is not yet complete, comma, let the matter stand adjourned till October 16, 2020.
Well, I'm grateful. Thanks. Actually, I have not mentioned my.
Yes.
Item number 5.
My lord, I appear on behalf of the petitioner bank, my lord.
Yes, please.
Your lordship, this is an application basically praying for DM's action in disposing of my section 14 application. my
You're
lord.
for the state.
I'm appearing under instructions of the council for the state lordship, Mr. Devanshu Dinda.
My lord,
Have you stated anywhere no section 17 or no interim?
my lord, I have got instruction as 17 has been preferred, my lord, but no stay has been obtained by the.
When was it preferred?
My lord, that date I don't know, my lord, but
Can I record your submission?
yes, my lord, that thing, my lord, can record.
I'll direct it to be disposed of by November 30th. Let them have some time after the puja.
Certainly, my lord.
Learned counsel for the petitioner bank submits that the petitioner's application under section 14 of the Surface Act 2002 is pending beyond the statutory period of 60 days. Full stop. Next para. It is contended on instruction that although an application is pending at the behest of the borrower under section 17 of the said act, comma, no interim order has been passed in connection with the same. Full stop. Next para. In such view of the matter, comma, there cannot be any fetter for the district magistrate to take appropriate action on the application of the bank. What's up accordingly? WPO 1622 of 2023 is disposed of by directing respondent number 2, comma, the district magistrate Purva Bardhaman to dispose of the application of the petitioner bank under section 14 of the Surface Act 2002 at the earliest, comma, positively within November 30, 2023. No address to cause urgency.
My lord, one indulgence, my lord, if kindly records, the compliance may be done in terms of the statutory duties and my lord, the law laid down by your lordship in Krishna Builders, my lord.
We cannot apprehend anything. You said convince the district magistrate.
And
to
my lord, my affidavit.
Instructions that there was a previous DM, the new DM has come in, and if lordship passes the time bound on to.
Very good. Thank you. Thank you. Very
And my lord, my affidavit of service may be kept.
Affidavit of service file today be kept on record. What is your name, please?
Shomojit Mojumdar, your lordship.
Item number 6, Indian Oil Corporation Limited and another versus Union of India and others.
You're for the petitioner in this.
Yes, your
Yes.
lordship. May it please your lordship, but I'm appearing for the respondent. Your lordships, again, I'm led by Mr. Shomu Mojumdar, but if I may please start.
Absolutely, sir.
Lordships, if your lordships recall on the previous occasion when the matter was taken up, just doing a recap, my lord. We are challenging an order of 1st of September passed by the Facilitation Council, wherein our objection as to the jurisdiction of the council to entertain the reference under section 18 was dismissed. And the council directed to say that the
please take the microphone a bit up.
I'm sorry.
Yes, yes, thank you.
And the Thereafter, the
Why
appeal
no
order-
jurisdiction? What was the ground for?
So the ground we had taken before the council that it was a works contract, and,
Oh, right.
and that therefore the MSME Act does not apply to works contract. Your lordships have already taken a view in that matter that MSME Act applies to the works contract. We'd also informed your lordship that the matter is now pending before the division bench, and as per the orders, the division bench has been pleased to observe that the matter ought not to be proceeded by the council until a decision has been reached. Certain documents were additionally supplied to the honorable division bench. We just wanted to bring those to your
So
lordship.
it's sub judice. Is there any order of stay in
There
there?
is no direct order of stay, your lordship, but the bench has noticed that because the matter had not proceeded for a year almost, that the status quo should be maintained. Ideally.
Before the council?
Before the council.
Well,
Right, your lordships.
That's not factually correct. There are subsequent orders in the matter. It is now settled with a direction to go back before the council. I'm sorry, my lord. He did not know.
it's all right. Subsequently, what happened?
There are orders now. There's no stay at all. The matter has been sent back to, my lord, the council, and the matter is in the verge of being settled by the council, my lord. It is being sent. I have all the orders.
Settle means the conciliation is going on.
Conciliation is going on.
So what is this challenge?
And the issue is not entered into, that's recorded. I'll make my submissions. I have all the records.
So this is a challenge on the same ground, works contract.
Yes, your lordships. So, your lordships, it appears that it's been recorded that the legal issue which has been raised is kept open and will be decided in this appeal if the need arises. And in case the issue of regarding jurisdiction, the council shall not be canvassed or decided. So
There's no
your
stay,
lordships,
there's no stay.
there is no
The difficulty is you are Mr. Mukherjee.
Yes, your lordships.
Mr. Mukherjee, the difficulty is as of today, I am bound by my own order because it's a
Understood.
coordinate bench. I am my coordinate bench.
I understand that.
Unless I refer it to a special bench, which I don't intend.
No, your lordships, I won't go
No,
that far.
unless you convince me,
No,
definitely.
you're-
You can
you're-
convince me. I may hold that is par incurem.
Yeah.
I mean, I have done that in my case. But unless you do that, otherwise that is binding on me.
Your lordships, I completely understand.
So why do you take the risk? I mean, come
Yeah.
back sometime after.
No, your lordships.
Get a
the
favorable
second
order
ground-
before this division bench.
The second ground that we have taken in the writ petition is on the basis of doctrine of election. Because we say that the respondent number 4 proceeded on the basis of the arbitration clause in the contract.
Section 9.
Section 9. It lost. Through a correspondence, it was revealed that they always wanted to go by the conciliation and the settlement procedure under the arbitration clause. And after having lost the Section 9, we sent a notice under Section 21 of the Arbitration and Conciliation Act, by which we commenced arbitration proceedings. And thereafter, they replied a month later
They
saying that
obtained the Section 9 order.
they did not obtain, they lost the Section 9.
I mean, they moved the Section.
Yes, they moved the Section 9. They moved the Section 9.
Arbitration commenced.
We have served them with a notice of
So Section
commencement of
21 is
proceedings.
satisfied.
Section 21 is satisfied, your lordships. And after satisfying that, 1 month later, they say that we no longer will go for arbitration because we have now filed a claim before the MSME Council. Your lordships, there is a decision of the Supreme Court which says that the MSME Act overrides the provisions of the Arbitration Act. But your lordship, that case does not decide this issue of election. It does not say that the
Overrides the Arbitration Act. The scope is, I mean, it's very ambiguous. I mean,
yes, your lordship.
once it reaches the stage of arbitration before the MSME Council, then the MSME Act itself says 96 Act applies. So overrides
lordships
up
have
to a
already-
particular point.
Your lordships have already taken a view that this overriding provision takes place the moment there is any conflict. And that
Right.
and that
Override, how can
Exactly.
it be overridden unless there is a conflict?
absolutely, lordships. In fact, the decision of the Supreme Court notes that there is a choice.
No, after resorting to Section 9 and after you went to the arbitrator, they are wanting to go back to the conciliation stage.
We had not gone to that. Your lordships,
You
please
gave a
don't
notice.
Place the documents, your lordships.
Give a notice.
Yes, your lordships. We just gave a notice under Section 21.
So you invoke the arbitration clause.
We invoked the
After that,
arbitration
they are
clause.
trying to go back to the
MSME Act.
to the conciliation stage.
Yes.
before the MSME.
Yes. Your lordships, if I may please place the order under Section 9, your lordships. That will be at page 58 of the petition.
Have you annexed the Section 9 application also?
We have not, but your lordships, I have a copy. I'll hand it up to your lordships and I'll show.
Get it photocopied in the meantime.
Yes.
To your clerks. Page 68.
Page 58, your lordships.
I'm sorry, 58. Yes.
Your lordships will see an application under Section 9. Kindly see who's the petitioner, Agnipar, which is the respondent number 4 herein. Para 6, this is an application as preferred by the petitioner under Section 9 with the following release. Kindly turn the page over, my lord. Your lordships will notice the prayers. The first one is for an injunction against the invocation of bank guarantee. And clause number 2 is to direct the respondents to release a pending payment of petitioner, which is of an amount of rupees 9,48,317 along with interest. This is their substantive prayer even in the before the conciliation and is also the amount due. Your Lordships, they've taken an attitude that makes us believe, and they cannot resile herefrom, that they want to proceed under the Arbitration and Conciliation Act. And not just that, I go a step further and I say that in their petition, they relied on the arbitration clause in the agreement. Your Lordships, I do not have a copy of...
No, Mr. Mukherjee, there's a tricky point here. I'm telling you that. You have to overcome that. Section 9 starts from prior to the arbitration proceeding.
Absolutely.
Even prior to section 21. And it ends after the award is passed and it is enforced. Now, therefore, the period when it can be, the time when it can be filed extends to much behind the arbitration commencement. Why can't they say that this section 9 can be invoked even keeping in view the MSME provision of arbitration?
Your Lordships, because the MSME Act
will be preceded. Ultimately, it will be arbitrated.
I appreciate
but prior to that, there is a conciliation.
I appreciate the contention.
So they may very well say that section 9 was keeping in view either way I had to go to arbitration if conciliation.
Lordships.
So then they can have that defense. Why can't they?
I take your point, Your Lordships. The thing is, section 18 of the MSME Act is a stepwise process.
Yes.
And it starts with a non-obstant clause.
Yes, yes.
Under the conciliation, only specific provisions of the Arbitration and Conciliation Act have been made applicable, where section 9 is not there. At the stage of conciliation, not at the stage of arbitration.
Yes.
So this omission, Your Lordships, in my respectful submission, means you cannot have recourse under section 9 at the stage of before, during, or after conciliation. After conciliation, Your Lordships, if I may please place before Your Lordships the MSME.
Let's see that section once,
yes,
the language of that.
Does Your Lordships have a copy?
Yes, yes, I do.
Lordships, kindly comes to section 18.
18, yes.
Reference to Micro and Small Enterprises Facilitation Council 1. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, Your Lordships, I'm emphasizing on may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Facilitation Council. Clause 2. On a receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of an institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation. And the provisions of section 65 to 81 of the Arbitration and Conciliation Act shall apply to such a dispute as if the conciliation was initiated under part 3 of the Act. Your Lordships will note it consciously omits the applicability of section 9. And Your Lordships have also taken a view that the provisions of the Arbitration Act with respect to arbitration only comes into play at the stage of 18.4. Sorry, Your Lordships, 18.3. For completeness, may I please read out subsection 3. Yes. Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of the Arbitration and Conciliation Act 1996 shall then apply to the disputes as if the arbitration was in pursuance of an arbitration clause referred to in subsection 1 of section 7 of that act. Your Lordships, may I please reread this particular provision? The provisions of the Arbitration and Conciliation Act shall then apply to the disputes as if the arbitration was in pursuance of the arbitration agreement. There is no question of application of these provisions at the stage of conciliation. They could not have gone under section 9. But the maintainability of section 9 is not under issue here. Their election to go under the arbitration clause in the contract is what is an issue here, Your Lordships. And that is for, in my respectful submission, they cannot blow hot and cold at the same time. They cannot rely on the arbitration clause when it suits them and resile therefrom and then go under the MSME Act. Your Lordships, under the election, under the rule of doctrine of election, there needs to be two remedies. These remedies need to be inconsistent with each other, and the person needs to make a choice between these two. There were two remedies. Your Lordships, in the petition, I do not have a copy, Your Lordships, but I will make submission, so I'll hand this up. Yes. So they could have gone to a civil court, they could have gone to the arbitration, they could have gone to the MSME Act. They made a choice to proceed with the arbitration clause in the contract, filed a section 9 on the strength of that clause. We exchanged affidavits. We were prejudiced to that extent. And then they later say, because we could not win there, even though we filed a claim that under Section 9, we ought to be given these reliefs. Now they're going under the MSME Act. Your Lordships, kindly turns to page 86. This is the last page of the order of the trial court, Your Lordships, under Section 9 of the Arbitration and Conciliation Act.
86.
86, Your
They are
Lordships.
Agni and you are petroleum. IOC.
I'm IOC, Your Lordships.
Dangerous combination. Yes.
Para 18, both parties are directed to take necessary steps for appointment of the learned arbitrator as per the relevant provisions of law for proper adjudication of the present dispute at the earliest. There was a direction upon the parties to take necessary steps to appoint arbitrator. Your Lordships, the law, as I understand it, is that they were supposed to, because they had filed the Section 9, they were supposed to take steps to appoint arbitrator. They did not. Therefore, we sent them a notice on 21st of November.
What is this a part of? I mean, page 86 is a part of what?
Is part of the order of the trial court under Section 9. The application under Section 9 that was filed by R4. Their application was dismissed, Your Lordships.
Already.
Yes. Your Lordships will also kindly just glance through para number 17 on the previous page. The present application as filed by the petitioner under Section 9 of the Arbitration and Conciliation Act is hereby dismissed on contest. Your Lordships, may I just kindly hand up this petition under Section 9, Your Lordships. I just want to show some important things that they had made.
But I'll keep it on record. Is it your only copy? Then
I'm afraid it is, Your Lordships.
that's why I requested you to have it photocopied in the meantime through your clerk.
Right.
You can read out the relevant portion if you
Right,
want.
Your Lordships, I just want to indicate literally three things. Number one, that in the cause title, it affirms that this particular matter has been filed under the arbitration agreement dated
No, I
30th
require a
August.
copy of that.
Yes, Your Lordship.
In the meantime, just argue, yes.
Yes.
In the cause title, it has been stated that
that this application is being filed in the matter of an arbitration agreement dated 30th of August 2008.
Otherwise, Section 9 is not maintainable.
Absolutely, Your Lordships. Because they cannot really go under the MSME Act and say, I can go under Section 9 at the stage of conciliation also.
All right. Yes.
Then, Your Lordships, at para 8 and 9, they rely on the arbitration clause in that particular contract and say that your petitioner submits that the terms of the general purchase conditions forming part of the tender documents are binding on the parties, wherein parties have chosen an alternate dispute resolution forum for the adjudication of disputes as and when they arise, and then it reproduces the.
So you say under Section 18, arbitration is only secondary.
Yes.
Once conciliation fails.
Absolutely.
Before conciliation fails,
There is no
arbitration does
application.
not exist. So if you rely on that arbitration clause and invoke Section 9, then you are relying on, you are going straight, jumping the step and going to the arbitration.
Precisely.
So you cannot resolve from that.
The
This is your entire argument.
The overriding effect that is conferred under Section 24
Yes.
does not override the choice that is there with the parties, Your Lordship.
The doctrine of election is there, as you said.
And Your Lordships, the doctrine of election, I do not wish to multiply cases at this point, but this being a doctrine of equity, Your
Choose
Lordships.
any of those judgments, which is your most favorite judgment side.
Your Lordships,
Since
there's
you are
a-
ready with so many judgments, at least
Your Lordships, I do not wish to multiply these judgments, Your Lordships.
don't multiply, but
Your Lordships, there's a
give one or two. I mean,
there's a
if you have
decision in
done the
Charles
research
Ford,
work and all.
2008.
Doctrine of election, any one of the best judgments.
Yes, Your Lordships. This is the decision of
And
2008.
give me the paragraphs also.
Yes, Your Lordships. Yes, 2008 one. $2006 60. Lordships. Lordships, I'm sorry, I'll be citing 2006 volume 2 SCC 641. This was a provision under the Motor Vehicles Act. And section 176 thereunder. May I take your Lordships directly to paragraph 22 at page 648. Or rather, your Lordships, paragraph 23 first. The doctrine of election is a branch of rule of estoppel, in terms whereof a person may be precluded by his actions or conduct or silence, when it is his duty to speak, from asserting a right which he otherwise would have had. The doctrine of election postulates that when two remedies are available for the same relief, the aggrieved party has the option to elect either of them, but not both. Although there are certain exceptions to the same rule, but the same has no application to the instant case. Then your lordships will kindly have paragraph 25, the second quote, the second subpara to that. Election is the obligation imposed upon a party by courts of equity to choose between two inconsistent or alternative rights or claims in cases where there is a clear intention of the person from whom he derives one that he should not enjoy both. My respectful submission is, once he's acted, he does not need to obtain an award from an arbitrator for the doctrine of election to be applicable. The moment he makes his intention manifest that he wants to proceed under the arbitration clause, he's bound by it. He cannot blow hot and cold. Thereafter, your lordships, para 27. The first respondent, having chosen the forum under the 1923 Act for the purpose of obtaining compensation against his employer, cannot now fall back upon the provisions of the 1988 Act. Therefore, inasmuch as the procedure laid down on both the acts are different, save and except those which are covered by section 143 thereof. Your lordship, this is a question of statutory interpretation. That's why I was going to place section 20, para 22, which reproduces what section 167 is. Your lordships, that is all I wanted to cite. I was told by my learned friend mentioned the other day he would like to cite a few judgments of the Delhi and Gujarat High Court. If I could please have an opportunity to deal with them.
Kevin, yes.
Just for completeness, your lordships, if I may please place section 21 of the Arbitration and Conciliation Act.
Section 21.
Section 21.
Notice.
Yes, your lordships, that's all I wanted to say. It's very clear.
You gave the notice in this case.
I gave the notice. The arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. And that is our letter dated 21st of November, 2022.
21st of November, 2022. And the section 9 order date is?
10th of February, 2022.
You grabbed the opportunity. No, you did not grab actually. You waited for 9 months. 9 months. Yes, Mr. Park, what is it?
May it please your lordship. My lord, may I hand over a compilation which we have prepared? My lord, this is only judgments, skeleton notes of the arguments which I'm about to make. It's essentially a roadmap of submissions which I'll make.
It is a roadmap. What would the road
the
look
judgments.
like?
It's a highway. That's the reason, my lord, of the volume. I'll hand over a copy to my learned friend.
Yes. What are
only
the
a roadmap? 2 points taken by my learned friend. If your lordships, my lord, take up page 3, that's, my lord, the start of the skeleton arguments. My lord, it has been challenged on 2 fronts. My lord, first,
this is a skeleton.
My lord, the skeleton runs into, my lord, the first 10 pages. My lord, the rest of it is, my lord, only the judgments. I'll only take not more than 10 minutes, my lord.
Yes.
2 points taken up by my learned friend. First, my lord, that the contract between the parties is a works contract. And the second is the doctrine of election, which has been, my lord, submitted. Now, it's a contention by my learned friend that the section 21 notice has been issued by my learned friend's client. I will show that indicates that it's not a doctrine of election at all. That could have been argued if we would have initiated the arbitration under section 21.
The doctrine of election, you preferred section 9.
Section 9, that's my point, my lord. Section 9 is not the point of invocation of an arbitration proceeding. It has to be under section 21. Had I given the notice under section 21, yes, I would not be making this submission before your lordship today. But before that, my lord, may I quickly touch upon, my lord, the point of works contract. That's the first proposition, whether the contract between the parties is a works contract. If your lordship kindly takes up the skeleton notes, my lord, page 4,
yes.
paragraph 2. My lord, here the agreement has 2 distinct elements. One is the supply element, and the second element is, my lord, the provision of services. We have indicated, my lord, page 37 and page 14 of the writ petition before your lordship. Lord, this has the contract and the purchase order. A perusal of the purchase order would show, my lord, that the provision of service and the supply element are duly segregated. They're segregated. In fact, the amounts claimed are also separate. We have indicated the page numbers. The supply part is page 47 and the site work part is page 48 of the writ petition. Now, I do not really need to go there and take my case to that extent because, my lord, in your lordship's order, your lordship had held in the previous judgment on the premise that the contract between the parties being a works contract. And then your lordship has held that the artificial distinction which is sought to be created for taking the matter out of the ambit of MSME Council.
Mr. Bag, is
wrong.
there any other order of our court?
Yes, my lord.
On
Yes.
this?
My lord, there is an order of Punjab Haryana High Court
No,
which
our
has
court,
followed
our
your
court.
lordship's order, my lord.
No, any other order of our court on this?
My lord, I have really not gone into because, my lord, cone elevators and the subsequent judgments have all been considered by your lordship in your lordship's order.
As a very.
My lord, here two other points have been taken
Hmm.
in the writ petition, which is my learned friend has not made any submission there to, but I've thought it, my lord, prudent to deal with those points.
Hmm.
My lord, in the writ petition, it is, my lord, stated and pleaded that one office memorandum was not considered by your lordship while passing the judgment. My lord, the office memorandum is at page 175. Then, my lord, at page 181, my lord, may I only refer to that page once, page 181 of the writ petition. This is volume 2, my lord. This is a office memorandum. A part thereof, question number 32. Are works contract part of services? What is the difference between works and services? It says works contract are not covered under the purview of public procurement policy for MSEs. Definition available here. That's the first. And the second, my lord, is the MSME document at page 185. Two additional documents which they are relying on, trying to distinguish, my lord, your lordship's judgment. This document at page 185 is a document dated 4th January 2023. Paragraph 3 of this document is what they are seeking to place reliance on. Based on economic activities taken from NIC Code 2008, so far as Udyam registration is concerned, for every activity in the drop-down menu of the portal, Udyam registration can be done. There is no activity named works contract in the code. Some activities in the portal are the major activity manufacturing, while others come under services. An enterprise might be performing purely manufacturing services or a combination of both. Our case here is, my lord, we have both been providing supply elements and services, which are charged separately. Can't be a works contract. So whether, my lord, at this stage, before at the pre-inception of the conciliation and arbitration in the MSME proceeding, this can be gone into as to interpret the contract, whether it's a works contract. There, my lord, I am fortified, my submissions would be fortified by the judgment of Punjab Haryana, which says clearly that at the very threshold, you can't decide it. It has to go into MSME. You can't decide the nature of the works contract, which is following your lordship's judgment. I'll place reliance on that. You know, the major activity of manufacturing and provision of services I have indicated. Now, kindly allow me to place reliance on your lordship's judgment, which, my lord, starts from page 11 of the compilation. Page 11, my lord.
Yes.
The relevant paragraphs are paragraphs 62 and 63, which are at page 21. Lord, we'll find the pagination at the top right-hand corner.
Yes.
62 and 63. Thus, the artificial distinction about works contract being excluded from the ambit of the said Act does not find place within the scheme of MSME Act itself. The said concept was borrowed from revenue jurisprudence, which has no nexus with the benefits sought to be conferred under the MSME Act. Importing the said concept in the instant context is beside the point and not apt. In view of the above discussions, this court is of the opinion that the council had correctly assumed jurisdiction under section 18 of the MSME Act to resolve the dispute between the parties thereto. Such exercise was well within the authority of the council as sanctioned by the statutes. My lord, this decision was followed before I, my lord, refer to the Punjab Haryana, my lord, the division bench, where, my lord, the appeal was carried by my learned friend's client. Page 23 is the first order passed by the division bench. The relevant portion is at page 25. My lord, fifth line from top.
Yes.
Page 25. Apart from examining as to whether the learned single bench was right in distinguishing the various decisions which were relied on by the appellant, the effect of the office memorandum dated 27/1/22 read along with the clarification of 6 June and 4 January 2023 has to be examined. It has to be seen that the office memorandum and clarification were not placed before the learned single bench when the writ petition was heard.
These are the two other
documents, my lord. In the light of the fact that kindly note why the stay was granted at the first instance. In the light of the fact that more than a year, the proceedings before the council did not proceed further, we direct that such status quo shall continue. That is in the sense that the council shall not proceed with the adjudication till the next date of hearing. And the next date was fixed. But over the page, my lord, this is a repetition. Kindly take up page 29. That's not very relevant. One line order, my lord, for further hearing. Page 31. 6 September 2023. Page 31, my lord. At page 32, kindly allow me to read from paragraph 2, my lord. Quickly, because, my lord, this is the relevant portion. Agreed by such order, present appeal has been filed in which we had granted an interim order. Of course, on the said day, the third respondent was not heard. Be that as it may, third respondent obviously would be interested in securing the amount payable to him rather than canvassing a case on a legal issue with regard to the jurisdiction of the council to decide the matter. Therefore, we are of the view that a conciliatory approach is required in the matter, and we opined that MSME council is the best body which can examine the merits of the claim, keeping the legal issue open, which will be decided by this court in this appeal in the event the council is unable to bring the parties to a consensus on the merits of the claim. Therefore, we are of the view that the matter should be remanded back to the council for a conciliation on merits, keeping the legal issue canvassed by the appellant in this appeal open to be decided in appeal. Accordingly, the matter stands remitted back to the council, and the council shall, without reference to any other orders passed earlier, nor any observation made touching upon the jurisdiction by the learned single bench, nor any observation made by us in the interim order, shall direct the parties, namely the appellant and the third respondent herein, to appear before the council for a limited purpose of conciliation, in which parties shall be directed to make the submissions on the merits of the claim made by the third person against HPCL. The report of such conciliation be placed. But this next date is, my lord, page 37. 4th October 2023. I'm only, my lord, referring to page 38, the last two lines. In fact, my lord, the first paragraph is relevant. It is heartening to note that from the averment set out in paragraph 15 of the report, that the parties are seeking or trying to seek a conciliatory approach to settle the matter amicably. So, my lord, that's how it is proceeding. And the last two lines of the page, my lord, list the matter on 18th October for orders.
This is the other matter, that matter.
The other, my lord, the matter in appeal. My lord, there's no stay order. Legal issue
Adjudication.
decided by your lordship, not adjudicated upon.
No adjudication.
And, my lord, that is where it stands as on date.
But if the jurisdiction issue was in question, then I mean,
Indeed, my lord, it could not have, my lord, but
yes,
my lord, thereafter, in my notes, my lord, the skeleton arguments, kindly take up page 7, the last paragraph. Your lordship's decision was followed very recently by Punjab and Haryana High Court. That's what we have, my lord, stated here. And, my lord, that decision starts from page 41 of the compilation. Page 41, the only relevant paragraph which I will, my lord, place reliance on is paragraph 157 of this decision, which is at page 100. My lord, yes. Before that, may I only refer to paragraphs 154 and 155. It's not 157, my lord. 154 and 155 at page 100. While countering the argument advanced by the counsel for the petitioner that the provisions of the Act of 2006 not being applicable on the works contract, reference was made to the judgment of Bombay High Court in the matter to contend that the question as to whether the contract would be said to be a works contract would depend on the facts and circumstances of each case, and that unless the issue is examined by the MSME Council, it cannot be ruled outrightly that a contract is a works contract. That's, my lord, the first part. Second paragraph, my lord, reference was also made to the judgment But may I also continue reading this part of the first
Yes,
paragraph?
yes, please.
They contend that even though the provisions of MSME Act have been held to be not applicable to a works contract, which is essentially an indivisible contract that may involve not just the supply of goods, but also the provision of labor and services. However, such a finding cannot be returned without allowing the parties to bring their evidence in support of the respective claim. Since the process of adjudication commences only after reference under Section 18(3) of the Act of 2006, hence, there is no scope for ruling on the same any time prior thereto. And the next paragraph, my lord, reference was also made to the judgment of Calcutta High Court in the case of Hindustan Petroleum Corporation Limited versus West Bengal State MSME to contend that such question can only be decided after parties enter appearance before the Facilitation Council and raise the objection and establish the nature of the contract as to whether the contract is for supply of goods and services or it is in the nature of a works contract or a composite contract. Now, this is decided in the next paragraph, paragraph 157, the first paragraph at page 101. The plea as to whether the contract is a works contract or a composite contract or a contract in relation to supply of goods or maybe back-to-back agreement are questions that require an adjudication. The process of MSME Act 2006 does not empower adjudication before reference under 18(3). Hence, an application for seeking rejection of claim on the ground that the contract is a works contract being a plea of defense and a question of law and fact cannot be rejected at the threshold.
So
that's the
this is a
finding
contention,
rendered.
yes.
That's the finding
Very
rendered.
good, yes. What about the other issue?
Now, this is the first point. My lord, the second issue, my lord, is from page 8 of the notes, skeleton notes. My lord, page 8, proposition, doctrine of election. My lord, here the submission is that we are barred from initiating an action under Section 18 of the MSME Act. My first contention is, my lord, Section 9 does not tantamount to commencement of an arbitration proceeding. It's a relief which we had claimed because there is no, my lord, provision under the 2006 Act, which is, my lord, apropos the Section 9 of the Arbitration and Conciliation Act. These are two very separate proceedings. Section 9 is for interim relief. The commencement is with Section 21. Admittedly, the commencement was never made by us. My lord, what is the stage of Section 9? We had filed an application for interim relief. It was considered. It was disposed of. We did not get an order there. Disposed of. There was a direction which my learned friend had placed, the last two lines, that you have to initiate the arbitration within the time frame, my lord. That if we would have done, we would have initiated through a section. So, my lord, that part is basically, my lord, Section 9, subsection 2 of the Arbitration and Conciliation Act, which mandates that an arbitration has to be started within 90 days from a date of the order. Now, that, my lord, would be the threshold of the arbitration proceeding. And that is to be done through a Section 21 notice, which if we would invoke, my lord, a Section 21 notice, 30 days would be the time limit. Then we approach the court in a Section 11 proceeding. We did not do that. My lord, instead of doing that, so that is where, my lord, my election would lie. If I would, my lord, then commence the arbitration proceeding by initiating a notice under Section 21, the doctrine of election would kick in. Because then I would be electing my remedy in law as to be under the Arbitration and Conciliation Act and not the 2006 MSME Act. We did not do that, my lord. In fact, my learned friend, his client gives a notice under Section 21. So doctrine of election does not apply at all. Because had I given a notice under Section 21, yes, I could not have made this submission. The notice was not given by us. What did we do, my lord? We immediately
Section 9,
invoked
Mr.
Section
Bhatt,
18.
Section 9 presupposes that there is an arbitration, there will be an arbitration. Before has to be read in context and before arbitration commences.
My lord.
So the moment you file a Section 9, you admit that yes, there is an arbitration
There is an
clause.
arbitration clause, my lord, but that does not mean
Yes.
that I am electing my remedy in law. My election of remedy in law would be through a Section 21 notice, which, my lord, I am placing reliance on because.
But if you if you choose to submit yourself to Section 9 jurisdiction, Mr. Bhatt, don't you implicitly say that yes, I am amenable to the arbitration jurisdiction?
In my very respectful submission, my lord, no.
Otherwise, people will be taking undue advantage of
No,
Section
my
9.
lord. The difficulty is, my lord, there
Everybody
is
will be
no
coming up getting a Section 9 order, or if it is refused, they don't go to arbitration. It is implicit that you have to go to arbitration.
Arbitration. But arbitration under which law? Because, my lord, today, Section 24 of the MSME Act 2006 has an overriding effect for the provisions from Section 15 of the Act to 24, my lord. 23. That's the overriding effect. The provision says it will have overriding effect over any other law. Starts with a non-obstant clause. Now, this is, my lord, the remedy in law would be under section 18, invoking a proceeding where we go
But
for a
under section
conciliation.
18, arbitration is remote. Arbitration is remote in the sense it's not proximate. There's something in between. Conciliation is in between.
That's,
Arbitration
my lord, a
does not
prerequisite.
start even.
But that's a prerequisite for the provision. If I
The
intend to, my lord,
prerequisite may be the only remedy. I mean, if the conciliation succeeds,
ends there, it ends then.
it ends there, it ends
But
there.
that is not,
It's
my
not
lord,
merely a prerequisite. It's an additional stage which you have to
an additional
overcome.
stage. Indeed, that is the difficulty, my lord. In fact, that is what, my lord, my
So
submission is.
section 9, could it be related to section 18 arbitration?
My lord,
Because conciliation comes in the way.
it can
That
be.
stage
The
comes
reason,
in it.
my lord, the reason in my respectful submission is section 9 is a remedy. Today, if I'm, my lord, I'm in urgent need of interim reliefs. I don't have a provision under the 2006 Act which would grant me that relief. And hence, my lord, I had a performance bank guarantee, which, my lord, I knew would be invoked. I needed a remedy. You know, that remedy is not provided through a conciliation proceeding. The moment my lord, a notice under conciliation is given for, my lord, invoking a proceeding under section 18, which is a mandatory provision, I do not have, my lord, a chance to go for an interim relief before the court. That is only provided
Probably
under
may
section
argue
9.
in certain cases, suppose there's an arbitration clause.
My lord.
In certain agreements, there may be arbitration clauses where also prior exercise of conciliation efforts are envisaged. There's an arbitration clause in a regular agreement. There's a prior, you have to undergo a process of conciliation, at least try
The
conciliation.
scale agreements, my lord, they are
Yes,
always there.
scale agreements and
My lord.
similar agreements.
Lordship.
So there also you can invoke section 9. You can invoke section 9, subject to an order being passed. You can then go back and try out the section, the
conciliation, and then it
section
fails.
11
Indeed.
and all this.
Indeed, my lord.
Very.
That's how I draw my analogy, because, my lord, section 9, there is no provision akin to section 9 under the 2006 Act. Also, my lord, the section 21 notice as in, my lord, issued by my learned friend's client was after the period of 90 days from the section 9 order. But that's neither here
That's
nor
neither
there.
here nor there, yes.
My lord, we have chosen our remedy because that is the doctrine of election. How do you choose your remedy? We have
So when
chosen
did
our
you-
remedy under section 18.
When did you move the council after that? And two of the dates are there.
But kindly give me a moment there.
Yes.
Check the first order.
November 2022 was the statement filed before the council.
21st November.
November.
The same date as you issued your section, your
Same date.
notice.
Same date.
You invoked the arbitration. Same date. You invoked arbitration on that.
No, I'll cite another fact. There is an admission on there.
Yes. Yes, sir.
My lord, I am not citing those judgments of, my lord, estoppel against the law would not lie, because, my lord, this is my remedy in law, which I've, my lord,
No,
tried
this
to
is not a
invoke.
question of estoppel against the law, Mr. Bag, because this is a remedy you can choose.
Yes, my lord.
If you
Doctrine
can
of
choose
election.
something, you can waive that.
Indeed, my lord. Whether my client's act of initiating, my lord, section 18 and not section 21 of the Arbitration Act would, my lord, bring me within the ambit of doctrine of election. Had I given, my lord, the section 21 notice and then approached section 18,
Yes, that is
there are
fine.
many judgments on that point. I'm not, my lord,
Yes.
because the judgments which I'm now relying on, my lord, is the next proposition at page 9, the overriding effect. Here, my lord, are three judgments which I've relied on. It's page 9, the last line, my lord, where we indicate the judgments. First is a very recent judgment of Gujarat State Civil Supply Corporation versus Mahakali Foods. This is, my lord, reported in 2023. And the judgment starts from page 110.
Other matters are released. 110, yes.
My lord, I apologize for, my lord, overshooting my 10 minutes, my lord.
No, no.
My lord, page 139. This decision, my lord, is relevant because this is, my lord, a decision which decides on the proposition that MSME Act has an overriding effect. But facts are interesting here, my lord. Section 21 was also issued
By the same person.
by the same person, my lord. But although the rendering, my lord, the judgment has been rendered on the point that MSME under 18.3 overrides the Arbitration and Conciliation Act. That's the finding. But the facts, my lord, here the Arbitration and Conciliation Act was, my lord, initiated. I am placing reliance on this judgment on the point that MSME Act, if I invoke, because of Section 24, may I place reliance on that provision once, my lord, of the MSME Act, Section 24. The provisions.
Yes.
The provisions of sections 15 to 23 shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. 15 to 23. Lord, we are concerned with 18, the reference.
Yes.
So this has an overriding effect that the law says, my lord, it has an overriding effect over any other provision. So today, my lord, the cases that we have not initiated are anything under section 21, no notice. So commencement of proceeding has not happened. There is no commencement of the arbitration proceeding. Section 9 disposed of. The direction being now you initiate the arbitration. How we initiate the arbitration? But we have chosen our remedy in law by initiating section 18. The day we file the statement is the day when the section 21 notice issued. Even if it was issued earlier, that would not change the.
You are not issuing it.
We are not issuing. That's why we don't fall under the doctrine of election as such. That's my submission. These are my respectful submissions, but only the paragraphs for the 3 judgments at page 10. These are all, one is Gujarat State, which I've just referred to, 2023 6 SSC. Paragraphs 33 to 42 and 52.1.
Yes.
The finding is rendered, at page 138. Paragraphs 42 and 42, which runs over to the next page. The court holds maintainability and counterclaim in arbitration proceeding initiated under 18.3 being a special legislation to protect MSMEs by setting out statutory mechanism for payment of interest. Said act would override the provisions of the Arbitration Act, which is a general legislation and refers to section 24. The next judgment, starts from page 150. This is Manibhai and Brothers, Principal Chief Engineer versus Manibhai and others. Gujarat, 2016 Gujarat. Paragraph 24, here we are in error at page 10. In the skeleton arguments, we have indicated paragraph 6.1 to 7. So that's not correct. It's page 24, paragraph 24. And paragraph 24 is at page 156,
Yes.
I'll not trouble your lordship by reading this. This is on the same proposition. And the last judgment, is Bata India versus AVS. That's a Delhi judgment. 2019 SEC Online Delhi 9801, paragraph 21 of the judgment, which is at page 175, rendering the same finding. Page 175, it's paragraph 21,
Overriding effect.
Overriding effect. These are my respectful submissions. Doctrine of election. That's neither here nor there. These are my very respectful submissions, And this is the reason, I'm not seeking to distinguish the judgment cited by my learned friend. My only distinction point is this, that doctrine of election does not apply in the present facts and circumstances. Very deeply applies.
Yes.
Your Lordships, may I just deal with the decisions that has been cited. The first one being that of the Supreme Court, 2023 6 SCC. Your Lordship kindly notes that in the judgment, the Supreme Court was not faced with a situation where the parties had made an election. All it decided was the effect of Section 18 on an arbitration clause simpliciter. There was no question of exercising any jurisdiction. Your Lordship, this will be evident from the facts. If your Lordships will have page 122 of the compilation. I do not wish to read the entirety of it, but on a simple glance, your Lordships will see that in all these proceedings, they had already reached 18.3. And the question was of the application of an arbitration clause to proceedings under 18.3. That when a reference to arbitration is made, is it statutory? Question is, would I need to look into the arbitration clause, or does a reference under 18.1 is not maintainable because of the presence of an arbitration agreement. None of these questions have decided that the party is precluded from, let's say, relying on the arbitration clause to seek its other remedies. The second point of distinction, Your Lordships, and this is crucial, is at para, Your Lordships,
You just complete this and this point of yours.
Yeah, Your Lordships, para 46, page 431. I'd mentioned this point before. I'm just mentioning the paragraph.
What is the running page of this compilation?
Page 140.
Yes.
The submission, therefore, that an independent arbitration agreement entered into between the parties under the Arbitration Act 1996 would prevail over the statutory provisions of the MSMED Act 2006 cannot be countenanced. As such, subsection 1 of section 18 of the MSMED Act 2006 is an enabling provision, which gives the party to a dispute covered under section 17 thereof a choice to approach the Facilitation Council despite an arbitration agreement existing between the parties. Your Lordship, this question doesn't address what happens when you accept that choice or when you do not accept that choice and go for something else. So, Your Lordship, in my respectful submission, this decision needs to be read in the context in which it was urged.
But some admission was being referred to by Mr. Mujumdar.
Your Lordships,
As we will continue that tomorrow.
Yes, Your Lordships, grateful.
Hard in part for further hearing tomorrow. Remember, we'll start from there and end it. Oh,